remedies have a strong deterrent effect on misconduct. Relatedly, the bill would add a provision that would establish the presumptive method for calculating reasonable attorney's fees. Particularly in this era of reduced federal oversight, increasing statutory damages to keep up with inflation and streamlining the process for consumer advocates to collect their fees is critical to ensuring robust private enforcement of the CPPA. I will conclude my testimony by thanking the Office of the Attorney General, DLCP, and the Council for facilitating a collaborative working group process with advocates on these amendments. We urge the Council to adopt these changes to make the CPPA an even more effective tool for protecting consumers in the district. Thank you.
Thank you very much, Ms. Millar.
Good morning, Chairman Nadeau and members and staff of the committee. My name is Melissa Millar, and I'm the Policy Director for Zedek DC. We're a small independent law center headquartered at the David A. Clark School of Law with offices in Ward 8. Our mission is to safeguard the legal rights and financial health of DC residents with low incomes dealing with the often devastating consequences of abusive debt collection practices and other consumer-related issues. And we're also submitting a more detailed testimony for the record. We support Bill 26-174, the Enhancing Consumer Protection Procedures Amendment Act of 2025. We have a keen interest in the Act's consumer protections for residents, as well as the CPPA's private right of action. This bill refines DC's consumer protection by clarifying what entities are merchants, confirming CPPA coverage for all unfair, deceptive, and unlawful trade practices while supporting redress for violations of law arising in consumer-merchant relationships, and amending complaint procedures to strengthen the district's ability to protect consumers from all unfair, deceptive, and unlawful trade practices. The bill expands the existing definition for merchant, asserting that a merchant or person need not have a contractual relationship with the consumer to qualify, may include someone providing a related or incidental good or service to or on behalf of another merchant to the consumer transaction at issue, includes the merchant's successors and assigns, and people involved in charitable solicitations. Additionally, the updated CPPA would not require a consumer bear any costs from the merchant and creates remedies for all improper trade practices before, during, and after the original transaction. These revisions ensure merchant is not rigidly limited and instead covers all relevant parties in the stream of the consumer transaction. The bill expands on interpretation of unfair or deceptive trade practices by referencing both Federal Trade Commission and Consumer Financial Protection Bureau interpretations, guidance, and court understanding. Given efforts to dismantle the CFPB, existing guidance could be revised to harm consumers. In fact, at least 67 CFPB guidance documents have been withdrawn covering fair credit and debt collection, truth in lending, and standards on unfair, deceptive, and abusive acts and practices. To address this concern, we recommend revising subsection D of section 4 to read, quote, "In construing the terms of this chapter, due consideration and weight shall be given to, and the court shall consider federal guidance that expands protections for District of Columbia consumers," unquote. In this way, the district's local and stronger consumer protections will be most favored if revocation of previously supported FTC or CFPB guidance documents occurs. Arguments about unfair or deceptive trade practices have been limited by what is delineated in statute, making it challenging for some consumers to see any effective relief for unfair or deceptive practices that harm them. So this bill would add abusive trade practices to existing unfair and deceptive, be explicit that a merchant may not commit acts delineated in DC Code 283904, and include without limitation language, such that unenumerated acts could also constitute unfair, deceptive, and abusive acts. The bill offers additional protections for retaliation against a consumer by a merchant and clarifies how one takes an unreasonable advantage of a consumer. It clarifies protections by including that it shall be a violation of this chapter for any merchant to engage in a trade practice in violation of any law in the District of Columbia. This more inclusive language should help resolve splits in case law regarding whether the violation of DC law, not specifically delineated in the code, is a CPPA violation. Finally, we support including language regarding how prices are advertised, displayed, or offered for a good or service. Drip pricing, where a consumer is drawn in by a low advertised price and increases significantly at the checkout, can be curbed by ensuring that all costs and fees are clearly and initially explained. The first advertised price should be as close to an item's true cost as possible, and what consumers and regulators should expect from businesses covered by the CPPA. We also support the bill's proposed increases to the statutory damages recoverable per CPP violation from $1,500 to $3,000 and adjusting it for inflation. However, we recommend the reinsertion of language currently in the code, which notes that whichever is greater between the set penalty amount and the treble damages should be provided. We also recommend eliminating one of two instances of awarding attorney's fees just for clarity. Finally, we recommend the committee include language that establishes discrimination based on actual or perceived characteristics outlined in the DC Human Rights Act as an unfair, deceptive, or abusive act or practice. This anti-discrimination provision would necessarily include reasonable accommodation and effective communication requirements for persons with disabilities. Ensuring that all residents receive necessary accommodation reduces barriers for consumers. This bill will strengthen the OAG's ability to protect consumers. We thank you for championing this reform and the opportunity to testify, and happy to answer questions. Thank you.
Thank you very much. Donald Maurice.
Good morning, Chair Nadeau. My name is Donald Maurice. I'm outside counsel to the Receivables Management Association International. It's a trade association of 600 banks, non-bank lenders, credit unions, debt purchasers, and the companies that serve them. So we commend Chair on the bill. We believe that it does enhance consumer protections. We have one concern, though, and it is with the expanded definition of merchant. As you know, that expanded definition would cover entities that provide goods or services to or on behalf of a merchant. A few years ago, we worked with Councilperson Mendelson on the debt collection law. Debt collectors covered by that debt collection law would very well be persons providing goods or services to or on behalf of a merchant. Essentially, the problem becomes that the Consumer Protection Act now is expanded to cover entities that have been covered for decades with their own regulatory framework under DC law. And this, of course, creates inconsistencies and conflicts in what those regulations are that are imposed on persons covered by debt collection. In fact, it creates a differing penalty structure. The Consumer Protection Act also provides defenses to debt collectors, covered debt collectors on the under the debt collection law, which are otherwise not available to them because these would be imported in under the amendment to the Consumer Protection Law. So we suggest simply a red line amendment to the definition, that expanded, broadened definition of merchant. It would preserve what we know the bill intends to do, to cover other merchant-related entities while excluding those debt collection entities already covered under DC law. I provided a detailed memorandum concerning this and a red line as well. It's an honor to, again, speak here before the council. I appreciate your time. I'm available for any questions.
Thank you for your testimony. Deborah Cuevas Hill.
Good morning. My name is Deborah Cuevas Hill, and I'm the manager of the Consumer Advocacy and Homeownership Preservation Practice at Legal Counsel for the Elderly, also known as LCE. Thank you for the opportunity to be here today. LCE's consumer practice focuses on homeownership preservation primarily through foreclosure defense. We raise CPPA defenses in these cases when our clients face unfair, deceptive, abusive, and unlawful trade practices, typically by lenders or loan servicers. The Consumer Protectors and Procedures Act, the CPPA, is a critical tool in helping our clients assert their rights. I'm here to speak in strong support of the Enhancing Consumer Protection Procedures Amendment Act. LCE works closely with Legal Aid DC, helping homeowners who face foreclosure. I want to voice my support and echo my colleague Jenny Joseph's testimony today. LCE supports the CPPA amendment in its entirety, but in particular, I want to highlight 5 points. Strengthening the Office of the Attorney General's power to investigate improper trade practices and enforcing the CPPA, clarifying and expanding the authority of DLCP to investigate and enforce the CPPA at the administrative level, increasing statutory damages for violations under the law, clarifying the definition of merchant, and enhancing what is already considered an improper trade practice under the law. My testimony today will focus on these last 2 points, the definition of merchant and also what constitutes an improper trade practice. First, I'll focus on the definition of merchant. As you've already heard today, the CPPA contains a private right of action under which consumers can go to court to seek damages against a business that has violated the act. Consumers can also assert violations of the CPPA in defense of claims filed against them by merchants. The CPPA defines relationships between merchants and consumers. Although the Court of Appeals has held that the CPPA's definition of merchant reaches any person connected with the supply side, that's already law, and is not limited to the actual seller of the goods or services, businesses defending CPPA claims still argue routinely that they are not a merchant because they were not the seller of the goods or services at issue, that they didn't have a direct contractual relationship, as my colleague Jenny Joseph mentioned, or they were just supplying the goods or services on behalf of some other seller or assignee of the original seller. We see this play out in our foreclosure defense cases where the mortgage servicers often claims that they're not merchants under the CPPA to avoid any liability. Mortgage lenders routinely hire mortgage servicers to manage their loans in these situations where the servicers make a misrepresentation or another unfair or deceptive practice. Servicers will claim that the CPPA doesn't apply to them because they were hired by the lender, not the consumer. And assignees of lenders often claim they're not liable for the improper trade practice either of their predecessor. All of this to avoid liability. The bill would end this and clarify that the definition of merchant has broad scope. Second, the bill enhances what falls under the definition of an improper trade practice. To have a claim under the CPA, you have to have a merchant, a consumer, and an improper trade practice. The CPPA currently enumerates a very long list of improper trade practices. Merchants will often argue that their business does not engage in improper trade practice because their line of work is not included in that long list. The bill addresses this problem by clarifying that this long list of improper trade practices is not at all an exhaustive list. By reorganizing existing improper trade practices and by making aiding and abetting another person's improper trade or entity's trade practice a violation of the CPPA. The Council should adopt the Enhancing Consumer Protection Procedures Amendment Act of 2025 to strengthen the tools DC consumers have to combat unfair and deceptive practices. I'm happy to reserve my time for any questions. Thank you.
Thank you all very much for your testimony. Ms. Joseph and Ms. Cuevas-Hill, you mentioned cases where businesses use the vague definition of merchant to avoid being held accountable, including mortgage lenders and servicers. What type of violations are these companies committing?
I can share a few. I mean, all types of violations. I would say particularly in our work with homeowners, we often see servicers making misrepresentations about related to the loss mitigation process, which is the way that homeowners try to avoid foreclosure. We see servicers mishandling applications, making misstatements about what a homeowner's rights are, telling people they're in foreclosure when they're not, protected by the moratorium that this council enacted. And, you know, I'll let my colleagues speak to some of the other ones that she sees as with her work with seniors, but many different types.
We see all of those. And like my colleague said, it's in the trying to save your home context when seniors and any homeowner for that matter are the most vulnerable. They might have fallen behind on their loan because of a servicing error. Perhaps they had an interest-only loan and suddenly they were being charged principal and interest, which is going to, of course, make them fall behind. And so that would be another sort of misrepresentation of what's actually owed, and then telling them, if you don't catch up, you're going to face foreclosure. All of this in the context of someone already being vulnerable.
Thank you. Ms. Millar, thank you for your suggestion to include language to restrict drip pricing or prices that are advertised as low but then are much higher at checkout. And we'll be having a lot of discussion about this issue later today as it relates to concert tickets. But I am interested in ensuring consumers have this protection in all industries. Is there currently no protection against this or other deceptive pricing in DC?
So as I understand it, there really isn't, that the initial price to lure people in, while it may generally not include taxes or potential fees, that there could be other aspects of the cost that are not explained to the consumer until they're basically at the point of sale. So the language that was recommended was to address not only that when you're ready to hit the button to buy, you should be clear about what your costs are, but when you're having an initial, when you're first seeing the product, you should understand what all of the potential fees that could be involved should be, with the exception potentially of just government taxes and maybe just a few other fees. So DC is not appropriately addressing that currently.
Thank you. And Mr. Maurice, can you say more about the regulations that currently exist for debt collectors?
Yes, the district, as you know, has probably one of the most extensive laws regulating third-party debt collectors, and it also regulates debt purchasers. And unlike everywhere else other than, I think, New York City and possibly California, it also regulates creditors in their conduct of collecting consumer debt. That is a debt that is owed by a consumer for money, property, services, or insurance for personal, family, or household use. The law sets up a scheme as to how consumers must be contacted, when they can be contacted, how often they can be contacted, what information has to be provided to them during certain of these contacts. It provides for the recovery of statutory damages, in my experience, the highest in the nation. It also allows for the recovery of actual damages, and it allows consumers to recover their attorney's fees and costs to prosecute those claims, and also provides a scheme for class actions and how those can be recovered should the type of conduct that is prohibited by the Act be of a class basis. It also provides for provisions during times of emergency. So it is extraordinarily detailed in its regulation of that class of entities. The concern, as I said before, is the Consumer Protection Act really doesn't have that granularity at all. It imposes different statutory damages. It doesn't address, to the extent that we have in the debt collection law, what happens during class action. And also, it provides for a defense that can be asserted by the merchant, something that isn't in the debt collection law. So I think it's clear that there wasn't consideration made of the debt collection law and that it's covering entities already, that this broader definition would. To be clear, under existing law, if a merchant hired a debt collector who engaged in a wrongful act, I believe that there is a possibility that the merchant could also be subject to penalties under the Consumer Protection Act if that was a failure of oversight that I think could be argued to be unfair, deceptive practices. So we're not asking to be relieved of regulation. We're asking that regulation be clear in DC. And since it is already the most extensive that we know of in the country, we believe that consumers will benefit from this clarity as well as businesses.
Thank you very much.
You're welcome.
Thank you all very much for your testimony. Okay, our second panel is also the last panel we will have in person for this bill, the Enhancing Consumer Protection Procedures Act. It includes Aaron Witt, Director of Consumer Protection, Consumer Federation of America, and Samuel Levine, Senior Fellow, Berkeley Center for Consumer Law and Economic Justice. However, if there is anyone else who is here to testify on this bill in person and would like to join the panel, now is the only opportunity to do so, so I ask that you come forward. After this, we will turn to the online witnesses. Very good. Okay.
Good morning. Thank you for holding this hearing, Chair Nadeau, members of the council. We really appreciate the ability to be here. My name's Erin Whitty. I'm the Director of Consumer Protection at Consumer Federation of America. I'm a policy advocate where I advocate for consumer protections both at the federal and state levels. But before I was at CFA, oh, I'm sorry, I see that my timer hasn't started. I don't want to get an unfair advantage here. So before I was at CFA, I was actually an assistant attorney general at the Virginia AG's office, where I enforced Virginia's consumer protection statute. And I was also in private practice, where I represented individual consumers who had been harmed. So I certainly have an interest in this legislation and have been following it closely. We strongly support these proposed changes to DC's Consumer Protection Procedures Act. I have written testimony that goes into some detail about the gaps that this bill would fill, as well as some of the clarifications that it provides. But today I want to focus on 3 key perspectives about this bill and really what it would do for DC residents, for business owners, and also, frankly, for the rest of the country during this tumultuous time. First, I want to provide perspective on what this really does for DC residents. Sometimes we think about consumer protection as a niche area of law or a cordoned off section of a government agency. But the fact is that these consumer protection issues affect the everyday lives of every DC resident. It affects their ability to afford their groceries, to send their kids to school without having their data hacked and monetized, and to pay their rent without getting scammed. The reality is that these big tech firms and social media giants are creeping into almost every aspect of our daily lives. And everyone is a consumer, whether they want to be or whether they think they are or not. So these laws and these amendments would expand the ability of the AG and private practitioners to protect every DC resident in their everyday lives. The tool to stop this creep and to take on these giant firms is the Consumer Protection Procedures Act. This is the way to fight back, but it does have significant gaps that we're concerned about and that could be filled by this bill. The second perspective I want to offer is about what exactly this bill and these amendments do for the marketplace and for business owners in DC. Many of the amendments that my colleagues have testified about and that we've written about in our testimony bring clarity and transparency to exactly what the Consumer Protection Procedures Act does. That helps businesses who are doing business here, companies who are engaging with consumers. It sets clear rules for them and allows them to see ahead of time exactly what the rules are. Adopting this bill would also level the playing field for honest businesses. They would be able to compete on honest terms and not have to compete with businesses that feel that they can profit despite violating the law or cheating consumers. It puts the right incentives in place. The last perspective is about what this bill can do for the rest of the country. DC has one of the most effective attorneys general offices in the country and an extraordinary plaintiffs bar that enforces these protections. The CPPA is the most impactful tool that they have to do this work. And candidly, I'd be remiss if I didn't mention what's happening at the federal level to invoke a sense of urgency about these amendments. The Consumer Financial Protection Bureau is being gutted. It has dismissed over 40 cases against lawbreakers. Some of those were consent orders that the companies had agreed to and have been rolled back. The Federal Trade Commission is abandoning common sense rules. They've dropped enforcement cases, and they are giving sweetheart deals to major corporations. Now is the time to ensure that DC can take on some of these practices and that DC has the tools it needs to continue to be a bold leader. A lot of these changes are updates and clarifications, but candidly, many of these updates are things that will empower DC to be a leader in consumer protection. We urge the council to pass this bill to facilitate exactly that. Thank you.
Thank you very much.
Good morning, and thank you for the opportunity to testify. My name is Sam Levine, and I'm a senior fellow at UC Berkeley Center for Consumer Law and Economic Justice. Until January, I served as director of the FTC's Bureau of Consumer Protection under Chair Alina Khan, where I led enforcement of the federal prohibition on unfair or deceptive practices. I strongly support the council's proposal to strengthen the Consumer Protection Procedures Act. Today, I want to focus on 3 key ways these reforms would improve lives for DC residents. Clarifying that merchants include providers of so-called free services, setting mandatory minimum penalties to raise the cost of cheating consumers, and leveling the playing field for honest businesses here in DC. First, it is essential to make clear that companies offering free services are still subject to the CPPA. Platforms like Facebook have argued unsuccessfully and implausibly that because they do not charge users money, they fall outside the law's scope. Clarifying this point will align DC law with the vast majority of states and will help ensure that there is no ambiguity that these companies are not above the law. During my time at the FTC, some of the worst abuses we saw came from providers of so-called free services, whether it was Facebook repeatedly violating federal privacy orders, TikTok illegally tracking children, or credit reporting agencies like Equifax recklessly exposing consumers' most sensitive information. The reality is that these services are anything but free. Although consumers don't pay them money, they pay with their personal data, fueling billions in advertising profits while unwittingly exposing consumers to serious privacy and safety risks. It would be perverse if a law meant to protect DC residents exempted these various companies, some of the largest and most powerful companies in the world with the longest records of breaking the law. For the sake of DC's residents and especially DC's kids, it is critical that free services are held accountable, especially when leading federal enforcers like the CFPB are being gutted. Second, I strongly support establishing mandatory minimum penalties for violations. One of the lessons I learned at the FTC across many years is that enforcement is effective only when breaking the law is more expensive than following it. Too often, companies, especially the largest companies, calculate that breaking the law is a profitable risk. Most aren't caught, and those that are caught often pay no more than what they stole from consumers. That isn't deterrence, it's a business model. Setting minimum penalties will help ensure that companies face more than a slap on the wrist for ripping off the people of DC. Finally, it's important to stress that the CPPA is not just about protecting consumers. It's about protecting DC businesses, especially small businesses that play by the rules. When companies can mislead consumers, bury fees, or exploit data while their law-abiding competitors play by the rules, the result is a race to the bottom. Deceptive businesses gain an unfair advantage and honest ones lose out. I've seen this dynamic play out across many industries. Companies that bury fees can appear cheaper than those that advertise prices honestly. Firms that harvest consumer data can fund rapid expansion while their privacy-respecting competitors lose ground. Businesses that skimp on data security can save costs up front and spend more on marketing instead. These are perverse incentives that reward reckless conduct and punish responsible businesses. Strengthening the CPPA will help reverse that dynamic. It will ensure that businesses competing fairly by treating consumers honestly are not at a disadvantage. A strong CPPA is good not just for consumers, but for every DC business that wants to compete on a level playing field. In closing, these reforms to strengthen the CPPA are a win-win for DC. They will stop big tech data harvesters from trying to escape accountability, step up deterrence against firms that cheat DC residents, and give honest businesses a fair chance to compete. Thank you for the opportunity to testify today and for your leadership in protecting DC consumers. I'm happy to take your questions.
Thank you both very much for your testimony. I'm very interested in what you both said about how this bill will expand DC's ability to go after sites selling our data without proper disclosure or a way to opt out. Do you think these updates to the CPPA fully address this issue, or do we also need explicit data privacy regulations like what's been done in California?
I think data privacy regulations are urgent. I was at the FTC for almost a decade. We waited for a very long time for Congress to pass privacy legislation. They failed to do so. I think it's critical that DC advance common sense protections like California has, protecting people's sensitive data, making sure they can delete data from data brokers, making sure they can't have their locations tracked. When I was at the FTC, we brought cases against a number of data brokers who were selling information on people's visits to abortion clinics, people's visits to political protests, people's visits to churches. All of these practices were seen as legal because of the absence of a federal privacy framework. So I certainly think the DC reforms to the CPPA would go a long way to giving the DC Attorney General and private plaintiffs tools to challenge individual privacy abuses. But when it comes to having a comprehensive framework to protect us from constant surveillance and civil rights abuses, I do think it's important that DC follow California and more than a dozen other states, including Maryland and Virginia, in passing privacy laws.
Thank you. Ms. Witt, you said that you believe there are gaps in the bill. Can you say more about what you think they are?
Sure. So some of the gaps have already been addressed, but some of these gaps would address the DC AG's ability to go after services for which some of these gaps that can be filled would address the AG and private enforcers' ability to go after services for which there's no exchange of monetary payment. I think that's a really big gap that could be filled. As I've noted in my testimony, there are multiple examples. Some of them have to do with social media and data brokers or credit reporting agencies, which you don't pay for, but they certainly have access to your information and lots of other ways that they can harm you. I think another example is the ability to go after charitable solicitation conduct. I think the language in the proposal would cover consumers who donate or would donate to a charitable cause, but as it turns out, that charitable cause may not be where their money actually goes. There's a recent example of the Federal Trade Commission in 19 states against Cars for Us, which said, your charitable solicitations will go to pay for breast cancer screenings, when in reality, the company and its executives who took that money only gave 0.2% of the money they took to actually pay for breast cancer screenings. So this is a really grotesquely exploitative practice that the CPPA should cover.
Thank you.
Sure.
Thank you both for your testimony.
Thank you.
We'll now turn to our third and final panel, which is taking place virtually. Please be sure to accept the invitation to join the panel in Zoom. Commissioner Tripti Patel, Chair of ANC 2A, Lauren Wolf, David Namias, Director of the Consumer Law Advocates, Scholars, and Students Network, Raynell Hall, and Courtney Weiner, Law Office of Courtney Weiner, PLLC. Okay. All right, of those I called, we will start with those present now and begin with Lauren Wolf. Lauren Wolf, if you could turn on your camera and unmute yourself, you may begin. Okay, we'll come back to you unless we can unmute her ourselves. Ah, there she is. Go ahead.
All right, great. Thank you so much. Thank you so much, Councilmember, for having me here today. I'm here to talk to you about this, incredibly important amendments to the Consumer Protection Procedures Act. So thank you for having the time to listen to all of us and many of the great friends who you already heard from earlier today. So I'm here as both a DC resident and as counsel for a nonprofit based in Washington, DC, that has used the Consumer Protection Procedures Act on behalf of consumers to protect consumers in Washington, DC. The Consumer Protection Procedures Act allows nonprofits such as Travelers United, where I am, to bring important consumer protection cases in the district. We've brought many of these cases about restaurant fees, about social media companies and influencers, and about hidden hotel resort fees in the district. We believe that consumers should know the true price of an item when that item is first advertised to them. Consumers should know when they're being fed advertisements on social media that are disguised as genuine posts from people that many view as friends of theirs on the internet, even if they don't know these people in real life. Consumers should have recourse when people who are selling a product are lying to them, whether it's in the Washington Post, on TV, or on an Instagram ad. So one issue that we've seen, to go a little bit further about this, is in our litigation, is that case law is about 30 years behind the actual law. And so what we're seeing in the court is that Some of the courts obviously are relying heavily on case law, which is saying, oh, we're looking at advertisements that were placed in the printed edition of the Washington Post, because that is something that is targeting DC consumers. The Washington Post print circulation is now down to under 100,000 people. That is simply not the way most people in the district are getting their news and seeing advertisements today. They're seeing them because they're being targeted on Instagram, they're being targeted on Snapchat, they're being targeted on TikTok. And that's what we need this law to address. And we need it to be explicit that obviously the SIPA covers the ads that are being shown to people in the district on TikTok, on Instagram, on Facebook, on Snapchat. And we need to make it clear that, that's where consumers need protection today. We're less concerned now about obsolete coverage, frankly, in a printed edition of the Washington Post, which may have been very relevant 30 years ago, but frankly is not today. We agree that the amendments before council have been discussed with a broad coalition, many of which have been before you already. These are wonderful people and excellent legal advocates and experts who will strengthen this. I also want to further emphasize that drip pricing is already illegal under SIPA, but it could be clarified with more explicit language, which we hope to have. And we need to widen the definition of merchant. We believe that more people could be subject to this and should be. And like previous people have said already, they refer to the fact that they're not explicitly mentioned on the merchant list to try to get out of being subject and liable to deceptive practices in the district. People like a social media influencer who are essentially advertising products on behalf of a company have argued that they are not a merchant under the law. But they are explicitly advertising and are kind of this interesting middle person that is essentially functioning as an advertising platform for the way that most people are getting advertisements on social media platforms. And we believe that they should be explicitly listed as a merchant and subject to the SIPA, which has already been interpreted that way, but more explicit language could be beneficial. We don't believe that people should get out of liability just because they're not explicitly mentioned as a merchant. And so we agree with pretty much everyone before that the merchant line should have as broad of a scope as possible. And I'll give my time up, but I'm happy to answer more questions. My particular interest is in drip pricing to make the language more explicit, even though I think it's already pretty good. And also to just modernize the law and make sure that SIPA is explicitly clear that we are protecting consumers who are seeing ads in Washington, D.C. on social media platforms.
Thank you very much. Mr. Namias.
Hi, good morning. You had it right the first time. Thank you so much. Good morning, Councilmember Nadeau and members of the council. My name is David Namias. I direct the Consumer Law Advocates, Scholars, and Students Network, or CLASS Network. The CLASS Network is a nationwide network of law school organizations and legal clinics that is fostering the next generation of consumer advocates through education and experiential opportunities. We have chapters all over the country, including several right here in the DC metro area. I offer my comments today on behalf of our national network, as well as our CLASS chapter right here at GW Law School. The CLASS Network and our affiliated schools strongly support the proposed amendments to the Consumer Protection and Procedures Act. The affordability crisis that is gripping our nation hits young people particularly hard, including law students right here in the district. Young people are more likely to be renters and carry student debt. They're thus particularly susceptible to fraud by collusive landlords who artificially inflate rents, or by student loan servicers that prioritize their own profits over helping students pay down their debt. The DCAG has taken on fraudsters like these using the powerful tools of the DCCPA. Now, the council has the opportunity to strengthen what is already a robust law protecting DC residents and help bring the district in line with the other leading jurisdictions in this country. One crucial way that these amendments will enhance protections for DC residents is how they will add charitable solicitations within the PPA's coverage. We all have had the experience of someone stopping us near DuPont Circle and asking us for money for a particular cause. I know I have. Yet, how do we know those funds are going to be used the way that solicitors say they are? In fact, current DC law does not expressly forbid anyone seeking charitable donations from lying about how the funds will be spent. In the past year alone, several nonprofit organizations in DC have been in the news for mishandling charitable contributions, or worse, for having their names used by scammers trying to solicit donations on their behalf and absconding with the money. These amendments to the CPPA take bold yet well-accepted action by expanding the law to cover individuals who give money or goods to charity. It subjects solicitors of charitable contributions to the same prohibitions against fraud and deception as ordinary merchants are. Over 25 states offer similar protections as those that are proposed here. So this is just common sense. I invite you to read our written comments drafted by GW Law students Nam Lan, Maya Clark, Ben Meyer, and Carly Chopin, and which thoroughly address charitable solicitation fraud. Finally, we want to underscore the critical role that states and municipalities like DC must play today in response to the decimation of the many federal enforcement agencies like the FTC and the CFPB that are responsible for protecting consumers, that is, all of us. By strengthening today the district's preeminent consumer protection law, the council shows that it understands the seriousness of the moment that we are in and the harms that the retreat on the federal level is unleashing on Americans across our country. We encourage other states and municipalities to follow DC's example and adopt similar laws that are intended to deter, prevent, and punish entities who try to hoodwink consumers, and to give enforcers even more tools to root out unfair and, especially relevant here today, abusive behavior. And we really want to emphasize the CPPA's work expansion on to include abusive behavior, just as at the federal level under the Consumer Financial Protection Act. I thank you all for your consideration of these amendments, and I invite you to read our comments on the record detailing our support. The Class Network recommends an aye vote.
Thank you very much. And Ms. Weiner.
Good morning, Chairman Nadeau. Thank you for the opportunity to testify. My name is Courtney Weiner. I am an attorney at the Law Office of Courtney Weiner, PLLC. My practice focuses exclusively on representing consumers, specifically those victimized by financial institutions. Many of my clients face issues with their mortgage servicers, their banks, their credit card companies, debt collectors, and a range of other companies that often double down on their mistakes again and again. I'd like to tell you about a couple of them, the importance of the CPPA, and the gaps and misunderstandings in its coverage that the Enhancing Consumer Protection Procedures Amendment Act of 2025 addresses. One client faced a mix-up with his property taxes. The mortgage company paid way too much, then it got refunded. The problem was that the mortgage company told my client that he had to pay the overpayment amount anyway, even though he didn't owe it. That was $45,000. The mortgage company told him on the one hand that they were fixing it, and on the other started rejecting his payments because they said he was $45,000 behind. The mortgage company took this all the way to a foreclosure case, even though my client was current on his mortgage, except for the $45,000 that he didn't owe and had never owed. The DC debt collection law does not cover this kind of situation, but the CPPA does. Unfortunately, some judges have misinterpreted the law as it currently stands to exempt mortgage servicers from its scope, on the theory that they don't have a contractual relationship with the borrowers and are just operating as an agent of the owner of the mortgage. Most people don't know who the owner of their mortgage is, and it's likely to change hands many times without the borrower ever knowing. Borrowers do know who their mortgage servicer is. It's the company they pay every month, that they call when there's an issue, and that sometimes messes things up. Without the clarifications in the definition of merchant in this bill, borrowers may have no recourse under DC law against mortgage servicers. I urge the committee to move forward with this fix and to make clear that the updated definition clarifies the coverage that has always been within the scope of the law as to mortgage servicers. Another client of mine had someone knock on his door and convince him to replace part of his HVAC system. The salesman told him all sorts of things that weren't accurate, to the point that he believed he was qualifying for a free upgrade to his system. So they installed the system the same day. He signed something electronically that they told him was to verify the completion of the work, but they applied it to a financing contract without his knowledge. Then the bills started coming, and the calls, and the supposed debt for almost $16,000 showed up on his credit. My client was understandably extremely distressed. His blood pressure went up and he got headaches from the stress of it. The current language of Section 3905 K2A makes clear that dignitary damages are available under the CPPA to compensate consumers, except for data breach cases. But again, some judges have misinterpreted the statute to conclude that the CPA does not cover dignitary damages. I encourage the committee to adopt the proposed clarifying language and to also make clear, whether through legislative history or through modified language, that the statute has always covered this type of damage. Thank you to the committee for your work on this important bill. I'm happy to answer any questions.
Thank you, all three of you, for your testimony. Anything else you want to? Okay, I think we are all set. Appreciate it very much. Thank you. Okay, with that, we will now move to the testimony for the Housing with Integrity Act. Please join the witness table when I call your name. Our first panel includes Salim Adofo, Patrick Cawthorn, Policy Attorney from Children's Law Center, Farah Fasseh, Community Development Director at Empower DC, and Caitlin Peter, VP of Government Affairs, DC Residential, AOVA. Go ahead. Get your button though. There you go.
All right. Good morning, everybody. Thank you so much, Councilmember Nadeau, for holding this hearing. And I want to start off by saying I think many of us are aware of the conditions that Ward 8 residents face, but for those who don't, we have apartment complexes such as Marbury Plaza. Recently, we just had a fire that took place in the Garden Apartments at Wingate. We have the Geraldine Apartments, Congress Park Plaza, and we have numerous apartment complexes where residents continue to face slumlord conditions that are just unfit for human beings to live. And we have to find ways to hold these property owners accountable. Just recently at the Garden Apartments, there was a fire and there was over 101 violations, notice of infractions that were found. And now we have 85 residents that have been displaced. And I think that we have to, like I said, find ways to hold these property owners accountable. And having this legislation is one way to do that. I think this legislation is a start to that process, but I think there needs to be some more substance added to that. And so some of the things that I want to offer to this legislation is to make clear the bill applies to the new basic business license and renewals, add explicit verification authority when thresholds are met. Otherwise, existing unsafe building, unsafe building stakes by until the next 2 to 4 years renewal cycle just won't work, because if we have an exorbitant amount of violations, if licenses are renewed every 2 to 4 years, that's a long time period before these licenses will be revoked and they can continue to operate in a fashion that does not work well for the residents. Something else that I think that is very important is that some of these property owners, they just start new businesses. And so then they just create a new business and then they're still able to function. And I've seen that happen all along the MLK corridor. We have property that was at 3639 MLK Avenue Southeast. And the people that live in that building tell me that they get sick and it's hard for them to even live in the building that they have a lease to because of the amounts of mold, the trash, a lot of the fire extinguishers, smoke alarms, none of that stuff seems to work. And so when we have property owners that can just start a new business under a new DBA, we're not really solving the problem. So we have to do better research at making sure that those things don't happen. And something else that I definitely want to make sure that we consider in doing this is that we make there be a 30% trigger, and that's workable and that the public can actually look at and see, and clarify this trigger to total active class 1 and 2 violations that are equal to at least 30% of the unit count. And so that we can ultimately put these folks in a position to where that we're not going to see, because I think that in the building on 3639, all 4 of the units that were there, they all had violations. In the garden apartments, the overwhelming majority of them have violations. So then at one point, does this actually trigger DOB or some other agencies to step in? And we just can't just keep putting people through some of these issues that we have. So I think I'll submit my testimony to you, and I'm here to answer any questions.
Thank you very much. Mr. Cawthorn.
Good morning, Chairperson Nadeau. Thank you very much for the opportunity to testify this morning. My name is Patrick Cawthorn. I'm a policy attorney at Children's Law Center, for whom I am testifying today. Children's Law Center believes every child should grow up with a strong foundation of family, health, and education, and live in a world free from poverty, trauma, racism, and other forms of oppression. To that end, we strongly support this act, but we urge this committee to strengthen this act with several amendments, particularly to the licensure component of this act. Existing housing code enforcement efforts are insufficient. As Councilmember Lewis George correctly wrote in this act's statement of introduction, too many district residents are forced to live in housing with serious health and safety violations, while landlords face minimal consequences for failing to maintain their properties. This quote effectively summarizes CLC's experience representing district residents. We work with hundreds of families living in rental housing with conditions like pest infestations, water intrusion, lack of heat that cause and worsen children's health conditions. The district's housing code is meant to protect against these conditions by setting minimum standards that landlords must comply with to maintain safe and sanitary housing for their tenants. The housing code, however, is only as strong as its implementation and its enforcement. This act would improve enforcement efforts by prompting district agencies to better utilize existing resources and information. While we support this concept, we have several recommendations. My written testimony that I've submitted provides our full list of recommendations and supporting explanations, but this morning I'd like to focus on 3 of those, which 2 of them you've already heard from my colleague. But first, we recommend that this act require DLCP to deny licensure at both the time of license issuance and the time of license renewal. As I read this draft, it applies only to license issuance, but as licenses may be either issued or renewed, this act could be strengthened by expanding its scope to include license renewal. Maintaining the omission of license renewal would allow non-compliant landlords the opportunity to exploit this act. Such an exploitive provider would need only to obtain their initial license and then would suffer no repercussions under this act for allowing their housing to fall into slum conditions. This cannot be the case. Second, we recommend amending the district's business registration requirements to prevent landlords from hiding behind shell companies by mandating disclosure of human owners. Enforcement efforts under this act can bring accountability to otherwise beneficial owners if this is done. There are several potential approaches to implement this, and we have provided some of those within my written testimony. We would welcome the opportunity to discuss this further. The final recommendation I will highlight this morning is a recommendation to better identify life safety violations. The current draft is both over and under inclusive. It includes items that are not directly related to life safety by mentioning classes 1 and 2, and it also omits other emergency conditions. As one example, a missing lock on an exterior door is not within class 1 or 2, but is a clear and immediate safety concern. Similarly, many violations going to mold would not necessarily be captured by classes 1 and 2. Lead paint is not included within those classes either. We recommend that this act specifically list additional violations or each violation to ensure that all life safety code violations are included. I have provided a rather lengthy list of specific violations to include, and I would welcome the opportunity to discuss that further with this committee too. In conclusion, the Housing with Integrity Act is a promising approach to an urgent issue, and we believe that with the recommendations highlighted here from my colleagues and in our written testimony, this council can continue to effectively protect district residents. Thank you for this opportunity to testify.
All right, thank you.
Good morning, Chairperson Nadeau. My name is Farah Fossey. I'm the Community Development Director at Empower DC, which builds tenant power through community organizing to advance racial, economic, and environmental justice, including housing justice. Members of our tenant power campaign have identified unsafe and unhealthy housing conditions as a major cause of displacement and affordable housing loss. Renters across DC know that DC can do a better job of enforcing the housing code and ensuring residents live in safe and healthy housing. I'm here today to support the Housing with Integrity Amendment Act and to encourage you to strengthen the act to better ensure that landlords comply with DC's housing code and related laws. When we talk about housing code violations, we're talking about health, life safety, affordable housing, and displacement. Landlords regularly neglect or refuse to repair older, affordable housing, pushing tenants to move out. In other cases, housing is in such disrepair the building is closed, leading to displacement and more affordable housing loss. Only a couple weeks ago, a DC resident lost her arm in an elevator that had been consistently cited for housing code violations. The district's housing code inspection and enforcement processes work for landlords who willingly comply with the law, but the city lacks the processes and laws to compel bad actors to follow the housing code. The Housing with Integrity Amendment Act is a start at sending a message to landlords that they need to comply or risk their ability to do business in DC. The legislation mandates that when a threshold of violations is found, DOB will add the property to a new Tier 1 proactive inspection group so that the property is inspected twice a year. This is a critically important piece of the legislation. DOB currently lacks a process for deciding when to conduct a building-wide inspection. This change will ensure that buildings with serious violations receive property-wide inspections, even if they're not on the proactive list. But the threshold may be too high of a bar, and it still relies on tenant reports. DOB should be encouraged to create additional simple metrics to decide when to carry out a property-wide inspection, such as stakeholder identification or just finding 2 life safety violations in the same property. I was just on the phone in the hallway with a resident telling me they have broken water heaters, and she was told by the code inspector that every resident needs to call for an inspection. It's the water heater. Every single unit does not have hot water. So there needs to be just simpler processes. The legislation further mandates that when this level of serious housing violations are found, the owner can't get a new basic business license. I'm concerned, as are my colleagues, that this will have very minimal real-world impact. When an owner would only be impacted when they try to get a new BBL under the same name. Most bad actors would just start a shell company and they would get a new business license. The legislation will be significantly stronger if DC can ensure that bad actors can't hide behind shell companies. There's many reasons that DC needs to be able to identify landlords across their companies. This act should mandate the disclosure of the actual people behind the companies to ensure enforceability. It should also be updated to ensure the denial of BBLs. When the same owner goes to renew a business license, they likely could renew. A bad actor shouldn't be able to continue getting a business license at the very property where they're not complying with the law. It's not logical, and I don't think it really conforms with the intent of DC laws. I think it happens because DC agencies aren't communicating with each other. To get a BBL, you need a clean hand certificate, which says that the business can't have more than $1,000 in outstanding fines and fees. It's likely that an owner with this level of violations would have $1,000 of outstanding DOB fines. It's likely they also need an inspection, but the inspections don't cover all the units. So it should just be clear that if they have outstanding violations, they shouldn't pass that inspection and get a renewal. The other issue, as mentioned, is that renewals only happen every 2 to 4 years. If a landlord doesn't want to make the repairs, they're just going to wait. So we really need a revocation process for landlords who won't fix health and safety code violations. And there needs to be a process to trigger this. I hope that when the agency speaks, we can hear if this formula is workable. I'm concerned that it's a little overly complicated with the idea that the number of violations meets 30% of the number of units. I want to make sure that the formula is easy to implement, that tenants can know when their building reaches that threshold, and that information will be shared with other agencies. It might be easier to look at total number of violations. So I just urge you to make sure that this denial is meaningful. Landlords should also not be able to bring cases in landlord-tenant court when they lack a BBL, and they shouldn't be able to take rent increases. Under rent stabilization, the rental unit in common areas by law have to be in compliance with the housing code. But landlords just check a box every single time saying they're in substantial compliance and they know there's no repercussion. As DOB looks at how to share information with other departments, they should design a process for sharing that information with DHCD's Rental Accommodations Division. Thank you for giving this issue the attention that it deserves.
Thank you. Are we on? Okay, we're on. Good morning, Chairperson Nadeau and committee staff. My name is Catalin Peter, and I serve as the Vice President of Government Affairs for the Apartment and Office Building Association of Metropolitan Washington, D.C., AOBA. AOBA represents owners and managers of nearly 120,000 residential apartment homes across the district. I'm here today to offer our testimony on Bill 26287, the Housing with Integrity Amendment Act of 2025. The legislation seeks to strengthen accountability in rental housing by linking business license eligibility to the resolution of housing code violations. AOBA supports the goal of improving housing conditions, absolutely. But it is concerned that as drafted, the bill could create unintended compliance and operational challenges for responsible housing providers. I'm going to take a little bit of leeway because I actually find some of the comments that my colleagues here have stated very interesting in terms of, while we may not get to the same place the same way, I think we are committed to the same outcome. So under the bill, the basic business license could be denied if 30% or more of a property's units have uncured Class 1 or Class 2 violations that remain unresolved for 90 days. Now, while that threshold aims to identify severe or systematic neglect, in practice, it could penalize responsible housing providers who are actively addressing issues but face delays beyond their control. And I would say this is likely our biggest concern. There are supply chain constraints, contractor availability issues, tenant access challenges, or pending administrative appeals. This could result in the loss of a basic business license for reasons unrelated to bad faith conduct. AOBA also urges the committee to consider some of the broader ripple effects that license denial specifically would create. Losing or suspending a business license could disrupt financing, insurance, and ongoing remediation efforts, which would undermine the progress rather than promoting compliance, which I do believe is the goal for all of us. We urge the council to consider some more targeted and narrow approaches to really go at the worst offenders, such as escalating certain civil penalties for verified chronic offenders, establishing a clearly defined repeat violator designation based on sustained neglect, and creating transparent appeals process to distinguish between willful noncompliance and administrative delay. Close coordination between the Department of Buildings and the Department of Licensing and Consumer Protection will also be essential to ensure consistent data-driven enforcement. We're very grateful and thankful for the work that we've been able to do with both agencies. We believe that both are highly committed to a track of compliance and that they are also highly committed to going against willful negligence and misconduct. AOBA also welcomes the opportunity to collaborate with committee staff on refining proactive inspection program tiers. When implemented predictably and transparently, proactive inspections can be an effective tool for maintaining housing quality without unintentionally discouraging investment or collaboration. The one other point that I would have to make is we are very concerned always about displacement of tenants. If basic business licenses are revoked, and they have an unintended consequences of having to displace tenants, we believe that that is a major problem that both, I think all of our colleagues here would want to ensure that it doesn't happen and that the goal really is compliance for violations. In closing, AOBA and our members share the district's goal of ensuring safe, dignified housing for every resident. We stand ready to work with the council to craft an approach that strengthens accountability while preserving fairness and operational stability across the city's rental housing system. I thank you, as always, for the opportunity to testify. Happy to answer any questions and always happy to collaborate with colleagues. Thank you very much. Thank you all for your testimony. I just have a few questions for Mr. Cawthorn, and then I will let you all go. Your colleague McKenna Osborne's testified in front of the committee about the ownership disclosure issue many times, including that CLC's never been able to use DLCP's LLC ownership data to go after a property owner in court. Has there been any improvement in the data, or is that still the case?
Yes, excuse me. Yes, there has been improvement in the data. I have been able to use that tool, that online tool, to look up housing providers. In the course of doing so, using those public records, I have found examples, though, of providers entities, I should say, who have obscured their interest by disclosing only another entity as the owner. An out-of-state entity in some cases, which is information that's less accessible, or it's goes into a trail that I cannot continue to track. It's too buried behind layers of companies.
Thank you. Appreciate that. And how does hiding behind LLCs hinder your organization's ability to get code violations resolved for clients?
Well, in the worst case scenario, it leads to us not knowing who is the responsible party, who to try and bring litigation against in the official sense, but also just trying to reach an informal resolution for some of the entities that have information that's contact information that's out of date, or they don't have any contact information that's clearly available. And all that's available is a entity name. Frequently, the entities are named after the address of the property. So there's very little to go off of, and it's difficult for our direct services attorneys to try to go through our official process or an unofficial process to reach a resolution.
Thank you. And thanks for raising the issue of case backlogs at OAH. That is an agency that's also under this committee's purview, and we are working with them to address that through additional staffing.
I'm happy to hear it.
May I note one,
Yeah.
with regards to that issue, we also find that it might be slightly different, but sometimes contact information that's asked upon is not necessarily the contact information of who you would actually contact to reserve certain violations.
Yeah.
It may be a parent company or something along those lines, because that's what's required. Our members face this issue all the time where they say, it's my name, I'm working on it, it's my contact, you can call me. But because of the way that the requirements are made, sometimes you don't end up access or finding that information. So I think that's something we would be happy to work on too, is effectively ensuring that people can get in contact with the people that they need to get into contact to, and that we're able to provide that information and still move forward with obtaining our respective licenses.
Okay, great. Helpful. Thank you. Thank you to this panel.
Thank you.
Okay, for our next panel, Denise Hunter L., Nathan Hunter L., Yolanda Thornton. Please come to the witness table when I call your name, if you are here. Okay, keep going. Jill Perry and Laura DeJager. It does not matter. I will ask you to go in the order that I called you. Since I called 5 and only 4 of you are here, you're gonna have to help me figure out who you are. So go ahead and sit wherever you like. So we'll start with Denise Hunter L. Is that you? Wonderful. So there's a button on the microphone base that you can hit when you're ready to go. And then just keep an eye on the clock. You'll have 3 minutes. Thank you. That's okay. Yeah. Just pretend you're talking to your friend.
Do what?
Go ahead.
My name is Denise Hunter L., and some of the issues that we are having at our complexes is the water leakage from the ceiling, the floors tilting in by the bathtub, mold around the tub, where we had a leakage that came into our unit, and it was right by my reptile enclosure, in which they could have started a fire in the building. I had to move him around. It's not just only the apartment that we used to live in, it's still our neighbors and the people that they had moved in 2 days after we had left. I'm more concerned about the people in the old complex that I live at because the landlord wasn't doing the things that they supposed to been doing. When you put in a work order to have things fixed, I know we gotta give them time to get the things that they need, and which everybody understand that, but how long can you go through living or seeing someone live going through something like that? And no one is actually there to help them. Even though I don't live there anymore, me and my husband still fight for the friends that we know that still live there. And I just want to make sure that the landlords be held accountable for the things that they supposed to be doing for them. That's all I have to say.
Thank you very much. And what's the building what's the address of the building?
Been Court.
Court. Okay. Thank you, ma'am. Mr. Huntrell?
Thank you, Councilman Nadeau. My name is Nathan Honeyhill. I'm a member, I live in Ward 5, and I'm a member of Empower DC. I support this bill. However, the landlords should be held more accountable for housing code violations, because as my wife said, we've put in work orders for several violations, and sometimes they got done, sometimes they didn't, or they didn't get done because the property management changed. Like at Bennett Court, the property management office is like a revolving door. So, but as my wife said, after we moved, because of the housing violations wasn't getting taken care of, housing code violations weren't getting taken care of, they moved somebody in 2 days later, and without even letting them know about the housing code violations or anything, or what was wrong with their apartment. As I stated, landlords should be held more accountable, because they want to hold us accountable as far as getting their rent, their rent and everything, but they won't be held accountable for taking care of the building. And so it's a good bill, but it needs to be strengthened to the point where, as I stated, landlords are held more accountable as far as if they don't take care of the housing violations in the time, code violations in a timely manner, they should lose their license. I'm in the process where we live at now, in the process of working with the property management on putting in a ramp for the tenants in the building that I live in now, because when we have like fire alarm go off for some apparent reason, the individuals in our building that have wheelchairs and walkers cannot use the elevators, and they can't use the stairs, so they have to use the elevator. So I'm trying to work with my building right now in trying to figure out a way how they can put a ramp or something, so those individuals, in case of a serious fire or true fire, can get out the building safely. I thank you for your time.
Thank you for your testimony. Is Yolanda Thornton among us? No. Okay. So then Jill Perry is next.
Can you hear me? Hi, my name is Jill Perry. I have been a tenant in Northeast DC for 3 years and 9 months now. My short personal story, amongst others, is that after 3 weeks of day and night, 12 hours a day, going to every single office in a landlord-tenant organization, it took me to discover that my landlord never had her permit inspection when she did construction to make one apartment 2. So with that being said, I'd like to speak to the part of the bill that says integrity. Integrity is defined as strong moral principles, not only for yourself and how you live, but for how you treat others. And that is critical in order to preserve the dignity, the human dignity of every human involved beyond their basic needs. My second point is that the current DC landlord system appears to be very divided and confusing. So instead, creating a system that connects and collaborates not only the organization itself, but with the landlords and tenants. So we are one working system, not 3, 4, 6 systems working back and forth with no common ground to understand each other. And with that, a goal of creating a system of accountability and transparency will give you an equal and just system. So.
Thank you very much for your testimony. And Laura Jaeger?
Hello, thank you, Chairperson Nadeau. Councilmember Louis George, nice to see you. And also obviously to staff. My name is Laura Jaeger. I'm here as an individual and as a president of my building's tenant association, which currently represents a little over 80 members, residents of my building. My building is located in Navy Yard in Ward 6. And we're a little unusual in Navy Yard because we're smaller and more affordable than some of the buildings that have recently been constructed, and because we're one of 2 buildings in the neighborhood that is majority voucher holders for residents. I'm here first and foremost to thank everyone and to support the Housing with Integrity Act, and time permitting, to offer some suggestions to strengthen the act. I'm confident that as of today, over 30% of the units in my building have serious unabated code violations, including pest infestations, heating and cooling violations, and plumbing problems. When I spoke with my neighbors about my testimony here, the majority said they believe that 100% of units in our building have unabated cockroach infestations. Despite the widespread issues, our building only has 3 open pest control NOIs. This is because residents know that reporting a violation is unlikely to lead to effective repairs or real consequences for our landlord, but is very likely to lead to intimidation and retaliation from our landlord. This is especially true after the passage of the Rental Act, which makes it much more difficult for tenants to independently address housing code violations, but makes it much easier for landlords to intimidate and retaliate against residents that do report their violations. So the Housing with Integrity Act is a very welcome first step in imposing real consequences on landlords that refuse to follow the Housing Act or the Housing Code. But I do think it can be strengthened in several ways. The first is that the act should consider violations that pose significant threats to health and safety but aren't associated with particular units. For instance, our building has a very significant rat infestation on the first floor, in our storage units, and in our loading dock and lobby. We have birds that live in the air vents in the facade of the front facade of our building, which causes bird droppings to stream down the building, hit our windows, and pool on the ground. And because they're in our ventilation system, this can be a very serious disease vector, but those aren't associated with any particular units. And so I think at the time may not contribute to the 30% threshold. I would also say that 30% is a high bar to meet, even if you have a tenant association with an active membership. And so I think violations like pest infestation, mold, heating and cooling issues that are likely to be widespread should trigger building-wide inspections at a lower percentage threshold. Vacancy rates should be considered. My building currently has a 36% vacancy rate due to the housing code violations, among other issues. I'm out of, I guess. Oh. I guess if I can go very quickly, I would say that tenants with open NOIs, especially after the 30% threshold is met, should get a hearing before they're required to pay into the rent registry if they're defendants in evictions, and that landlords that have their business license revoked should probably not be able to raise rent or initiate evictions until they fix their buildings. Thank you very much.
Thank you so much. And what building are you?
Onyx on First.
Okay, thank you. Thank you all very much for your testimony. I really appreciate you being here today.
Thank you.
Oh. Okay. Our next panel is virtual. This will be the final panel for the Housing with Integrity Act. The panel includes Andrea Chapman, community organizer with Empower DC, Michelle Chandler, Janet Phoenix, executive director of the Coalition for Environmentally Safe Communities, Mish Garner, Marta Cruz, Eduardo Fernandez Maldonado, and Wanda Harris. Go ahead, Ms. Chapman, you may begin.
Good morning. My name is Andrea Chapman. I'm a community organizer at Empower DC. My comments focus on the Housing with Integrity Act. Empower DC is grateful for the council's increased attention to improving unhealthy housing conditions and landlord compliance to DC's housing code, and we believe this legislation can be a critical step towards meeting those goals. However, while we encourage the council to move forward with this bill, we have several recommendations to expand its impact and support more tenants. I echo my colleague Farah that this bill should prohibit landlords with outstanding Class 1 and Class 2 violations from filing cases in landlord-tenant court. Since February 2025, Empower DC has been organizing at Benning Park in Ward 7, a property whose emergency conditions have garnered increased public attention, including by Councilmember Robert White. Empower DC was first alerted of this property due to numerous open landlord-tenant cases. When we conducted outreach to connect people with legal support, we discovered severe housing code violations that residents, some of whom you'll hear from today, report have been ongoing for years, including flooding, mold, and pests. Many Benning Park residents are intentionally withholding rent to get repairs for these unaddressed issues in landlord-tenant court. While this court is meant for lease violations and evictions, withholding rent and facing eviction is often one of the only ways to get repairs, clogging the court with these types of cases. On the other hand, Housing Conditions Court has tenants waiting years for repairs with no relief. A Benning Park resident brought a housing conditions court case related to flooding, mold, and other serious issues over a year and a half ago. The case is open and they are still waiting on repairs. Tenants there are contending with flooding, and recently tenants in several buildings faced both a gas and sewage leak and currently have no hot water. Despite these emergency conditions, some tenants remain at risk of eviction, new tenants are moved into units with outstanding violations, and there's no ownership or management accountability. While Empower DC will collaborate with the council and Department of Buildings to address issues at Benning Park, we asked the council to use DOB's nuisance abatement fund for the property. It's been a week and a half since we requested this with the strategic enforcement team, so we would just like to, see if we can get that moving. DC also needs stronger and speedier processes that encourage compliance before it gets to this point. With the Rental Act that'll accelerate evictions and change protective order processes, we need strong legislation that prevents repeat violators from evicting tenants in an even speedier process without ever fixing bad conditions. Empower DC also recommends that the legislation apply to both new business licenses and license renewals, and should establish an automated process through DOB to revoke business licenses for bad actors. Applying this legislation as written only to property owners seeking new licenses limits the bill's impact. Properties with current outstanding violations that are seeking to renew their license would not be affected. What's more, basic business licenses are typically renewed every 2 to 4 years, which further lessens the impact on license renewals. Empower DC recently held a tenants meeting with DOB strategic enforcement team, where tenant leaders, including Ms. Laura, from across the city, highlighted the failures of DOB's enforcement process to incentivize repairs and prevent displacement. Timeline requirements for abatement aren't followed, fines continue to mount, and many tenants are forced to leave their homes in search of livable conditions, like Ms. Denise and Mr. Nathan. Without expanded legislation that includes license renewals and revocation, housing providers who are currently failing to comply could continue operating while properties languish without improvement. In conclusion, Empower DC supports this bill as a positive step towards improving landlord compliance and conditions. However, we encourage the council to consider our recommendations to expand the impact of the legislation. Thank you.
Thank you very much. Next, we will hear from Michelle Chandler.
Hello. Hi, my name is Good morning and good afternoon, council members. My name is Michelle Chandler. I'm a resident of Ward 6. I'm here today to support the Housing with Integrity Amendment Act of 2025 and to encourage you to strengthen this act to ensure that landlords comply with DC Housing Code and related laws. I live in Bennett Park Apartments. We were displaced from our
Ms. Chandler, I'm so sorry you froze. If you, we can come back to you. We may need to have you turn off your camera so that your internet can transmit your message. So let's go ahead to Janet Phoenix.
Good morning. Thank you very much, Chairperson Nadeau and members of the committee for allowing me to testify.
I'm sorry, I don't know where.
Ms. Chandler, we'll come
Hello?
back to you. We'll come back to you.
Okay.
I'm happy to wait.
Okay. All right. Ms. Chandler, you want to try again? It might help to turn off your camera if the internet's a little spotty, because then we can still hear you. Go ahead and give it a try. However you
Okay.
want to do it.
Okay. Is this good?
Yes, we can hear you great.
Is this good?
Yes, go ahead.
Okay, so I don't know where y'all left off. Okay.
You can go ahead and
basically,
start
I'm not
over.
gonna start. Do I start over?
Go ahead and start over. Yeah.
Okay, good morning, good afternoon. My name is Michelle Chandler, and I'm a resident of Ward 6. I'm here to support the Housing with Integrity Amendment Act of 2025 to encourage you to strengthen the act to ensure landlords comply with DC housing codes and related laws. I live in Bennett Park Apartments. We are displaced from our homes on September 21st due to a sewage backup in our building. We returned to our homes on September 30th, but we still don't have any hot water. 22 days without hot water. The DOB and council members from Robert White's office were on our property when we returned, but we still haven't heard anything. We don't even know the future of our property management company. We've been abandoned. DOB, all they do is issue citations. I don't have Section 8 or a voucher. I've never missed paying my rent, but I've had no air conditioning since July the 9th of 2025. I reported this to DOB. They came to inspect and issued the citation, but the same unit that controls my AC also controls my heat. So as winter approaches, I don't have any heat, no hot water, and I have 2 daughters who don't understand why it's happening or why. I had concerns about the sewage backup. What happened to cause the backup? I'm concerned if the building was exposed to any airborne bacteria. Would the HVAC and air ducts need to be cleaned? Are they going to be cleaned? Would there be any mold and mildew prevention throughout the building? What is the maintenance inspection plan and service guarantee for the issues in the next coming months? Our community needs some direction as tenants and what the next steps are, but who's going to help us and who's going to be held accountable for our complex? Which agency is going to do the enforcing? What agency is going to do what they're getting paid for and what they were created for? I'm willing to talk to anyone who can help, even news and media outlets. We don't, as a community, deserve the unresponsiveness from the government agencies and the management company. We currently have 39 AC units out, 7 buildings without hot water. We need help with habitable housing, staying informed about what's going on with the property, and talking to someone who's going to take accountability within the scope of landlord-tenant law. We have habitability, which is a landlord's legal obligation under the state and local laws to ensure properties meet basic health and safety standards. Ignoring maintenance requests can be a breach of this warranty. Thank you for your attention to this matter. Housing code violations are serious. I encourage you to pass this legislation and consider it a first step in updating DC's laws so that landlords comply with the housing code. And that's it.
Thank you very much. And Janet Phoenix, thank you so much for waiting.
Yes, thank you very much, Chairperson Nadeau and members of the Committee on Public Works. My name is Janet Phoenix. I'm the Executive Director of the Coalition for Environmentally Safe Communities. I also chair the DC Asthma Coalition, and both of these groups and organizations participate in the campaign to reduce lead exposure and asthma. And my testimony is being submitted on behalf of the campaign. I support B 26 0287, the Housing Integrity Act of 2025. I also support the improvements to the legislation that were suggested by my colleagues at Children's Law Center and Empower DC. Many of the children in DC I work with suffer from asthma, a respiratory condition that is associated with housing conditions such as pest infestations, rodent infestations, leaks, and mold. I've managed an asthma home visiting program for children, primarily for children in the Medicaid program since 2013, and I have visited or coordinated the visits to the homes of more than 1,000 children, the sickest children, those who frequent the emergency room and who are hospitalized frequently, who were referred to me by their pediatricians at Children's National and MedStar Georgetown Hospital. That work has brought me before the council to testify many times over the past few years, in particular before the Committee on Housing and the Committee of the Whole, about the need to improve housing conditions, especially in low-income rental housing. Emergency room visits and hospitalizations for the children I work with cost DC a substantial sum in cost to the Medicaid program each year. And many of these costs are preventable if you address the underlying housing conditions that cause the children to become ill: pest infestations, mold, leaks. I have included in my written testimony some of the statistics about how DC compares to other parts of the country. I won't mention that today, but let me say that some of the reasons for asthma disparities include housing conditions as well as exposure to outdoor pollution. Guidelines published by the National Heart, Lung, and Blood Institute, and that's the part of NIH that creates the standards that pediatricians use to manage the care of children with asthma, recommend assessing homes for asthma triggers, especially cockroaches and mice, and removing these as part of a good medical management plan. There's strong scientific evidence supporting that approach. Through the DC Asthma Coalition, I've worked with many organizations and agency representatives to create a plan for DC to help address some of these conditions, and I've included our recommendations at the end of my written testimony. Our campaign to reduce lead exposure and asthma really is advocating that these housing conditions be addressed, but that the framework of housing code enforcement be improved. I support this legislation because it's likely to result in a decrease in the time and to address some of the worst actors, those landlords who defer maintenance despite repeated complaints having been made by their tenants. It's a step towards implementing some of the recommendations that were made in Broken and in Need of Repair, a report for the DC Council on the District of Columbia's housing code enforcement process that was prepared in January of 2024. Many of the recommendations that have been mentioned today were also included in that report. It highlights the often lengthy process between a complaint being filed, a notice of infraction or violation issued, and verification of the abatement of the adverse conditions. The ideal outcome stated in this report is that any housing code enforcement process obtains substantial compliance from housing providers as quickly as possible to ensure the safety and the well-being of the tenants. The last point I'll make, which I did not include in the written testimony, is that the information systems at DOB don't seem to easily provide for building-wide approaches to housing code enforcement, and as well as being deficient in helping to track repeat offenders like these landlords that we've all been talking about today. My thanks to Chairwoman Nadeau for acknowledging our campaign by attending and speaking at our town hall event on March 8th of this year. I applaud your leadership on continued efforts to protect DC residents. Thank you.
Thank you very much for your testimony. Marta Cruz.
Hello, good morning, Chairperson and members of the committee. My name is Marta Cruz, and I'm a Ward 1 resident, mother of 3, and parent advocate. I'm here in support of the Housing with Integrity Amendment Act of 2025. This bill creates real accountability for landlords who repeatedly ignore serious housing code violations because safe and stable housing is a necessity and not a privilege. When landlords ignore violations for months, families are forced to choose between their health and their home, and no parent should ever have to make that choice. I appreciate the intent behind this bill by tying business licenses to compliance and creating a tiered inspection system, but I want to focus on two key areas that can make this legislation stronger. First, the 30% threshold. Right now, a landlord could be denied a license only if 30% or more of the units have unresolved Class 1 or Class 2 violations for more than 90 days. This is a great concept, but a bar too high. A landlord with a 100-unit building could keep theoretically 25, 28 units unsafe with no heat, electrical hazards, a collapsed ceiling, and still be considered compliant. The council should consider lowering the threshold to 10 or 15% because even a few families living in dangerous conditions is too many. The second is the data transparency. The Department of Buildings public dashboard shows open violations, but not unit-level historical data, making it impossible to see how many properties truly meet the threshold. I urge the council to require DOB and the Department of Licensing to publish clear property-level data showing the number of buildings with chronic violations that meet the threshold and how many licenses are denied or renewed under this law. User-accessible data is essential for public oversight. And if we want this policy to truly change landlord behavior, we must make it a deterrent. In closing, I strongly support this bill as a critical step towards protecting tenants and improving housing conditions, but the council can make this legislation even more effective by lowering the 30% threshold and improving data transparency to ensure that every DC family has a safe and healthy home. Thank you.
Thank you very much. Wanda Harris.
Good morning, Chairperson, and good morning, council members and all who have been a part of this process. I thank you for the opportunity to testify this morning. My name is Wanda Harris, and I'm here today to provide this testimony in support of the Bill B26-0287, the Housing with Integrity Amendment Act of 2025. Ooh, that's a mouthful. I also encourage you to listen to some of the suggestions to strengthen this bill, but I definitely support this legislation. I'm a third-generation Washingtonian, a retired public school educator after 40 years, and a proud resident of the 16th Street Heights community for 38 and a half years. I've been blessed to live in a supportive and caring neighborhood with hardworking neighbors who looked out for one another. Our community included single-family homes, semi-attached homes, and a variety of apartment buildings, including co-op and rent control. Approximately 5 years ago, our neighborhood started changing when development groups like Petra, Nachitos started purchasing the rent-controlled buildings, and other individual property developers started purchasing single-family homes, leveling them and building multifamily buildings. Soon afterwards, at community meetings, community members and tenants in these buildings started complaining about the negligence. They started experiencing a decline in their living conditions and safety and community stability. Hazardous and unsanitary conditions inside and outside of the properties were reported. In my written testimony, I include some of the things that were reported at meetings, and you've already heard those concerns from others, and they are real. I'm also here to say that having been a public school educator for 40 years, I know the effects of substandard living environments. They have a severe and wide-ranging effect on the people living under and around those conditions, and you've heard some of that. The research shows an increased risk of chronic diseases and injuries, physical, mental, and emotional health effects. These impacts of these developers' negligence regarding the deplorable housing conditions that these people are allowed to live in, it's affected our entire community. There have been countless numbers of police responses to violent crimes in and around buildings. And listening to how the tenants feel and how they feel in terms of not getting responded to is concerning. I have followed the reports and attended the meetings that outline widely known and thoroughly documented housing code violations. And while I can only speak for the Ward 4 community that I live in, I know and you know that there are many such landlords throughout our city who willfully neglect our city's residents, including our most vulnerable residents, without consequence. They've been well paid for providing unsafe housing, causing a lot of damage to residents, communities in this city. I urge you to pass this bill after strengthening it, Bill B260287.
Thank you, Ms. Harris.
Housing with Integrity Amendment Act of 2025. And I thank you again for the opportunity.
Thank you.
Bye.
Our final witness is here in person, Giselle Powell. Giselle, feel free to correct me.
Grand Rising. My name is Giselle Powell, and I'm here to speak on the conditions that I have been living in. I have been underneath housing for the past 10, 11 years. In the units that we have lived in, the first unit we moved in, we had black mold severely to the point where my child had to go through emergency surgery to have his adenoids and tonsils removed because of his breathing condition in there. They moved us to another unit that, again, also had black mold. It was hidden underneath the carpet that also affected both of our breathing as well, and was going through court issues with that. And they finally moved us again. Now we're in another position where there's water damage in the unit. There's mold building up in our bathroom, and it's smelling very badly, and it's starting to have more health issues on me and my son again. And I also wanted to bring up the issue where, my mom, she just passed 2 years ago. She was placed in a unit, and come to find out she was placed in the wrong unit. The unit, she was exposed to carbon monoxide 30 days of my mom moving in. She died. That week, I took her to the hospital. Not even 24 hours of her being discharged from the hospital, I was performing CPR on my mom. So it's to the point where these landlords need to be penalized for what we are enduring. We cannot see issues in homes if only thing that they're worried about is appliances working. We can't see carbon monoxide. We can't always see the mold, but we're inhaling it, and it's affecting us dramatically. My son also has autism, so it actually played a dramatic role in his learning ability as well. So it's taken a little bit more for him to develop the things that he needs to develop due to the exposure of black mold. I just wanted to share that, and I thank you all for listening. Y'all have a good one.
Thank you so much for taking the time testimony. And I want to thank this whole panel. Did you have questions for the panel? Yeah, okay. I did want to ask Ms. Chapman, you mentioned a tenant at Benning Court brought a case against the landlord in Housing Conditions Court, but that had been going on for more than a year and a half. Why is the court case taking so long?
I think that's just been the nature of Housing Conditions Court for a while now.
Okay.
We've spoken to several tenants who, they filed the complaint last year and they're still in the process. When I checked last night, the court had ordered like 45 days to do the repairs, but we are very concerned that this timeline won't be followed because, of course, the issues that I mentioned were very severe. And, we're learning more and more now. We found out that one of the buildings lacks gas. So there's just, I think there's just a delay all around.
Okay, thank you. Thank you all. We have been joined by Ward 4 Council Member Louis George, who may have some questions, but also is going to make an opening statement.
Awesome. Thank you so much. Thank you, Councilmember Nadeau. Thank you for having the leadership to care about tenants and to bringing this legislation forward in your committee. And thank you to the tenants and advocates who have testified thus far and shared your real life experience. I introduced the Housing with Integrity Act from being on the ground in my ward and dealing with housing issues persistently. Neighbors calling me, Councilmember, we have mold in our building. Councilmember, can you come look? I'm coming, I'm on my way. I go to the building. I go to meet one neighbor about it, and then I end up in multiple neighbors' homes seeing the same conditions. We have infestation of rodents and roaches. Can you come see? Yes, I'll come. I go to one person apartment who called me over, and multiple people say, Councilmember, why are you here? Come look at my apartment. Come see what I'm experiencing. The door is broken, serious public safety concerns. The door is always broken. The trash is always piled up in the back. Trash is always throughout. Councilmember, come see it. Okay, I'm coming. I come and I see the conditions, and every time what was supposed to be sort of a 15-minute visit for me ends up an hour and a half, a 2-hour visit in apartment buildings where tenants are finally just happy somebody is here to see what they have been emailing or sending pictures about. But being able to see it in real life, in real time, makes a serious difference in sort of your advocacy and trying to find a solution for it. I do the things that I'm supposed to do, call the Department of Buildings and say, I need you all to get over here and do these inspections. And I'm grateful that when I call, DOB does answer and comes out and does these inspections. And they do, they come and they give the violations. And then I'm back again the next week, over and over again, dealing with the same issue. And then that's leaving neighbors with serious, not only serious housing code violations, but children arriving at school sick due to unsafe living conditions, and neighbors left powerless as nearby properties fall into dangerous repair. It's not just the tenants in the buildings who are experiencing this, but the greater neighbors who are saying, Councilmember, you got to do something about the conditions that are happening in these buildings in our neighborhood. This is something we've never seen before. And neighbors surrounding these buildings also trying to advocate for the tenants inside of the buildings. I'm proud that I live in a ward where the neighbors surrounding the buildings and the tenants inside the buildings are willing to fight together. But I'm disappointed in the fact that while these things are left to happen, then I get news that the same companies who own these buildings and who are allowing these persistent housing code violations repeatedly are expanding their footprint. Expanding their footprint in my ward, expanding their footprint across the city. And I'm like, I'm sorry, how are you creating more problems for me? It's true in our ward, because now I'm in another building and I'm like, who owns this building? Oh, same person. Who owns this building? Same person. Well, maybe call the Attorney General's office. We can't sue our way out of this. Like, the Attorney General's office isn't the answer to this, right? Suing your way out of this and going through litigation doesn't help anybody, not the owners, not the city. We can't rely on the Attorney General's office to be the persons and people who are doing this. So I said, my grandma always says, don't come to me with problems, come to me with solutions. The Housing with Integrity Act is just one of the solutions that I am proposing, because I have been persistently for years in apartment buildings with tenants living in unsanitary conditions, doing the things, filing the reports with DOB, trying to get some action moving forward. And this is one of the solutions that I'm hopeful. It's a clear current enforcement tools are not strong enough and effective enough, and we have to create new ones that actually will have some teeth and curb some of the behaviors that we are seeing that are persistent in our city. So that said, I know that during the development of this bill and preparation for this hearing, we've heard serious concerns from the Department of Licensing and Consumers sort of about their capacity to effectively implement and enforce the proposed measures. And one of the most pressing questions is how we ensure accountability for landlords at properties they currently own, not just future acquisitions. That is something I'm willing to address and strengthen. But again, I'm coming to the table. Don't come to the table with the problem, come to the table with the solution. We understand that when a landlord is barred from renewing a business license due to code violations, they may continue to operate illegally if left unaddressed. This creates a dangerous loophole that may lead to unintended consequences, including displacement. That is something we have to address. We must ensure that both DLCP and DOB have the tools, the staffing, and the resources necessary to hold bad actors accountable and prevent them from continuing to operate unchecked in the district. That's my commitment to both DLC and DOB. And we need to do this in a way that both is effective and workable with maximum impact for our communities. The Housing with Integrity Act is a first step in the right direction, and I'm grateful to the public and government witnesses that are here today testifying on their lived experience and technical expertise so we can ensure that this bill goes far as it can to hold bad actors accountable in our housing system and curb the current behaviors that are leaving our communities unsafe, our children unsafe, our seniors unsafe, and our families unsafe. We can do better, we must do better, and the Housing Integrity Act seeks to do just that. Come to the table with a solution because the problems are not being currently addressed and the status quo is going to leave our neighbors and our communities behind. So with that, I want to ask the panel of witnesses a few questions. Ms. Harris, I want to thank you for your testimony about the issues you witnessed in your community and the concerns you have for your neighbors. Petra's actions have been a particular concern for me, and I want to put a stop sort of some of the exploitive practices as soon as possible, and I appreciate you shedding light on these. Can you speak more to changes you have seen in your neighborhood and why it is so urgent that we stop bad actors from snapping up more properties in our communities?
Yes, ma'am. First of all, I do sometimes volunteer up at the school, so we see some absenteeism because children are sick. Neighbors come to neighborhood community monthly meetings and seeking help, and they are talking about the conditions in their building and trying to figure out the next steps. Some of them are afraid to speak up for obvious reasons having to do with what's going on in our country right now. And others just don't know what to do. And some don't really have the time. So as I'm walking around and picking up trash, you know me for that, Councilwoman, and at the playground, I listen to the conversations to try to understand what's happening in my community, and I'm willing to be a voice and say, this is what's happening. And you're right, we are blessed in Ward 4 to live with a lot of people ranging from a lot of different backgrounds, and the diversity is beautiful, and the support is beautiful, but the conditions that our neighbors are having to live in are deplorable. They're just deplorable. And you don't have to go in the building. You have the opportunity to go in the building. And you can go in the building because doors are broken, glass is broken, and that shouldn't be. So there's a level and concern of security, as well as just the exterior. My first job in the city way back in the 70s was the youth conservation worker. So I'm persnickety about trash. So I don't walk without picking up trash, but I don't go on other people's property. But I will pick up trash because I believe, just like the tenants of those buildings believe, that they have a right to live in a good condition. And we know that the impact on people emotionally, not only what they're experiencing in their housing and living conditions, but just the pressures of making it in the world. This shouldn't be. We're better than this, and they deserve better than this. Our community deserves better than this. And so I do applaud what you've done, council member, and I thank you for that. And I thank you for always coming when we call, because you do. And I don't know when you sleep, but I do pray for you every day because I know you are extending yourself.
Thank you.
I yield back.
Thank you so much. Ms. Chapman, I want to thank you for your testimony about the housing conditions calendar and the issues with the enforcement mechanisms that we have and aren't working. I'm wondering if you can speak a bit more to what you have seen on the ground with regard to sort of current DOB enforcement practices.
Yeah, so we actually just had a meeting about all of this. Starting even from requesting inspection, communication is definitely a big issue. We had about 60% of the tenants that we spoke with who said that they actually got like a report following their inspection, or were even notified about the time and the date of the inspection. Other issues include the enforcement mechanisms. As I mentioned in my testimony, the timelines that are supposed to be laid out for landlords to follow aren't really being followed. And, the fines just continue to go up and up, but there is no mechanism to really hold landlords accountable who fail to pay those fines. So, those issues. Language accessibility has been another issue for non-English speaking folks. Other issues are the professionalism and the completion of the inspection, making sure that all violations are actually captured. And we do have some recommendations that we're going to submit in the roundtable that's happening, I believe, next week under Councilmember Robert White that go into more detail. But another issue we've seen is that when people actually are in the process of having their inspection, inspectors aren't really proactively asking if there are other violations that weren't included in the original request. So we just, we think that there needs to be more proactive communication, and there needs to be more of an effort on DOB's part to make sure that they're capturing all violations. And then when it comes to enforcement, fines should be imposed directly to the landlord. And, there also should be a report actually sent out, and there should be more of a detailed explanation on how the timeline or what would happen if the timeline isn't followed, and who the tenant can actually, speak to about that and get the repairs done.
Yeah, absolutely. Thank you so much. And I look forward to participating in the roundtable and hearing more about sort of you all fleshing those things out.
Thank you for having me.
Of course. Ms. Chandler, I'm so sorry to hear about the terrible conditions at Benning Park Apartments. You and your neighbors absolutely deserve better. Experiences like yours are exactly why I introduced this legislation, both to stop what's happening to you all and landlords from inflicting those conditions on even more communities, but hold them accountable to try to create more proactive and try to create more proactive inspections. We'll be hearing from Department of Building later on today, but I do want to ask, how many times have you had to have DOB come out to your unit, and have they ever given you sort of a sense of what follow-up they are doing to make your landlord do better? Is she still on? I can't see the screen. Ms. Chandler, are you still on? Can you all see the screen?
Yes,
I didn't see her name, Councilman. Oh, there she is. Okay.
Ms. Chandler, did you hear my question?
No, ma'am. Can you repeat that?
Yeah, I'll shorten it and just say sort of how many times have how many times has DOB come out to your unit? And do you have a sense of what follow-up they've been doing to sort of accountability follow-up they've been doing after coming to your unit?
They've been to my specific unit 3 times, where I have put in the complaint, and then to my entire building 2 times upon us returning back to our property after the sewage backed up, and every single thing is still the same. And when we did have a management company, the management lady, she told me, she said, I got the citations. We can't afford to pay them, so just let them keep coming. I don't care. And she showed me a stack of them on her desk. And nothing's changed. Every single one is still the same since July.
Got it. So you're saying DOB has come out, they've done the inspection, they have made infractions towards the owners of the property, and yet the issues are still remaining.
Yes, ma'am. They've emailed me the citation number and everything.
Got it. Thank you. I appreciate that, and actually have my team try to follow up. And I know how you probably work for the housing committee, but we just want to make sure there is some follow up for you all. And I appreciate you coming out to testify and understanding that. Yeah, you wanted to say something else? I see your hand.
I just wanted to jump in. Thank you, Ms. Michelle, for all you said. But I just wanted to add that that's why we really would need that nuisance abatement money, if possible, from DOB to fix Benning Park. Just wanted to add.
Understood. Awesome. Thank you. With that, Councilmember Nadeau, thank you so much. Thank you to this panel of witnesses, and I appreciate you all coming out and adding to us taking the steps to strengthen this legislation and come up with a solution for our community. Thank you.
Thank you. And with that, we are concluding the portion of the hearing regarding the Housing with Integrity Act. Now we will move on to the Resale Act, which I don't think that we have very many people signed up to testify Or we are going to begin with in-person witnesses, and I'll seat the first panel. And while they're being seated, I will turn to Ward 6 Council Member Charles Allen to make an opening statement. So our first panel includes Ron Gubitz, Music Artists Coalition, Audrey Schaefer, Director of Communications with IMP, Jean Hamza, Community Liaison with the 930 Club, and Catherine Ferrando with the Black Cat. So please sit. Oh, it doesn't say that. Oh, the fifth one. Okay. And then Adam Webb, Campaign Manager for Fanfare Alliance, is going to join this panel virtually because we are just that good at holding hearings, so we can pull that off. Go ahead, Councilmember Allen.
Well, first off, thank you, Madam Chair. I appreciate you holding today's hearing. I appreciate your staff as well, working and collaborating with mine over the last several weeks and months on Bill 26-224, the Restricting Egregious Scalping Against Live Entertainment or Resale Amendment Act of 2025. We love our acronyms, and so we made sure it worked. And I also want to thank all of our public witnesses. I know we have a large number of folks that'll be here throughout the day, and so I appreciate everybody coming in to share their feedback and their recommendations here. Madam Chair, for the amount of culture and arts that's available here in the District of Columbia to absorb, you'd think that it's relatively affordable and easy to buy a ticket to see your favorite artist or band or comedian at one of DC's world-class venues. Unfortunately, the ticket buying process is an expensive Wild West here in DC and around the country. When you search for your favorite artists and tickets, there are 4 or 5 sellers paying to put their link first. None of them are probably actual venue and box office. You might buy a ticket that isn't even available yet. You're going to pay a ton of fees. At the end, you can't even say for certain that you're actually buying a real ticket. If you do buy a fake ticket, will there be a real person there who can fix it for you? Let's be very clear. The status quo for going to a concert today doesn't work, and it is not a free market. It's a race between a person and a bunch of computer bots, and the bots are winning. It's a race that forces you into another artificial and manufactured market, one that the bots and the scalpers have created. It drives costs up, it shuts out most fans, and it simply is not fair. It's bad for our music fans, who are basically expected to shell out hundreds, if not thousands of dollars on tickets to an out-of-town digital scalper, basically paying the same price they would to buy a flight overseas. They also spend less money on things that then support our local economy. Dinner or drinks out, merchandise at the venue. When people get gouged on the price of the scalp ticket, their budget isn't unlimited, and now they go to fewer shows they otherwise would, and they spend less within our own local economy. It's also bad for the venue, who have to now try to help that disappointed fan who bought a fake ticket. It's bad for the performers, who don't want their fans to resent them for the crazy cost to go see them perform, even though they set a face value ticket much lower. All of this is driven primarily by the ridiculous profit incentive that there is, magnified by a combination of technology and a captured market. A concert ticket has become a luxury good, not just for the biggest acts, but for nearly every performer out there. It may cost a fortune to see Taylor Swift, Beyonce, or Bruce Springsteen, but it also costs a fortune to see Lorde, Hermanos Gutierrez, Wet Leg, Waylon Watt. And if you don't know who all those artists are, that's the point. Everybody gets hit. That's why I included a 10% price cap on how much you can mark up this ticket in this legislation. That should work fine for someone who has a change of plans, but it takes out the financial incentive to game the system by employing thousands of bots and then reselling the tickets in bulk on their manufactured market. And we are going to hear a lot of disinformation today from out-of-town companies and lobbyists that stand to lose a lot of money when the council passes this law. I've seen a lot of paid Instagram ads this week trying to convince people that this bill is actually good for Ticketmaster and Live Nation's near monopoly who operates the box office. Can't make sense of that. First of all, the bill applies to Ticketmaster, just like everyone else. Second, almost every ticket that we're talking about today is a resold ticket. Have you ever noticed that when you're buying tickets a couple of months out from a show, most, if not all, are resale tickets? I think it's more accurate to say the companies who control and dabble in the secondhand market, which are the ones paying for those Instagram ads, and are some of the Ticketmaster and Live Nation's most loyal customers, since they buy so many tickets from them at the initial sale, then later force your everyday consumer to buy them on the secondary market. I do want to make one thing clear and address an elephant in a room, who chose not to be here today, Live Nation and Ticketmaster. I wholeheartedly think it's a monopoly. Its practices can be harmful to artists, fans, and venues. And I'm extremely supportive of the DC Attorney General joining the antitrust lawsuit to make a change. But let's also be clear here. It may be convenient for the resellers that stand to lose their ability to gouge fans' wallets to confuse people with this PR strategy, But addressing monopolistic behavior is a separate issue and one that is not within this council's legislative powers. However, what this council can address is the ridiculous profit and gouging incentive out there that allows the bots and the scalpers to exist in the first place. So let's make one thing clear. This incentive exists with or without a monopoly. And to buy their arguments, you'd have to believe the way things are working today is doing just right. The companies testifying today against the bill, as well as their Delaware-based, not DC-based, corporations and LLCs, might have some good tweaks that I do want to consider to ensure a safe and trustworthy secondhand market. But let's not lose, they stand to lose a lot in profits. And I'm okay with that, because that profit is coming at the expense of my constituents, at the expense of the artists who create the music or performance that people are paying to see, at the expense of the men and women working backstage who put that show together and make it happen, and at the expense of our local music venues who anchor their neighborhood and live and work here year-round. IMP shared data with me that shows more than 61,000 tickets from their venues have been listed on the secondhand market just this year. The combined markup on those tickets above face value, $59 million. Not one penny of that money is going to go to the artist. It's going to go to the stagehand, go to the audio techs, or to the venue itself. I imagine almost none of it actually stays in the district. I look forward to hearing from the 930 Club, Union Stage, DC9, Black Cat, some of the most iconic venues in our city and in the country who invested in and helped shape our city. I look forward to hearing from DC residents who are sick of paying the middleman way too much money just to go see a show. There's a growing sense among Americans that almost everything has gotten worse in recent years and the cost of everything continues to go up. And I think that's right. The promise of big tech has led to some amazing improvements in quality of life, but also to plenty of cases like this, where a middleman just makes the whole process more expensive and more annoying to just go see a show. But thankfully, we can fix that with this legislation today. Thank you, Madam Chair, and I look forward to today's conversation.
Thank you. We'll now turn to our first panel, and we're going to go the order in which I called you. So Ms. Schaefer may begin.
Here we go. I'm Audrey Fick-Schaefer, excuse me, with an allergy here, Director of Communications for IMP, the independent DC company that operates the 930 Club and the Atlantis in Shaw, the Anthem at the Wharf, and the historic Lincoln Theater on U Street. I'm testifying in support of the Resale Act and with gratitude for Councilmember Charles Allen for drafting this bill and Madam Chair Nadeau for chairing this hearing and the rest of the committee. Make no mistake, this is the most pro-consumer protection bill we've seen pertaining to DC concert tickets. And I believe that's why 8 council members co-introduced it in April, including those on this committee. And it also came with the endorsement of the Attorney General. And I also believe that's why you'll hear today from a bastion of those representing predatory ticket resellers and the platforms that make billions from them. Thank you for considering legislation that will finally put district residents and local businesses ahead of predatory resellers. I know you'll hear today from scalpers and platforms that call this the free market, but I've spent 2 decades watching what their free market does to our neighborhoods, our fans, and our local economy. Independent venues are a part of DC's economic infrastructure. We are based in DC and we're taxed in DC. When the 930 Club opened at 9th and V in 1996, the neighborhood was abandoned buildings and us. Today, it's home to thriving restaurants, apartments, and small businesses that generate millions in sales and property taxes, all growth seeded by live music. At the Wharf, the Anthem anchors a mixed-use district that brings more than 1 million visitors a year, supporting hotels, metro ridership, and thousands of jobs. Every one of those dollars circulates here in the district. But the money siphoned by ticket brokers and secondary market platforms goes out of DC entirely to Silicon Valley, Chicago, LA, Connecticut, and hedge funds that have never booked a local band or hired DC workers. Well, all the money except for what they spend on lobbyists and PR people anyway. We see consumer harm nightly. We track our tickets on the resale sites. As Council Member Allen noted, we have tracked at IMP with our 4 DC venues, 61,000 tickets resold at double face value or higher just so far this year, taking $60 billion from DC customers. I spoke to a reporter earlier today, and they spoke to someone who was on the opposite side that questions the data in this report, I'm happy to share it with anybody at any time. Some examples. At the Atlantis, our average ticket is $29, but the average resale price on the secondary platforms is $355, more than 10 times face value. At the Anthem, John Mulaney ticket was $724. And just today, we have an example. There's a band called The Last Dinner Party that you might not have heard of, but it's very popular. And we had not put a single ticket for sale yet on the market this morning. But yet, SeatGeek, Vivid Seats, StubHub, Ticket Network, all of them had tickets on sale today, up to $220. These are fake tickets. And when we put them on sale, they'll be $46. That's speculative ticketing. Fake tickets that trick fans into overpaying. What else are you allowed to sell that you don't already know? I can't think of something. It's not just deceptive, it's fraud. And please don't fall for what the brokers say who say spec ticketing with disclosure or concierge service helps consumers and she should be permitted. That's bogus. Bots enforcement alone has failed, but it's easily fixed. The Bots Act of 2016 was meant to stop automated scalping, but it's only been enforced once in 9 years. No local agency can chase anonymous, invisible out-of-state bots through shell LLCs. The Resale Act closes the gap with clear local rules that DC can actually enforce. How? Price caps. They take the profit motive out of using bots and gives everyone the same chance to buy the ticket. DC must hold the platforms hosting these tickets responsible. It won't be complicated, and the fines for violation will be an incentive. Price caps will keep fans, artists, venues, and make DC competitive. In France, where ticket price caps exist, DC's Taylor Swift fans literally flew overseas, rented hotels, bought restaurant meals because it was cheaper than buying a ticket in the US. If DC adopts reasonable recap sales, we can keep these dollars here and make ourselves a DC concert tourist destination.
Thank you, Ms. Schaefer.
Oh, am I on? Oh, I'm almost done. Can I have 1 extra
I'm
minute?
so sorry. There are way too many witnesses. We'll have it all in writing.
Okay.
Okay. Okay. Ron Gubitz, please.
Good morning, distinguished members of the committee and council, and thank you for the opportunity to speak. My name is Ron Gubitz. I am the Executive Director of the Music Artists Coalition. We're actually incorporated here in Washington, D.C. in 2019. MAC is an artist-driven organization that fights to ensure that music creators have a voice at the table like this in policy negotiations concerning the practices that are going to directly impact our artists' careers, their livelihoods, and their families. Our board includes Irving Azoff, Dave Matthews, Verdine White of Earth, Wind & Fire, and Anderson .Paak, among others. Our artists simply believe that the people making the music should be the people making the decisions about how their tickets to their performances are sold and resold. Artists invest precious time and energy and money and creative gifts to deliver deeply memorable live entertainment experiences for their fans. There's truly no one who cares more about music fans than the artists themselves. Our artists owe quite literally everything to their fans, and we have watched nationwide as those fans have been repeatedly taken advantage of by resellers, profiteering off of the art we make and the performances we craft for our fans. Washington, D.C. has before it a unique opportunity to stand up for the fans who have had music change their lives for the better and to lead the nation in protecting artists' rights in doing so. MAC's core ticketing issue is the limit or cap on resale. We love the provision of a 10% cap here in D.C. This is a critical issue for artists because where tickets are resold at an exorbitant markup, not a single cent of those additional revenues flow to the artists, not to their crews, not to the venues, not to the local businesses around those venues where you might get dinner or drinks before or after a show supporting that performance. I've heard people sarcastically say, oh, poor Taylor Swift or poor Beyonce, they're not getting any of these markup dollars. But the truth is Taylor and artists at every level, local punk bands, nonprofit productions of the Nutcracker, they employ carpenters, they employ electricians, sound and light tech, caterers, drivers, security, and more. Those folks don't get any of that markup either. Artists want diverse audiences, not just those with the deepest pockets. We further support the ban on speculative tickets, which, as you know, are tickets that a seller does not actually possess. that we just heard about today. These are just people's hopes that they hope to acquire this ticket. Should someone be able to sell something they don't own? We have stories of people buying a ticket on a secondary platform, showing up to a venue and finding out that the ticket isn't real, and that speculation went bust. The venue's forced to figure out how to help this consumer. So you have venues trying to sort this out. The fan is angry. They've spent money. They've traveled. They've made an effort to go to a show, and they are on the outside looking in. They get angry at the artist. They get angry at the venue, not the fact that they bought a fake ticket. Seems obvious, that, again, that if you sell something, you should have something to sell. Speculative ticketing is fundamentally deceptive. It creates false scarcity and funnels access to those with the deepest pockets instead of genuine fans. And the provision in the Resale Act fixes that. We also support the bill's registration and bonding requirements for resellers, because when resellers face real consequences, registration, bonding, potential enforcement, then they're less likely to exploit the system. Accountability and enforcement matters. Washington, D.C.'s status as a cultural capital depends on artists feeling empowered and protected when performing in the district, and fans having access to such performances. If D.C. is to remain a preeminent venue for live entertainment, it is vital that its laws ensure artists and fans are welcome and protected. Thank you for the opportunity for the Music Artists Coalition to testify here today. You all have the chance to be a leader on this issue, so please vote yes in favor of the Resale Amendment Act. Thank you.
Thank you. Now go to Jean Hamza. And Jean, you have the 5 minutes, and then Jess will have 3 because each organization gets only 5, and then the second ones have 3. So, okay, so you get the 5 unless you want to swap.
Okay, thank you very much. And thank you, Councilmember Nadeau, for holding this hearing, and Councilmember Allen for your incredibly hard work making this happen. And Councilmember Henderson for being here. We sure do appreciate it. So my name is Jean Hamza, and I am a resident and homeowner in DC for over 40 years. I've also worked in the live music industry in our city for well over 30 years. When I first started working in the industry, there was no way for someone to buy tickets from the comfort of their home. In the 80s, we had to physically go to the Heck Company or another licensed outlet to purchase tickets for any event we wanted to attend. In 1994, when we wanted to attend the Rolling Stones Voodoo Lounge tour, I had to get up early and stand in line at Commander Salamander's on Wisconsin Avenue to get a number indicating where I would be in line when the tickets actually went on sale. A lot of time and effort invested. This process involved a great deal of time, but the ticket price was the ticket price. For someone to scalp a ticket, someone had to stand in line to get it. But times have changed, and unfortunately, bots don't have to stand in line. I'd like to try to focus a little bit on the customer experience. And I'd like for you to think about the customer experience when they discover that they haven't purchased a real ticket. Aside from the money loss, the extreme disappointment after trying to call the ticket company and getting crickets and trying to think of every way possible to make fake tickets work, they have to leave without seeing the show. And while we empathize and do everything we can to help the customer, in the end, there is nothing we can do. Everyone is left feeling lousy about the situation. So I'd like to share the experience of a few of our customers who can't be here. Lisa Higgins. I have tried to get tickets to a November show since August. The resellers and bots purchase them even before they are on sale through pre-sale in general and raise the price of a ticket that would normally be $60 to $1,200. StubHub is infamous for this kind of pricing, and a lot of times it's a scam and tickets are never emailed to the buyer. I've noticed the show often sells out, but scalpers seem to have plenty of tickets and resell them for a much higher price. For example, the UK artist known as Youngblood made it his mission to sell his tickets for no more than $55 in the DC area and similar prices across the US. However, after the pre-sale, many of my friends are only finding tickets priced between $438 and $1,500 per ticket. StubHub. This seems unfair to both the artist and the fans. This has been going on way too long, and people are using money that they use to pay their mortgage to buy one at a reseller price because they know it is a once-in-a-lifetime chance to see Youngblood, as well as other well-known artists. This has to stop. And then I'd like to share a few data points we have for the last year at just the 930 Club. 9,993 tickets tracked this year listed on resale websites for more than double face value. 390 tickets listed for more than $1,000 each. 606 tickets listed for more than $500 each. 3,472 tickets listed for more than $200 each. Highest price found for a single resale ticket, $11,933. Let's go on vacation, right? Average price for a single resale ticket, $395, and average face value ticket price is $37, okay? Estimated profit leached from the 930 Club, its fans, and its artists by those scalped tickets, assuming that they all sold for the prices that they were listed, $3,949,298.77, nearly $4 million. That's just 930 Club. So council members, this is a consumer issue. Our residents are targeted for tens of thousands of dollars that do not go to the artists they want to support, nor the venue that provides the entertainment. Everyone loses except some company in another state laughing all the way to the bank. Please pass the Resale Act. And in closing, the Resale Act protects fans, artists, and venues. When you vote for this bill, you're voting for small business over speculation, real jobs over bots, and the district's identity as a place where art, commerce, and fairness exist. Thank you very much.
Thank you. Catherine, go ahead.
Thank you, Jean. Thank you, Chairperson Nadeau and council members for the opportunity to testify. I'm Catherine Ferrando, representing Black Cat. And I'm also here as a consumer of tickets and a musician in the city too. At Black Cat since 1993, we have been combating scalpers. And the problem, as Jean described, has only grown exponentially given the changes in technology. And what I really want to focus on today is the price cap and also the enforcement model and reporting requirements. Because while in recent years, honestly, fraudulent tickets, they still happen. And when they happen, they're terrible all around, but it's relatively rare. And it's usually coming from, in our experience, at least at Black Cat, it's usually more likely to be a Craigslist or a Facebook purchase, Facebook marketplace purchase that people know maybe wasn't legit. But at any big show, people are paying hugely overpriced tickets. That's something that is broad and constant, and anytime there's a big show, it happens. And when the show sells out, that's when they really skyrocket. And to some degree, the bots and fighting bots is a little bit of a red herring, because as long as it's legal to charge those excessive amounts of money, they're going to find a way to do it. The big resellers have more money, more resources, more advertising dollars than the local venues will ever have, and they will find a way. And the thing is that the way everybody's been talking about that, the pricing system, and the bands and the clubs really care about the prices. That's one of the most intensive parts of negotiating when we are negotiating as a new show is how much it's going to be. And we have intense negotiations over like $1. Is it going to be $27? Is it going to be $25? And then it all gets blown out of the water when the prices go sky high if the show sells out. And it's important to artists because that's how they develop their fan base. It's how the clubs develop the music scene, and it's how we're all in it for the long haul. We're not trying to make the most money we possibly can out of the consumers. We are trying to develop a scene, develop a nightlife culture, develop the city. And the bands and the clubs both put a lot of effort into choosing those price points. And we can't make them stick unless we have the council's help. And the price caps, we think, are the only way to do that. If the bands wanted to, they could use dynamic pricing and get that extra dollar when they, the excess of prices at the end of when you're selling the last 20% of a show. But they don't want to. They never ask for dynamic pricing. In fact, it's in most of the contracts coming from bands that they will not allow dynamic pricing because they do not want to overcharge their fans.
But then they can't help it because the resellers come in and do it for them. On to the enforcement issue, I think the price cap is the key there too, because while it can be really hard to spot fraudulent tickets or speculative tickets, it's really easy to see the overpriced tickets because they advertise them. It's right out there. It's easy to spot. And so it will be a lot easier to stop. We are concerned somewhat about the method that's in the bill of doing that, where the reporting requirements seem burdensome, both for on DC's end and also on the secondary ticketing market people, because we do want there to be resellers. We don't want to chase small resellers out of the market. We want them to be able to operate so that people can, sell their ticket and back for the original price if they have a babysitter fall through or something. But they can operate under that 10% cap. We talked to Dice, which is a company that works with several local venues, not Black Cat specifically, but other local venues, and they already use a 10% cap. That's what they mark up. When they buy back tickets and resell them, they use a 10% method. So even if, honestly, if the council needs to change that exact price point, we're fine with that. We just want there to be a cap. The cap is the key. And we also think that there should be a better way to capitalize on the fact that you have a built-in enforcement mechanism of all of the bands, the consumers, the venues who will watch those prices and be able to flag for the city when they see prices that have gone over the 10% cap. And we would love there to be, like, instead of the reporting requirement for the resellers, there to be an easy way to report to the enforcers when we see that there has been a violation. We really appreciate the opportunity to be able to advocate for this bill, and we would appreciate it greatly if the council would impose a cap and find a way to actually finally give bands the ability to set the ticket prices where they want to. Thank you.
Thank you very much. And then the final witness for this panel is in the Zoom, and that is Adam Webb.
Hi there. Hi. Thanks for having me. I would like to speak, obviously, in support of the Act, and just also to give you a quick rundown of some of the progress we've made in the UK on this issue. Fanfare campaign came together in 2016. It was founded initially by 4 management companies representing some major UK artists, Arctic Monkeys, Radiohead, Mumford & Sons, One Direction. Back at that time, 2016, our market was in as much a mess as the UK market was. Absolutely zero transparency. Fans exploited on a weekly basis via the big resale sites, particularly Viagogo and also StubHub. And back then, Ticketmaster also operated in the uncapped resale market in the UK. But we did have some light on the horizon, because in 2015, we had a new Consumer Rights Act that came in, which had some very light touch regulation around the resale of tickets, which basically meant if you resold a ticket through a resale platform, you had to supply the original face value, the block, seat and row, any details around the restrictions of the ticket. So some transparency was there, or some requirements for transparency were there. Unfortunately, none of the resale sites were complying with the law, and Fanfare was originally set up to try and change that. As a result of that, we've worked very closely with regulators in the UK, our Competition and Markets Authority, who started a large-scale enforcement investigation back in 2016. As a result of that, Ticketmaster and StubHub, which was owned by eBay at that point, had to sign legal undertakings. Viagogo, who is what you know as StubHub in the US, owned by Eric Baker, who's recently IPO'd, are serially non-compliant with legislation, refused to sign legal undertakings, and were eventually they were served a court order to comply with the law. Ticketmaster eventually moved out of the uncapped resale business in 2018. And finally, as a result of the court order from the CMA, Viagogo were also forced into greater transparency. As a result of that work, we have finally in the UK got a far greater picture, I believe, anywhere in the world about how these markets operate, who is reselling the tickets, and also a kind of an indicator in terms of the large scale fraud and speculative ticketing which goes on in these platforms. I know we're short of time, so I'll just come onto the price cap very, very quickly. Price caps have been widely adopted in many other countries in the world, for instance, Ireland and Australia, we believe very successfully. Fanfare has been advocating for a price cap since late 2023, along with other measures, for instance, preventing Google from directing fans towards unauthorized sites. And we also believe that the industry also has a role as well to better promote capped resale. That's a very, very important element of this. There's two different markets. There's the uncapped, unauthorized black market, which is endemic with fraud. It relies upon large-scale sellers who are breaking the law to acquire tickets and resell those tickets. And on the other side, we have a capped, consumer-friendly market, which is fan-to-fan, not business-to-fan. So that's what we want to promote. The UK government, we believe, is going to introduce price caps very soon. So that, again, we believe we're now on the road to this. What you're going to hear, though, is counter lobbying from clearly these sites. Obviously, StubHub recently IPO'd for an $8 billion valuation. It's slipped to about $6 billion, but it's these are large, well-funded businesses. They'll be arguing that price caps will drive resale offshore and underground and onto unregulated illegal platforms. But the news is that these platforms are already offshore. Fraud is endemic on these platforms, and they are dependent, as I said, on law-breaking suppliers. At the moment, we're under a sort of a lobbying campaign from Viagogo and StubHub in the UK, and they've had one recent report, which is based around by a company called Bradshaw Advisory, which is trying to suggest that countries where a price cap has been introduced, that fraud has gone up by 4 times in those markets. There's absolutely no evidence for this whatsoever. We've spoken to Irish banks, Australian consumer authorities who tell us unequivocally that price caps have made absolutely no difference to fraud. So I just wanted to make those points very clear.
Thank you.
Thanks.
Okay. So we're going to turn to questions for this panel. We also have been joined by our at-large colleague, Councilmember Christina Henderson, who can make an opening statement at the beginning of her round of questions if she chooses to do so. Okay, Ms. Schaefer, you know that Maryland passed a law last year that requires more price transparency and bans speculative ticket sales. What impact have you all seen for shows at the Meriwether Post Pavilion located in Maryland? Push your button, please.
Sorry about that. This is, it's a new law, and we definitely saw some impact with people behaving better at the start. And we're working with the Attorney General to make sure that enforcement occurs going forward.
Great. Thank you for that. Mr. Webb, are there any precautions we can put in place to prevent some of the fraud that others are saying this will cause?
Well, in the UK, we are, as well as the cap, we're also asking for a couple of extra safeguards. I mean, one of the important ones, particularly around speculative ticketing, is to make the resale sites take responsibility for the tickets that are listed. At the moment, there's nothing to stop you on, and again, Viagogo is your StubHub, but there's nothing to stop you listing, 50 tickets that you don't possess and list them speculatively, because those websites don't ask for the receipts. And again, we think that's a really, really important part of this. Again, I can't emphasize enough how large the scale of speculative ticketing, which is fraud, it is on these websites. It's in the interest of the websites themselves because it makes them look flush with tickets, which is very useful if you've got an IPO coming. And also if the touts or the scalpers, I mean, effectively it's risk-free scalping because you don't actually have to buy the tickets. You advertise something you don't possess, someone buys it, and then you fulfill the order. But if they don't fulfill the order, then the platform can fine them. So it's a win-win for the platforms. So we think that liability on the platforms is really, really important in this as well.
Thank you very much. I'm going to actually turn to my colleague, Councilmember Allen, for questions.
Thank you very much, Madam Chair. I was going to start, maybe Audrey, with you. I appreciate you sharing the example of the speculative ticket example with a real show, because I think we've talked about it a lot, but you really kind of just helpfully laid out an example. I just want to make sure I heard it correctly. The show that you described upcoming, tickets have not actually been released to the box office. They have not gone on for sale. And yet I could go onto StubHub or one of the resale platforms right now and find them.
Yes, we pulled this information this morning before 10. I think it was about 8 o'clock in the morning when there wasn't a single ticket for sale. And we grabbed the screenshots of that. And the first pre-sale went on sale today at 10 a.m. So I don't know if what's on there is something that is speculative, that the people don't have the ticket, or it's something that someone got a pre-sale ticket and wants to profit off of it.
But what I heard you describe was you looked at this prior to even the pre-sale opening up.
Yeah, absolutely. I mean, that's how we know it's a
Right.
fake ticket, is
Yeah.
they cannot have a ticket if we don't sell it.
Okay. Obviously, the bill is trying to get at many issues. That's one of them. Selling something you don't actually have in this speculative marketplace. The other, I wanted to go look at the Anthem, for example, for a couple upcoming shows, and looked up Ty Myers. I don't know who Ty Myers is, but sure he's fantastic. But there's no tickets. Went to the Anthem's website, sold out, not available. But guess what happens when I type in Ty Myers Anthem? First link that shows up on a Google search directs me to a resale platform, and then I can find plenty of tickets there. And in fact, for $551 right now.
Yeah.
I don't know if you know off the top of your head what the face value of that show was, but I'm going to guess it wasn't $550.
I don't know any show that we've put on that's had that kind of a face value, but I can find out. The thing that you brought up before too, sorry, it's contagious.
We're just going to get like hot
Listen,
tea somewhere.
I don't know, this topic gets me all choked up, but is that because the ticket scalpers and the predatory resellers and the platforms that host them, the billion-dollar ones, that's been talked about, they don't pay for overhead like we have. They're not paying for our venue, our employees, our licenses, our insurance, the staff of security. They're not paying the band. And so they've got all sorts of money to work with. So they can spend their money on those Google ads. And they, if you say, as you type in the name of the venue and the artist, our link usually comes up on the second page because we have to pay those other people to make the show happen. And they're spending money on Google and lobbyists and PR people.
Yep, absolutely. Ron, is it Mr. Gubitz? Mr. Gubitz. I was talking to an artist and musician last night who shared with me an example. He had a performance not too long ago where face value of the tickets was $40. And he was really frustrated because the show sold out so fast, and he had friends and fans. He was trying to make sure they could have a chance to come in and buy it. And then they all started sending him screenshots, and then he pulled up and showed me all the screenshots of the exact same ticket now being resold for $150, $169, $181. And his friends and fans couldn't afford that. And I asked him, I was like, first off, he was disappointed just about the fact that his own fans couldn't come see his show. But I also said, how much of that markup did you see? And he laughed, of course. I was like, no, we don't see any of that. How common is that, though, for our artists? Like I think that most artists, maybe not everyone, but most artists do have a hand in trying to say, this is what I think the face value of a ticket should be for my fan base, because I want them to see the show. I'm here to perform for them. I want my fans and my community that I've helped build to actually be able to be there for that performance. Is what I heard last night a common experience you've seen from the artists you worked with? And if you could turn push the buttons, the mic comes on.
Thanks. You would think the entertainment folks know how to work the mics. I'd say that it is common, and ultimately what we're when you have these speculative bubbles, I think the artists are saying, well, I mean, first of all, good for them, right? They should book maybe a bigger room next time, or they would be able to charge more, but they don't want to necessarily charge the maximum price per show. They are trying to build a long-term relationship with their fans. They want them to not just come this time, but the next time when they do move to a bigger room, or the next time and the next time. They look at it more as a magazine subscription. You want folks to be return subscribers and continue working and building with that artist. And so they are, not trying to gouge up front. And so I'd say when it does happen, it breaks the artists' hearts, because the people in the room are not necessarily the folks that they want in the room. They want diverse audiences, people who are going to be able to come back. And I think they also, for the sake of the venues and other artists, they want the fans to be able to see multiple shows, right? Not just spending all of the money on one artist. So in terms of the actual data of how common that is, I'd say it's more common than it should be.
Yeah, I appreciate that. I will date myself, but I'm old enough to remember a fairly famous interview clip with Nirvana and Dave Grohl and Kurt Cobain when they were talking about they try to set their price for $17 for a show when they were asked about that a Madonna show is $50. And they just thought that was outrageous. But they actually spent a lot of time talking about how they were intentionally trying to price their ticket at $17, $18 because that's what their fans could pay. And that's what they felt was the fair price for that. Ms. Ferrando, I was going to ask you, I appreciate all your testimony, and I think you hit the nail on the head of why a price cap is so important. There's one other part, though, that we want this to make this work, right? And you talked about having some recommendations about how to improve some of the reporting requirements, and that may go into the weeds a little bit here, but whether you just want to share briefly that or follow up with us to kind of give us some of those requirements, can you just share about why you think that's so important to make sure we get that part right so that this whole thing works?
It's twofold. One, because as a small business owner, I know whenever we have a new reporting requirement, it's hard. And big companies are going to have a staff that can do it, but small guys, if there's little companies that are trying to be in the market as small-time resellers, are not going to be able to comply easily with that kind of data requirement. And I don't think that it's a good use of the city's time and money either, because there's easier ways to enforce it. I think having some specific mechanism where individuals who see violations can report in would be so much more efficient and would give us a chance to police ourselves, which I think we're quite capable of doing. Just on your earlier question too, I would say at Black Cat, any show that has a decent chance of selling out, we're going to see tickets being resold at 100% of those. Anything that's we think might sell out, you're going to see it.
Excellent. And then just real quickly, Mr. Webb, I appreciate you being here and sharing your experience as well. And there was kind of something you talked about around the fact that a resale market's going to happen, right? I buy tickets to a show. Turns out I can't go all of a sudden, and I don't want to just eat the cost. So I'm looking to be able to resell that. There was something the way you talked about this of it transitions the resale, like the legislation like this and a price cap helps transition that resale back to frankly what it used to be, which is the person-to-person resale rather than companies and bots that can just scoop up hundreds of tickets and then create an entire secondary artificial manipulated marketplace that is just driving up the costs. And that's what I kind of heard you describe, is that by using that price cap and moving in that direction, we're making sure it's actually much more back to an actual market where I bought tickets to a show, turns out I can't go any longer, and I want to be able to find somebody who wants to go and resell that, rather than what I will argue is a completely manufactured and artificial marketplace of manufactured scarcity that drives up the costs. Did I hear that right, the way you described that?
Absolutely. I mean, I think you're absolutely right. You've got one side which is trying to create a commodity market, which is effectively they're creating their own demand, and then encouraging you to go and have that demand fulfilled, that artificial demand. But clearly, the easier we make it to resell a ticket, fan to fan, you can get your money back and your fees back, and someone else can go to the show. That's exactly the kind of market we want to see blossom. And again, in the UK, every single major primary ticketing company offers that service, and we have other services. I know Dice was mentioned earlier. We have specialist services like Twickets, Tixel. We've actually got a whole bunch of these, but for those to take root, we have to get rid of this parasitic black market that's stopping that market from evolving.
Okay, thank you. I know I've used my entire 10 minutes, so thank you very much, but I gave the chair time to be able to get back. But thank you, Jean. Thank you, everybody, for your testimony and support here. I'm going to hand it back to the chair now.
Thank you. Yes, I think you prefer me chairing while not coughing on everybody. Now turn to Councilmember Christina Henderson for an opening statement and any questions.
Just real quickly, you had asked a question. Oh, I'm so sorry. On the ticket price, it was $39.50. So.
Awesome. Good afternoon, everyone. Thanks so much, Councilmember Nadeau, for holding this hearing and for allowing me to attend, because I am not actually a member of this committee, but I did co-introduce this legislation. By way of background for folks in terms of this conversation, I am a concert goer. So I won last night. Made it here on time. It's okay. Shout out to Doechii and all the Doechii fans who were there last night.
It was a late night for some of us.
A concert this month. Like, I want to explain to people, my friends get frustrated with me because even some of my colleagues who will say, well, you didn't tell us about such as, no, I shop in the pre-sale because I don't want to deal with the resale issues of, is my ticket real, paying 3 times for it, X, Y, or Z. But I'm also in that group for Mr. Webb, who the next time Beyonce tours for Act 3, I'm going to France because I'm tired of dynamic pricing and all of the other things that kind of come with it. And so for this legislation, for those of us who are actual lovers of artistry and music, and we like to see you in the small venues before you hit Capital One, before you're going to Northwest Stadium and all of these other places, this makes it really difficult for us to be able to do that. A couple of years ago, I did 40 shows in a year. That was like my, let's see if I can make it work, which in DC you can with the number of independent venues and it not break the bank if I have a $15 show or a $25 show, and to be able to do some of that. But so I'm coming at this from a perspective of a fan and a consumer, but also now needing to come at it from the perspective of a policymaker as well. This is an issue that I wish that the federal government would take up. But when I look at the average age of members of Congress, I don't know if this is going to be something that they're able to do because they themselves are not fans in the same way. And dealing with what you have to deal with now, and my staff will tell you, like I block off time on my schedule, usually 30 minutes. I hope I could get through the Ticketmaster process in 30 minutes, but usually that is not, I am not that lucky to kind of make it through that. That's all I have for my opening statement. So David, you can sort of start my questions. I want to start with Mr. Webb. So one of the things that we'll probably hear testimony from later, but already in conversations with other folks, they will say, Ireland has done some of what you guys want to do here. And in Ireland, when they did price caps, it broke the market. You're seeing 4 times more fraudulent behavior and all of these different things. And I wanted to give you an opportunity to respond to that. I know that the UK itself hasn't yet gotten to the point of implementing as well, but what is the experience, I guess, for our friends across the pond?
I mean, I'd like to kind of deconstruct it a bit. I mean, like I say, there's a report that was actually paid for by StubHub International, a firm called Bradshaw Advisory put it together. And this has been the kind of the foundation of an AstroTurf campaign, which has been run by Viagogo and StubHub in the UK, where they've kind of used this research, presented it as independent research, even though they paid for it. And it's based on modeling and it's not based on facts. And the modeling that they've paid for has come up with a very convenient conclusion that fraud has increased 4-fold in Ireland and Australia compared to the UK as a result of price caps. Just really quickly, the facts just do not bear this out. I've spoken to Irish banks who have told me there's been absolutely no increase in social media ticket fraud as a result of the cap. If anything, they tell me that fraud has actually gone down. I've spoken to Australian consumer bodies like Choice, who again have told me there's no correlation between a price cap and social media fraud. If anything, social media fraud is everywhere. We have UK banks have published numerous warnings around shows like Taylor Swift, Oasis, major football tournaments. It's just a fact of life that large scale events lead to social media fraud. There's actually no relationship between that and the cap. The other thing that this lobbying does very conveniently is it doesn't actually acknowledge the existence of a capped resale market. So the choices that they create within their modeling is either StubHub, Viagogo, Vivid Seats, SeatGeek, or Facebook Marketplace. So they basically say that if you close down our websites, everything will transition over to Facebook Marketplace. What we're saying is that actually there's a sort of a consumer to consumer market in the middle, and that's the market, again, as I said before, that we want to see take root and blossom. So again, I think that the modeling that they've produced, they've paid for it. They're paying for spokespeople from bogus consumer organizations to promote those arguments, and they're paying for advertorials in magazines to get those point across. But basically everyone's on the payroll of Viagogo and StubHub.
Okay, thank you for that. I did notice that there was an article in the Rolling Stone UK, and then you scroll down, and then it's sponsored by, which is kind of an interesting approach, because if you're not looking for it, you would miss that part.
Absolutely, and again, it keeps going back to, and again, it's Bradshaw Advisory Research, independent research, and it's like, actually, I made a complaint because when this research was initially published, it made no disclosure about who paid for it. I actually instigated a complaint with the British Polling Council because this is against their rules. They upheld my complaint, and as a result of that, they did right at the bottom of the report saying commissioned by StubHub International. Again, it's just like I say, it's an AstroTurf campaign. It's absolutely bogus, and I think that like I say, I just recommend you go and speak to some Irish banks, go and speak to some Irish venues, to some Australian consumer bodies, and I think you'll find a slightly different view of the world from them.
Okay, thank you. I want to ask a question about speculative tickets. I did meet with StubHub, meet with anybody. We have a conversation, and I appreciate StubHub for sending some recommended changes that they wanted to see to the legislation, as opposed to wholesale control, alt, delete the whole thing. That's not what they sent, I will say. But in the conversation about speculative tickets, and just for context, so I told you I'll go to concerts. So earlier this year, a young Memphis artist by the name of Glorilla was on tour, and her tickets had not gone on sale yet, but literally like days before, you could go on StubHub and somebody was selling the tickets for like $538 general admission. Now, I know the ticket was not, I know I didn't pay $538 and I was seating. One would say, or in the conversation, they would say, well, there are different types of buckets of tickets, which I could, sure, right? Artist pre-sale, Live Nation pre-sale, credit card resale, Verizon has a pre-sale, right? Everybody has a pre-sale, but my own credit card, but that's okay. And so they'll say some of those speculative tickets had been made available from like one of those other buckets of groups of people. How do you distinguish between that?
So when we analyze the ticket behavior every single week, we analyze spec tickets before any of those pre-sales have started to look at what the websites have, just like today with the dance party and the spec tickets there. At 8 o'clock this morning, not a single pre-sale had started. So everything that was on those 4 websites, SeatGeek, Ticket Network, Vivid Seats, and StubHub, those were all speculative. One thing you'll probably hear in a little bit is if Vivid Seats is here, or the people who represent them, they would like to have what they called a concierge service. And that is just a big fat loophole to make spec tickets still legal. They'll say spec tickets with a provision. And
so you need like a note on the bottom.
They
technically
say
don't
that
know this.
they'll notify, they'll disclose it, but all it is just another way to sell a spec ticket. Now, if the cap comes into play here, when the cap comes into play here, people aren't going to need a concierge. They're going to be able to buy their own ticket.
Okay. I worry in terms of, in the same way that we got issues around media literacy. I know for some people, particularly younger fans, they might not have the literacy around looking for these smaller pieces. I'm often surprised when people tell me they bought a ticket off of TikTok. I'm not buying nothing off of TikTok. Even Facebook Marketplace to me is like, are you real? Like,
Yeah.
and I'm gonna meet you in a parking lot because I don't know you, right? With people around type of deal. So it is, that part is just kind of weird to me around the social using social media as a form of commerce in this way. And perhaps we all just need to do a better job of, trust but verify and encouraging people to go to other sites, because I'm not, our third-party sites do have customer service. The problem, I think, and I've seen for fans, is that can your customer service solve my issue that night while I'm standing outside the venue and it is one night only?
I would like to answer that if I may.
Sure.
Based on experiences of having stood at our box offices. And I recommend anybody who's going to be opposing this bill, come hang out with us at a show like last night or any night where it's a very popular show, because people do come with fake tickets. And if it's a sold out show, we cannot let them in because of the law. They will try to call whoever it is that they got their ticket from. And a lot of them don't have customer service that are 24 hours. If they do, StubHub will say, oh, they're very proud that they give 100% back to the ticket fan.
But I missed the
turned
concept.
away. However, that doesn't make the fan whole. They drove there or they flew there. They have a hotel or a babysitter or a Uber to get there. The cost of the ticket is just part of it. And last thing I'll say is that StubHub will charge, we'll give the face value of the ticket, but they'll charge the person who sold the ticket 200%. So StubHub, I believe, is still pocketing 100% of that ticket price themselves. So it's like another revenue source for them.
Okay, really quickly, as I'm running out of time. In addition to concerts, I go to sporting events as well. Sporting is feeling is a little bit different, right? With baseball, I got a lot of opportunities to see the Washington Nationals. So if I missed a game, it's not going to kill me.
And it's on TV.
Yeah, and they're not great this year either. But this happened with like the US Open, for instance, this year, right? So you watch the US Open, huge sporting event, the entire lower bowl is empty. Now, you got people who are up in the 400 levels, and I've paid, they've paid double for the 400 level tickets, which I think are originally priced like $50. And then the 100 level is empty, but all the bots bought them. So, or other groups or other different types of things. Nonetheless, why not do this also for sporting? Because that's going to be a question that comes up as well. And I don't know if, Audrey, if you want to give some.
What I would say is, we know concerts. Sports is a whole other industry. And so I can't really speak to that. That would be up to the council to decide if they want to make any regulations pertaining that too. But it seems like the biggest issue, as far as I can tell, are concerts.
Okay, thank you. Thank you, Councilmember Nadeau.
Thank you so much to this panel. Our next panel includes Jess Scher from the 930 Club, Kareem Karefa with the Lincoln Theater, Jake Diamond, Union Stage Presents, and Dave Cooper, venue manager at the Hamilton Live. Please come forward and be seated. Mm-hmm. Okay, I'm going to add one person to the panel because we have a lot of people today and we want to make sure every seat is filled here. So we will include Stephen Parker, Executive Director of the National Independent Venue Association. All Okay, beginning with Jess Shear.
Hi, and thank you for the opportunity to speak today. My name is Jess Shear. I am the ticketing director for IMP, and I have been working in box offices in DC and Maryland for 11 years. I see firsthand every day how bots and professional scalpers affect fans' ability to go to a concert from the first moment a show goes on sale to the night of the show. I can say for a fact that at the box office, most of our patron interactions aren't just handing out will call or guest list. They're helping fans who got screwed over by resellers. Back in May, at one of 2 sold-out Megan Moroney concerts at the Anthem, I assisted a mother and her teenage daughter who traveled from North Carolina with tickets they bought third party. The face value of these tickets was $49.50 each, but they paid over $1,500 a ticket, only to find out at the door that the tickets were fake. There simply is no argument that someone upcharging $1,450.50 for a concert ticket, real or fake, is not doing something morally wrong, that is profiting off a product that is not yours. When we encounter these poor fans nightly, we're happy to help. We all got into this industry to get music lovers like ourselves into concerts, whether they bought real tickets or not, through us or through a scalper. And even on sold out shows, we do everything to make sure that if someone bought a fake ticket, we find a way to get them in the door. I will call my friends that bought tickets and ask if they're coming. I'll call our owner and see if he's coming. Whose tickets can I give to this poor girl that got screwed over? We're not just kicking people out. Spending our time and our energy cleaning up the mess left behind by scalpers, we're always going to be at least a step behind scalpers as they come up with new ways to get around security measures. You may be familiar with queuing in a waiting room to buy tickets the moment a ticket goes on sale. Seeing yourself as number 10,000 in line for a venue you know can't sell that many tickets. On our end, we see all of those tickets get carted immediately, but not actually convert to real sales. These are bots, they're not fans, or else they would have actually purchased the tickets. Instead, they tie up all of the tickets in carts so that to the real fans, it looks like the show is sold out. So then the real fans go to a third-party site where the speculative or fake tickets are already posted for sale. Then, 15 minutes later, all of the tickets on our site get dropped out of carts. At that point, the fans have already gone to these third-party sites and bought tickets that may or may not be real, where under the current law, they will be at a huge markup. And while we're constantly coming up with new solutions and security measures to ensure that the tickets go directly to fans and not to scalpers, we are outnumbered in resources. Scalpers only have to worry about buying and reselling. They're not putting time and energy into running a venue, putting shows on sale, and helping fans get in the door every night. I urge the council to pass the Resale Act. This bill is our strongest effort to curb scalping by cutting profitability. Putting tickets directly into the hands of fans is imperative protecting live music. Thank you.
Thank you very much. Kareem Khalifa is not here. Okay. Jake Diamond.
Hey, everyone. Thank you so much for listening in on this bill. And yeah, my name is Jake Diamond. I'm the marketing director for Union Stage Presents. We're the operators of Union Stage, Pearl Street Warehouse, and the Howard Theater, and the exclusive promoters of the Plaza Stage, the Miracle Theater, and Capitol Turnaround. I've been involved in nearly every side of the live event experience. I've played in multiple bands, I've attended countless concerts, and I've done nearly every job one can do in a concert venue. From all my experience in all these vantage points, the Resale Act is needed. This bill is essential when it comes to consumer protections for fans in Washington, D.C. Scalpers and speculative ticketing practices have an adverse effect on the entire experience and ecosystem, taking hard-earned dollars from fans and negatively affecting the bottom line of venues. For example, Union Stage has a show tomorrow night with an artist named K1. And on the secondary market, tickets are listed as high as $2,484 for a 500-cap venue. There's an additional $611 in fees on top of that. The all-in price of $3,095 is insane, and none of that goes to the venue or the artist. And those tickets were initially listed at $25. And we don't even know if the person selling these tickets actually has them. This type of predatory secondary market behavior also makes it incredibly difficult for day-to-day venue operations. When a scalper sells a ticket multiple times and someone tries to use said ticket, that requires our manager on duty to leave whatever task they are doing within the operations of our venue to then go help a fan who, like Jess said, like is upset. They spent a lot of money. They can't get into the show. And that takes our staff away from what their job is of running the show. On the speculative front, we have a show that announced on Monday, very similar to Audrey's example of the last dinner party. We have a show with Machine Girl. Tickets were made available this morning at 10 a.m. There were tickets listed on Monday for $359. Our tickets were on sale for $44.77, and they weren't made available until this morning. Sorry, my iPad is messed up. These affect our drop counts too. You know, our drop counts are our attendance. If the scalpers scoop up our inventory and then price out the fan base, that negatively impacts the attendance of the show, which subsequently hurts both the artist and the venue with their ancillary revenue streams like bar sales and merch sales. The Resale Act allows consumer protections that prevent these negative effects of the secondary market with a price cap so that even if someone is selling tickets on the secondary market, fans will not be price gouged. It requires transparency from these sellers with registration on if they are selling secondary tickets in bulk so fans know who they are buying from. The Resale Act is a step forward in ticketing policy because it protects fans from being taken advantage of, and fans are the lifeblood of the live music ecosystem. I urge you guys, the council, to pass this bill, and I thank you for the time.
Thank you very much. Dave Cooper?
Distinguished members, I'm here today to ask for your consideration to rule in favor of Bill 26224, Resale Act restricting egregious scalping against live entertainment. In addition to my position as venue manager handling ticketing marketing for the Hamilton Live, I've also, like Jake, played music for 10 years, and since then have worked for 5 music venues in the DC area. And let me tell you, when it comes to reselling, I've heard it all and have seen the fans in tears overpaying, which creates blames for our local businesses. For the venue who's doing everything to make music affordable for its fans, we use Eventum, previously C-Tickets, so our fees are as low as possible. But secondaries are exploiting that to bring in even more profit while digging into inventory and decreasing the drop count or percentage of purchasers who are scanned in, which affects our food and beverage numbers. While we forecast for this, we need staff to be planned for anything. So these companies are making enormous profits and leaving a huge mess of operational issues behind for everyone else, even without proof that they even possess the tickets. Imagine treating the experience and connection like selling stock, yet you sell a stock you don't possess or own. And this is the human experience. Passing this gold standard legislation will protect consumers, artists, local venues, and surrounding businesses when our economy needs it most. Currently, practically every event of ours is listed on a secondary market site, and just imagine the confusion, potential animosity from customers, and financial impact that can cause. What business wants to start off with a new guest on the wrong foot? Why should businesses have to spend extra time on combating this, reworking floor plans so these outside parties can take money out of the DC economy? Businesses need repeat business, and our regulars can come multiple times in a week, but scalping threatens that way of life. Not installing a price cap leads to egregious scalping, and I'd like to share some examples. Emmylou Harris throws a puppy charity every year at our venue, and our most expensive ticket, just over $100, and is reselling for $269. The reseller is currently making more than the puppies. Reselling a $35 ticket to Rare Essence, the flag bearers of DC's own music genre, go-go, for $292, 8 times the MSRP. A New Year's Eve event brings the spirit of New Orleans to DC with Rebirth Brass Band, MSRP $48 to $95, currently selling for $181, although tickets are still on sale. New Year's Eve is a big event for businesses. Everyone can clearly see the problem there. Oyster Riot is an annual event we do in the Ebbett Atrium. Our $225 tickets for that event, it's an all-inclusive, all-you-can-drink oyster event, are selling for over $600. This event employs so many people, from those with our company and up to the shuckers we hire to open the oysters. Selling something that is not possessed is really dictating the market through deception. Resellers are boosting their listings because they're competing with the venues and often spending money on advertising to drive their listings to the top of Google. Most people use Google to search for shows, so this is a major funnel and really is essentially fraud because those consumers want to buy tickets from us. They obviously want to buy the lowest prices, but they're being shown something that looks like the ticket, and we are selling one for far cheaper. So what are the potential downturns of price caps? Fans paying less, tickets being sold on Facebook Marketplace, people already get messaged and scammed on their platform. Shortages, we're dealing with that on popular shows now. If the artist wanted tickets to their shows sold for these high prices, that's how they would sell them. Reduced quality, it's a digital ticket. Placing a cap is necessary. In fact, it's the whole point. Saying that potential violators will not abide by potential regulation is never a reason not to do it. People need this right now. They need a reasonably priced night out, an experience that serves as a distraction, and that is what we provide. Help us send a message that some things, including experiences, should not be exploited by outsiders, and that those individuals making money do not take precedent over participating in the community of Washington, D.C. Thank you for your time.
Thank you very much.
Thank you. Thank you, Chair Nadeau. Thank you, Councilmember Allen, and all of council for moving this bill forward. I represent the National Independent Venue Association. We are the small stages in every community in the country. We are promoters, we are venues, we are festivals, we are small businesses, and we're nonprofits. The two biggest threats to their continued existence are Live Nation and Ticketmaster and an unchecked resale market. This bill addresses both of those threats. Live Nation is one of the largest industrial scalpers in the world. They are operating in more countries. Their resale platform is operating in more countries than many, if not all, of the resale platforms that are here to testify against this bill today. Last month, we found out in a lawsuit from the Federal Trade Commission just how in bed with scalpers Live Nation and Ticketmaster are. We saw evidence from the Federal Trade Commission that shows that they were opening their digital backdoor to scalpers and letting them have access to tickets prior to any on sale, in many cases without the venue who is selling them's knowledge. They were ignoring ticket limits, allowing scalpers to buy them up. They were working with scalpers and their developers to create an API to allow scalpers to know exactly how many tickets Ticketmaster had for sale, so that they could take advantage of that number and get as many tickets as possible. Every single resale platform and scalper that had access to those tickets benefited from Live Nation's actions. The FTC said that Live Nation, if they had actually enforced the rules and not done those things, could have lost $5 billion. But instead, they ignored the rules, and ultimately, it's consumers that paid the price. Earlier this week, we spoke up against Live Nation because they were trying to tell untruths to Congress. And we called on them to voluntarily place a cap on their resale. It was NEVA who spoke up and asked them to do that. The resale platforms were silent. The scalpers were silent. StubHub benefits from what Live Nation does in their partnership with scalpers. We know from the FTC lawsuit that allegedly the resale platforms and scalpers were in bed with Live Nation. This is not about competition for StubHub and the resale platforms that are here today, because the biggest competitors to Live Nation are the venues that aren't Live Nation. They are the ticketing companies, of which there are 16 that are not owned by Ticketmaster that operate here, partnering with venues. Ultimately, Live Nation is the problem, but StubHub is here because of their shareholders. Tickets above face value constitute 82% of StubHub's ticket revenue, based on publicly available data that they provided in a report to the federal government and to numbers they provided to council. The average price of those tickets based on publicly available data, based on analysis we did, is $885 when they are sold above face value. Resale and StubHub and resale and all of the scalpers are all a threat. And the council can follow the model of your attorney general. Your attorney general sued Live Nation alongside the U.S. Department of Justice. And they also sued StubHub. You can take care of both threats through this bill. This does not help one over the other. This isn't about fans for resale platforms and the quote unquote fan organizations that are here today funded by them. This is about their stock price. Ultimately, we would encourage you to listen to the small businesses and nonprofits that are here. A price cap has worked in nearly 10 European countries. It has worked in Australia. Companies like Twickets and others have come in and operated under a price cap. Ultimately, the small businesses and nonprofits that are here before you today, the artists that are here before you today are asking you to take action because they may not be here a year from now or 2 years from now. Last week, my organization released a report that showed that 60% of independent stages in DC were not profitable. Part of that is the scalper problem. Part of that is the resale platform. And ultimately, businesses will close without action by this council. Artists will move away. And ultimately, StubHub and all the other resale platforms are not going to replace that. They're going to move on to the next venue. They're going to move on to the next show. And they're going to move on to the next city, extracting until it's all gone. Thank you for working to pass the Resale Act.
Thank you.
I'm going to turn now to my colleague from Ward 6 for a round of questions.
Thank you very much. I'm going to try not to use my full 10 minutes because I know we have a lot of witnesses today and I want to try to keep us on track. So to our venue representatives, thank you all very much for coming to share kind of just what you've seen every day, gut-wrenching stories about, you know, a fraudulent ticket and the ramifications that has. They're not on the witness list, but they're submitting testimony. But I was also struck because we've heard a lot from our music and performance venue spaces. Last night, we actually heard from Ford's Theater, nonprofit theater spaces, who reached out and said, "Oh my gosh, like we so strongly support this bill because for Ford's Theater, for example, every season around the holidays they do a Christmas Carol. It's a big thing they do, and they have, I guess, not advertised this, but they lose thousands and thousands and thousands of dollars from these practices and from the resale and from the speculative tickets, and they very much want to see this passed. So for the public out there, I want them to understand how pervasive this is, because you may be thinking, you know, the Anthem or Black Cat. I'm trying to think about it from my artist and concert venue. This impacts our nonprofit theaters. This impacts everybody. And so it really is quite broad in that. Mr. Parker, I wanted to ask you, I appreciate the way you outline a little bit of the Live Nation conversation. I mean, listen, there is a truck driving around this building all day. I mean, probably the worst investment you could make, but somebody told them to do it. And they're driving a truck around saying that this legislation is just a handout to Ticketmaster and Live Nation. I mean, they're competing for space with criticism of, I think, the president of China and everything, these digital trucks that drive around. Not worth the money, but that's the narrative that some folks are trying to create, right? And I think they're doing because they're trying to protect their own interests. It's a false choice of what's actually they're trying to concoct with this. But you laid this out a bit, but I mean, why is it not something that's just advantageous for Live Nation and Ticketmaster? Why would you say this isn't something that's just is really great for them, but bad for everybody else?
That truck and the really expensive lobbyists and PR firms that are in this room working for resale platforms shows what we're all up against, including you all. Multi-billion-dollar budgets, billion-dollar ad budgets based on StubHub's filing with the federal government prior to going public shows what we're up against. They are able to use those dollars on PR firms, on lobbyists, and on advertising to make them look fully legitimate. And maybe there are some transactions on those platforms that are under face value based on their own numbers, 80%. But we know that based on just sheer math of what they filed with the federal government that transparently talks about their revenues, that they're making a lot of money. More than 80% of their revenue is made from tickets sold above face value. And so ultimately, what you said is true. It's a false choice. But the bigger issue is that they are using Live Nation as the boogeyman. Live Nation is bad. But some of the things that happen on resale platforms every day are also bad. There is no accountability to verify whether tickets actually exist when someone posts them on their resale website. There is no way on eBay, I can go and I can see a seller's rating. I can go and see where they're at. I can go and see exactly where their location is and everybody who's done business with them. We don't know who we're buying from when we go on StubHub, when we go into Event Ticket Center, when we go on Vivid Seats. That's a problem. The lack of transparency in this industry is a problem. And ultimately, Live Nation also does the same thing. Live Nation also, based on the FTC's estimates, could lose $5 billion if they started selling just at face value. This hurts both of them, but in the end, this isn't about hurting any organization or sector. This is about protecting consumers and protecting the small businesses and artists that put on shows every single night and take on all the risk. They make sheer profit on every single ticket sale. We are trying to keep our doors open. And that's the difference between us, and that's the difference between Live Nation, StubHub, Vivid Seats, and all the resale platforms and scalpers that you'll hear from today.
Yeah, I appreciate it. I do think, definitely as I've heard and talked with artists and venues, and what I don't think it's mentioned enough either are all the folks that actually go into the production of all of these shows never see a penny on the price gouging and the marked up prices, right? I do want to note that I've sat down with representatives from StubHub, from SeatGeek to hear their concerns around it. And to their credit, there actually are elements of the bill that they have said, hey, we support some of this. And so I appreciate that. I think I'm never going to hear them say, though, that they're going to support a price cap. And I think that's going to be a sticking point that there's no massaging that one, that I think we're going to hear from those companies that say, just pick a different number and we'd be okay with it. And I'm really struck again by what we see from the gentleman who testified on the earlier panel around the nature of what happens here. When you can just charge anything, when there's no price cap on it, that creates a false market. It's not a true market. It creates a false market where I can go in and just scoop up all of the tickets through these different platforms and then be able to control the volume of tickets. I can create scarcity. I can manipulate the market over and over again. And all of us, I'm going to assume, never want to see fraud. And I will call a speculative ticket fraud, but I also don't want to see somebody selling something that they don't actually have, right? And harming that mom and daughter who want to be able to come see a show. Nobody in this room wants to see that. I'm going to go ahead and just treat that as a basic assumption for everybody, right? But I think that we actually will do better about combating fraud, which existed before a SeatGeek and a StubHub and a Vivid Seats ever existed, and fraud will exist after as well. But when we disincentivize that ability to just go scoop up hundreds of tickets at once, I don't see that bot and scalper going onto Facebook Marketplace or to Craigslist to sell 200 tickets. Folks go on to do individual sales, and that's what I think we would likely see. Again, limited to that. I also think, as I've talked to a few businesses around this, especially in the last couple of months, when we talk about a price cap and what's the number, what should the number be, what should it not be, for most hardworking businesses in DC, if I came to them and told them, listen, I'm going to tell you, you can't make a profit more than 10% this year. Most of them who are struggling to make a 1, a 2, a 3% profit, 10%, if I can guarantee you a 10% profit in return every single year, most of our small businesses would take that deal in a heartbeat. Again, the profitability of these venues is important. And I think that, again, you outlined very well. These venues, they don't put the show on. They're not the artists. They're not paying the staff. They are merely a platform that is just scooping up, and it is pure profit. And they figured out how to do it. But it's everybody else who has to pay the price. And that's what we're trying to fix here.
All right, really quickly. I think StubHub in their one pager that they provided to you made the best case for why a 10% price cap is the best solution. And that is if 80% of the tickets that are sold are under $100, it seems to me like most of their business will be fine. So I don't know why they're not supporting a price cap, given the evidence that they presented to council.
Yep. All right. Thank you very much. Thank you, Madam Chair.
Thank you, Councilmember. Okay, Mr. Parker, you mentioned Twickets and these other platforms that operate with their own caps or in countries with caps. Do they have the same type of fraud protections or refund guarantees as platforms like StubHub and SeatGeek?
I can't speak to all of them, but the ones that I'm most familiar with are Twickets and Tixel. who-
Sure.
Well, you'll hear from later today.
Okay.
And they do. And Tixel actually just expanded to the US and they've actually imposed a voluntary price cap on resale that they're currently operating under and able to do well under here in the US. I think that I was on with a lot of my European counterparts yesterday morning. Every single country from Estonia to France to Germany, all were operating under resale price caps. And all of them talked about a platform that's going quite well for them. The fans are happy with it. The company that runs it is happy with it. There are fraud guarantees on it, and ultimately they are operating across country lines in the EU. So I think we are hearing from our counterparts across the world that this is possible. It is possible for safe, fair resale platforms, not just one, but many, to come in and do this well and operate under a price cap. And I think, we need to look more to those examples like Twickets, like Tixel, like TicketSwap, who are doing well in terms of their business.
Thank you very much. Thank you all so much for your testimony. Appreciate it. Okay. We're, again, trying to fill all 4 seats, but we didn't want to split up StubHub and SeatGeek. So I'm moving someone up on this next panel. So everybody listen for your names and be ready for anything. Okay, panel 3 includes Kokai Walker, the Recording Academy, Kevin Erickson, Director of the Future of Music Coalition, Edgardo Malag, President of the Washington, D.C. Federation of Musicians, and Rowan Ghosh, organizer with AFM Local 161-710. Uh-oh, do I need one more? Okay, and we will also include Kendall Gilvar from Fix the Ticks Coalition. About great. We have our 4. So we will go first with Kokai.
Good afternoon, Councilperson Nadeau, council members. My name is Kokai. I'm a Grammy-nominated artist, Guggenheim Fellow, lifelong Washingtonian, born and raised off South Capitol in the little sliver of Southwest on the Southeast side, and at present a Ward 7 resident who grew up on Junkyard and Chuck Brown and now plays hundreds of shows and festivals across the world. From international festivals to hole-in-the-wall clubs, the one consistent thing, no matter what language the audience speaks, after there's interest in the music that we play, is how much are tickets? And depending on who it is there a guest list? I usually speak with the promoter, my manager, or the venue regarding guest lists, so I'm here to speak with you about the tickets and my strong support of the Resale Amendment Act. And I want to thank Councilmember Allen and the co-sponsors for introducing this bill and you for your time. Because time, even if reclaimed, is the only thing we can't get back. I'm here to advocate on behalf of artists and friends, and as a Recording Academy governor, I know that the Recording Academy, or the Grammy folks, as you may know them, have been pushing for transparency and ticketing for a while, for both the artists that they care for and for fans. And I'm leaning in on the word transparency because if both sides don't know where the money's going, who does? I'm an artist and a fan. I've stood in actual lines for shows and have been in these digital lines where when I started with the ticket advertised at $45, when I click checkout, suddenly it's $82. I'm hit with processing fees, convenience fees, delivery fees, and at this point, I'm wondering if there's a your internet or your fingers are too slow fee. This isn't just annoying, it's deceptive. When resellers swoop in and buy up all the tickets only to flip them for 3, 5, or 10 times the price, it creates the illusion that the artists are the ones cashing in. But let me be real clear, we are not. My fee stays the same. The booker gets a cut, the ticketer gets a cut, the venue gets the bar and concessions. And by the time everybody's done slicing the pie, what's left is the artist's fee. And that fee has been locked in months before tickets even happen. Everything associated with the ticket after that, that money's going to someone who didn't play a note, write a lyric, didn't set up a mic stand, or had to deal with their parents telling them to have a fallback plan to get a real job, and years of therapy to reconcile those old traumas. But that's another meeting. I want to be clear, this isn't just about money or price caps, it's a both and issue. Because it's both about the aforementioned and it's about messing with that relationship between my work as an artist and any potential new or longtime fan. I've had folks come up to me like, Coke, I love your music, but why are these tickets $300? And I'm standing there thinking, when did these tickets become $300? And I wish I knew that these tickets were $300 and now I got to go holler at somebody. The deeper issue that is happening is that people are leveraging love. The love fans have for the music, the love I have for the fans and our connection. That's sacred, and that's something we're not really supposed to play with. I'm supporting this act because it tackles the messy entanglements head on. It makes ticketing transparent, and transparency is key, specifically when we talk about all-in pricing, which helps people know exactly what they're paying for. When the fees start piling up, they know exactly whose pocket to watch. It bans speculative tickets, meaning no more people selling seats they don't have, and it caps the resale price at 10% above the face value. That's fair, and I get it because plans change. Folks need to resell sometimes, but nobody should be running a low-key Ponzi scheme and a Wall Street hustle off a Rico Nasty, Oh He Dead, or Backyard ticket. I've spent over 30 years performing, collaborating, teaching, and traveling, and I've seen how music brings people together. But I've also seen how predatory tickets drive them apart when that kid is calling their parents to give up some more money because the better seat that they could have got online at the beginning and is up close, they can't afford anymore. And because a reseller bought up the front rows to sell to the highest bidder. So in desperation, they're on the phone with their parents. That's playing with their love. It's about watching people get Beyonce fresh, boots, cowboy hats, and clear bags standing outside the venue in tears when the scan ticket that they purchased online through the reseller is non-existent or fake. That's playing with love. This bill is about protecting that love, restoring that trust, making sure that when people spend their hard-earned money to see an artist they love, that love isn't exploited. With nebulous processing fees, fees for typing too slow, or astronomical fees based upon people being desperate to see the artist they love. So yes, to some, this might sound like a technical issue about fees and percentages. To others, it's about free market and supply. But for artists and folks that have to answer to our supporters, it's about respect and relationships and respect for the artists, the fans, and for the culture that keeps the city alive. So as a council, I know you need action items. So let's have some action and approve this bill. Our neighbors in Maryland have already passed a similar bill, and we should be right there because it's 3 stars, 2 bars forever. Thank you for your time and for taking steps to make sure that the love between artists and audiences, the real economy of live music, can't be bought, flipped, or resold. And I'm available for any questions.
Thank you very much. Kevin Erickson?
Hi, so the DC music community's emphasis on treating fans well, treating them as partners in creating this live music experience is one of its greatest gifts to the broader music scene and to the world. And so with Future of Music Coalition, we work to put that into practice as we work for artists to have a voice on the issues that impact them. You know, like that's why we've been one of the most aggressive advocates for regulating resale, but also for breaking up Ticketmaster. Too often these policy debates have been framed as a choice with a false choice with Live Nation on one side and the predatory resale industry on the other side, both pointing fingers at each other. The journalist Andy Cush has described this as a Godzilla versus King Kong battle. And he points out just because the 2 monsters are fighting doesn't mean that one of them is the good guy. We think of the effort to fix ticketing as 2 distinct pieces which together add up to a complementary and holistic public policy approach. You have market regulation, rules of the road that apply to every firm to address potentially harmful practices. That's what this bill is about. It's a good bill that reflects best practices. And then the other piece is about the structural, the competition issues, the harms that follow from consolidated ownership, which is what the Department of Justice is seeking to address in its antitrust lawsuit, which we fought hard to make happen. Assistant Attorney General John Cantor was responsible for bringing that antitrust suit forward, and in his farewell speech last year, he warned, All over the world, money from powerful actors is finding its way into the academic and expert communities. This insidious influence has contributed to the decline of our intellectual infrastructure. He warned that the problem of paid influencers posing as neutral observers, and we are going to see that problem in full force today. And even well-meaning folks can get duped. So there's a range of bad arguments I want to warn you about. Hear about people claiming that resale price caps result in fraud. Just hasn't been the international experiences in countries like Belgium, Denmark, France, Italy, Poland, et cetera. You'll hear claims that resale price caps entrench Ticketmaster's monopoly or conflict with the DOJ case, which, its high market margin ticket business subsidizes the lower margin concert promotion business, not the other way around. You'll hear claims that resale saves consumers money. Okay, so first, if a consumer is paying less than the face price on a ticket, it's usually the product of a broker losing money via miscalculation. They thought that they could resell it for more than they paid, but they misjudged the demand. If brokers collectively saved consumers more money than they charge in markups, they would, of course, go out of business. Secondly, it's worth interrogating the specific data offered in support of their claims of lower prices. Typically, they tally the tickets sold below face value and offer a number that they claim represents total savings, but they don't include this in this count the many tickets sold above face value. In other words, they count tickets where fans spend less, but not the tickets where fans spend more, and then present it as if this is net savings. The UK's Advertising Standards Authority recently found that StubHub was misleading UK consumers about how much of its inventory is sold below face value, and so policymakers need to be careful not to be similarly deceived. You'll see resellers saying that they're the only source of competition in the ticketing market. Of course, above face value resale sites don't really compete with any primary seller in ways that serve the public good. Rather, they compete with fans for inventory using whatever technology is available to them to acquire those tickets before real fans get a chance. And then they use their advertising budgets and various deceptive practices to reach fans online ahead of the actual venue and search results. They're effectively competing to efficiently siphon the wealth to investors and brokers and big tech away from local businesses and nonprofits and away from artists and other live music workers. And by the way, we stand in solidarity with workers unionizing at IMP. You will hear calls to weaken some of the proposed fee transparency provisions to align with the FTC rule. I urge you to resist this. What they're asking for is less information presented to consumers. You will hear claims that resale marketplace fees fund fraud prevention and customer support. Well, we know from StubHub's IPO filing that they spend 14 times as much on marketing as they do in operations and support, and much of that goes to Google and Meta ads to get consumers before the actual presenter. I am struck by the cynicism and the cruelty of some of these groups, like Chamber of Progress and like whoever is running that anonymous AstroTurf campaign, of accusing the small businesses and artists and nonprofits behind this bill of carrying water for Ticketmaster, saying this is a Ticketmaster bill. These are people in my community locally and in the broader community of touring musicians who are the most getting crushed by Live Nation right now. And some of whom have spoken out against Ticketmaster at significant personal risk. It is profoundly dishonest, and I hope the council will see through it and that these lobbyist guys will reconsider the life choices that brought them here.
Thank you.
Thanks.
Thank you. Edgardo Malag? It's not.
Sorry, Ed Malaga is not here, but my name is Roheen. I'm speaking on behalf of the DC local of the American Federation of Musicians. Should I go ahead?
Very good. Thank you.
Perfect. Hi, my name is Roheen Ghosh. Thank you so much for bringing up this bill and for holding this hearing today. The DC local, the American Federation of Musicians, we represent over 1,400 musicians, mostly in live music in DC and the surrounding community. Our members are the backbone of the beautiful culture of live music that we have in our community here. And that's really what I want to talk about here today, is that the work that artists are doing here is the work of building community. And that is something that is acutely threatened by these exploitative practices that we're seeing, the price gouging and the fake tickets and the fraud that we are seeing done by these outside entities that have had nothing to do with the actual production of the music and of the performance arts that we are seeing in the community here. The companies that are making these massive profits, they are taking money that audiences are paying, that should be going towards the people who are actually behind the performances that they're seeing, whether that's musicians, that's our stagehands, food service workers, like the ones who are now standing up at IMP. Behind all of those artists, those workers that are making this art scene happen here, the exorbitant markup prices that audience members are paying is not going to them, it's going to these out-of-city entities that are gobbling it up and leaving, very little of what they're making for people who are actually in our community making this scene run. And the way that threatens our community here is what speakers previous have described. It makes the experience of patronizing the arts a worse experience for audience members. And that is a serious threat to arts workers who are very precarious in the work that they do. When we see audience members turned off of attending live performances, struggling to attend as many performances as they would like to, especially as we're seeing a struggling economy in DC where we want more people out going to performances, but people are having to stretch their incomes more. When the prices that people are paying to attend performances are so marked up by entities that, again, have nothing to do with putting these performances on, that is a huge threat to artists, to audiences, and to our entire arts community that we have built together in the city. So that is why the members of the American Federation of Musicians are local here in DC. We urge you to move this legislation forward. Our members are really, really struggling with the impacts of seeing these huge markups on ticket prices, seeing the fraud that's happening. And we really urge the council to move this legislation forward, protect artists, protect consumers, and protect the arts community that we've built here in the city. Thank you.
Thank you very much. Kendall Gilvar.
Hi, good afternoon. Thank you very much, Chairwoman Nadeau and members of the committee. My name is Kendall Gilvar. First and foremost, I'm a DC resident, shout out Northeast. I'm also here on behalf of the Fix the Ticks Coalition, which is a broad alliance of really the folks who put on all the work to put on shows across the country. We have members including Universal Music Group, the Recording Industry Association of America, APAP, the Recording Academy, SAG-AFTRA, as well as hundreds of independent venues, artists, and fan groups. Together, we represent hundreds of thousands of artists, music workers, and fans nationwide, including thousands in DC who depend on a fair and trustworthy ticket marketplace. The Resale Act, as you've heard, is a common sense pro-consumer measure that will protect DC fans, artists, and venues from price gouging, fake tickets, and deceptive resale practices. It placed a very reasonable 10% cap on resale prices, not to block resale, but to block exploitation. And we actually know that this model works in the United States because Maine just passed a very similar, almost identical piece of legislation just a few weeks ago. It went into effect last month, and StubHub itself actually published a public statement on September 23rd titled New Maine Ticket Resale Law, What Buyers and Resellers Need to Know. In their own words, StubHub says that the law places a limit on the resale price of event tickets, capping resale at no more than 10% above original total price paid. StubHub goes on in that brief to say that the resellers must confirm that their listings comply before posting it, and that there is now a confirmation requirement on its website and app to enforce this. They know that compliance and communication to sellers is their responsibility, and they've started to build a mechanism in Maine to enforce it because they have to. And it's already working. In Maine, according to the Maine Attorney General's office, in just the first few weeks of this law being into effect, StubHub has been named in 5 of 8 official consumer complaints filed over potential violations, more than any other platform. That's more than 60% of all reported issues in Maine tied directly to StubHub so far. This is exactly why the platform and ones like it are fighting so hard against this legislation in DC. They don't want other states or cities or localities to hold them accountable the way that Maine has. And I'm encouraging you today to just do that. You'll hear from opposition from groups calling themselves consumer advocates, but according to public records, public disclosures, and financial filings that we plan to submit, these groups are funded by corporate secondary ticket resale platforms. I'd like to call them out so everybody understands. Organizations like the National Consumers League, Fan Freedom Project, Protect Tickets Rights, Sports Fans Coalition, Chamber of Progress, unfortunately list goes on to the Coalition for Ticket Fairness. All of these organizations receive direct or indirect financial support from StubHub, Vivid Seats, or the National Association of Ticket Brokers. These are not independent voices. These are industry-backed lobbying arms dressed up as consumer advocates today, and they are opposing this bill because their funders make money, so much money, off of the very price gouging and deceptive listings that this bill would come after. If the Resale Act passes, these companies face real oversight for the first time, and I think they know it. I'll add as a DC resident that every single inflated resale ticket is not just a bad deal for a fan like me, it's a loss for local venues. I want to support the local venues. Me and my friends want to support the local venues. We want to give them our money, but we're unsure when we go to buy a ticket if our $100 is really going to the Black Cat, if it's really going to Songbird, which is right down the street. There's a lot of ambiguity for fans all across the country and a ton in DC. This is about protecting my community. It's about protecting fairness and access to live performance for all. And we urge you to pass the Resale Act today. Thank you.
Thank you so much. I'm going to turn to my colleague for a round of questions. Thank you very much.
Thank you very much, Madam Chair. Thanks, everybody, for your testimony. Mr. Walker, could you maybe help us walk through the process a little bit of how do you price your tickets for your performances? What are some of the factors that go into, at some point you got to pick a number. How do you help factor that in?
The actual factual truth is my fee is decided way before. So I don't have anything to do with the tickets in some instances. So what happens is I'm called about a show and then we negotiate how much that's going to cost. That's an all-in cost from the beginning. So if I'm playing a 9:30 club, I know exactly how much I'm supposed to get paid. We may or may not discuss tickets, but once I get paid, right, either in advance or at the end of the night, right? Once I get paid, all of that money goes to management, it goes to booking agent, it gets split up. Once the tickets go on sale, as soon as the tickets go on sale and I see the price go up, I'm just as surprised as anybody else, right? And so we're sitting there looking like, wow, should I have charged more for this show? Should I have done that? Or no, my price is my price, and I hope that folks can get in at the price that I would hope the ticket would be, right? And so what we're left with is, from the Future Music Coalition, is people looking at StubHub and Ticketmaster, the Spider-Man meme, right? They're just pointing at each other saying, you're bad, you're bad. And we as the artists are sitting back going, hey, we tried to make it affordable, and somebody else is coming along, profiting off our kindness. And once again, and I will always reiterate, they're playing with the love, right? That's the intangible. It's the thing that music is the thing that drives us as a culture and a society. We have the songs that are our favorites. We have the artists that are our favorites, and we'll almost do anything to go see that. I'm the same way, right? If I see a artist that I want to actually go see, I'm going to pay for the ticket. I'm not going to ask for the guest list. I'm going to go and support. One of my favorite bands is in here right now. Oh, He Did. Great band. I will pay whatever ticket price to go see him, but that's because I love them, and I want to see them prosper, and I want to buy their merch, and I want to do all the things. But once you get a resale situation happening, it's no bueno.
Yeah. Well, I appreciate that. To help explain that a little more, have you ever had a situation where you got put in a position of having to explain to a fan or a friend why that ticket was so expensive when you thought it was going to be something different?
Exactly. Well, the ticket price will go, it goes on sale, right? So if I did a song, a show of Songbird, right? Ticket price is $20 to get in. That show sold out. So now my friends are outside and they're like, yo, did you know this ticket was X amount? I was like, no. How'd that happen? I mean, it was part of a larger thing. It was multiple acts on the bill. But I'm like, well, how did that happen? I wanted them to come see it. If my mom wants to come see it and my brother wants to come see it, right? I'll try to put them on the guest list, but if we can't do the guest list situation, then it's your time to get a ticket. So then I'm outside and they're like, yo, what happened? I'm like, somebody bought the tickets up, right? I don't know. And you find that all the time, especially when you walk into a venue and the tickets are gone and you walk in, you're like, there's mad space. There's seats.
Yeah.
There are a lot of seats. Why are there so many seats, right? If it's sold out.
Yep. Okay. And that kind of lines up a little bit too with representative of one of the venues on previous panel was basically as the host venue, right, is trying to do everything they can to figure out how to make it right for, in that case, the mom and the daughter that traveled and is going to try to figure out, does somebody not using their tickets? Do we know somebody? Because when the price gets jacked up, you're going to have folks that say, well, I'm not going to see that person anymore, or I'm not going to go to that venue anymore. So you had nothing to do with jacking the price up. The venue had nothing to do with jacking that up, but you're going to kind of suffer the brunt of it.
Yeah, 100%.
Yeah.
Yeah.
Okay. To Mr. Erickson, I really do like your the line you used. Two monsters fighting doesn't mean one's a good guy. It's a great way to put it, because I think that's one of the things we're going to hear. I mean, we wouldn't be hearing it if it wasn't kind of an effective strategy that they've used before, right? So I think that's what we're going to hear, but I appreciate you kind of helping debunk that around what this is, because maybe it's a really good distraction. It works. I mean, and the more we talk about it, the more that it shows it works because we're talking about it, but it's not true and it's a false choice. On the previous panel, we kind of talked about that. Anything else you wanted to add about how we, as the policymaker, need to be trying to think about what we're hearing and rooting ourselves back into what's the problem we're trying to solve?
Sure. I mean, the core of the problem is also a resource disparity. The folks that policymakers in all the states and federally that could clear these issues up quickly are also often the folks with the least amount of public policy resources, right? I don't have any lobbying budget at all. If we had time and resources to talk to everybody about this, it'd be easy to clear it up. And meanwhile, Ticketmaster has virtually unlimited resources. The resale platforms and the various broker organizations have virtually unlimited resources, both to use themselves and to advocate either directly funding or just investing in white papers and things that put forward their perspective. We just don't have those kinds of capacities on the musician side, and especially the independent musician side, right? And so I think the way that we get past that is just for policymakers and regulators and everybody who wants to understand this issue, journalists as well, to invest the time in talking to people that are active in this work at the community level and active in trying to bridge the antitrust conversation and the regulatory policy conversation and grounded in the lived experience of music communities.
Yeah. And I guess to believe the argument, I would need to believe, or they'd have to convince me that somehow there is a massive cabal of every small and independent venue, every nonprofit theater space, and every individual artist. First, I need to believe that you all are involved in some massive secret cabal conspiracy to convince me that you're all secretly working for Live Nation or Ticketmaster. Right. When I have this many DC long-time based independent venues, local businesses, residents, artists, they're not making it up. And so I think that's a big part of what we're going to get here. Before my time runs out, Ms. Gilver, I did want to bring you in. You talked a little bit about Maine. I appreciate that. Now, Maine is not DC. It's lovely, I'm sure. But I'm not sure yet, because it is so new, how much yet we can draw from the experience of Maine. I'm looking forward to kind of hearing what that experience looks like. Maryland, which has a slightly different approach, some similarities, doesn't have the price cap, obviously, still relatively new, but we've heard a little bit of experience out of that yet. But From a consumer perspective, what do you think has changed? If someone wants to go to a show in Maine right now, what does that consumer experience look like differently now than it did a couple of months ago?
Sure, absolutely. And like you said, this piece of legislation has only passed in the coming weeks. Right now, publicly, there are 8 violations that are being worked on. As I mentioned, 5 of those are coming from StubHub. We worked with a number of venues in Maine to try to get their voices heard for that piece of legislation as well. I was just talking yesterday to a woman named Lauren Wayne, who runs the State Theater. I believe she's submitting written testimony as well. What she described it as is just a breath of fresh air, a weight lifted off her shoulders. She said that as a venue, they're already seeing fewer complaints. And anecdotally, I'll say, based on my knowledge of the resale industry, I wouldn't be surprised if professional resellers are going to other states to commit these fraudulent acts when a state like Maine even recently passed this 10% resale cap, because they want to avoid any sort of infraction or pushback to reselling in this state. So one thing I'd like to just really say is, although enforcement will take some time, and there will be things that need to be sorted out in terms of how DC can enforce this piece of legislation, I guess that resellers will go elsewhere besides DC and besides Maine to sell hundreds of tickets every day. And I would encourage you to also read Lauren Wayne's testimony, who works with Maine consumers every day.
Okay. All right, I appreciate I'm out of time, so thank you all very much.
Thank you, Councilmember Allen. Thank you to this panel. Our next panel includes Chelsea Bennett with StubHub, Kevin Callahan, Head of North America Government Relations with StubHub, Joe Freeman, Vice President of Government Relations with SeatGeek, and Brian Barry, Executive Director, Ticket Policy Forum. Okay. Do you want me to add anybody to the panel? Coming. Oh, okay. All right, then Kevin wants to go first. Okay. Yeah, go ahead.
Thank you, Chair Nadeau. Good afternoon, members of the committee. Thank you for the opportunity to testify today. My name is Kevin Callahan, and I serve as Head of North America Government Relations for StubHub. You've heard a lot about us today, the world's leading ticket resale marketplace. Appreciate the chance to speak with you about the Resale Act and to share why we believe that as currently drafted, though there are a number of provisions which we are supportive of with some certain modifications which we think would improve it. We do have a number of concerns, and we do think it would unintentionally harm consumers. It would reduce competition, and it would strengthen the monopoly power of dominant ticket companies. StubHub was founded in 2000 to make buying and selling tickets safe, transparent, and reliable. We do not set ticket prices or control ticket supply. Instead, we provide a marketplace that connects fans who want to attend live events with those who have extra tickets and back every transaction with our Fan Protect guarantee, ensuring that the buyers get the tickets they paid for or receive a full refund. In 2024, StubHub connected more than 23,000 DC residents and over 150,000 visitors to live events in the district, supporting the city's cultural and economic vibrancy. While high prices have been raised on, has been a topic that has been raised on StubHub, 40% of concert tickets have been sold for under $50, while nearly 80% of concert tickets sold on StubHub were priced under $100, demonstrating that resale does provide access, affordability, and flexibility to fans across income levels. We know there are a lot of frustrations often associated with resale, and you've heard some of that today. These are definitely important conversations to have, and we are a willing participant. We want to make sure that those discussions happen in parallel and not in lieu of an examination of the root cause of these frustrations, which does generate from a lack of competition in the overall ticketing marketplace, upstream and not just downstream. Many of the frustrations fans experience today are often blamed on resale, but with the problems upstream, including the structure of the primary markets and how tickets are initially allocated, priced, and restricted, fans who leverage resale can feel that. As has been mentioned several times, certainly the Department of Justice and AG Schwab, a bipartisan group of 39 other AGs, have filed the sweeping lawsuit last year against Live Nation and Ticketmaster. alleging that they maintain monopolistic control through exclusionary conduct, harming fans, artists, and venues. This conduct has also included restrictive ticketing technologies and anti-consumer contract terms. Ticketmaster controls roughly 80% of major concert venue ticketing in the US, including a dominant share of DC venues. And its parent company, Live Nation, manages artists, promotes tours, and owns many of the largest venues, as we're aware of. We do believe DC is well positioned to be a thought leader in how to craft policies that expand consumer choice, foster competition, and ensure every fan, not any one dominant company, has control over their live event experience. I do want to hit on just a few points that have been mentioned, but we are concerned about the proposed price and fee caps as a clear example of how policies intended to help fans do actually reinforce monopoly power and undermine consumer protection in the marketplace. While on paper, a price cap sounds consumer friendly, in practice, it would make ticketing less safe overall and less transparent. There has been research that is supported by Irish police authorities, banks in both Ireland and the UK and in other markets that does show that there is fraud and as a result of ticket resale price caps that is higher. And though this is focused on the UK, which is considering a price cap, most markets, as we know, and particularly here in the US, have not moved towards enacting a price cap. In fact, they've moved away, including most recently Massachusetts, which rescinded their almost century-long price cap just last year. When legitimate marketplaces are restricted, buyers and sellers do move to unregulated spaces like social media. And further, you find that fewer legitimate marketplaces are competing for customers. A consumer may find themselves forced to transact with a singular entity, which, given the dominance of Ticketmaster in the DC market, may further entrench their power. I do want to touch on a second issue, which is about the limitation on consumer rights that's within the bill. And while the Resale Act appears to protect a consumer's right to transfer tickets, it contains a major loophole that allows primary sellers to restrict transfer if disclosed at the time of sale. This is a false choice that effectively legalizes restrictive technology and practices, which are the very subject of the amendatory complaint.
I can
I
follow
know
up
my
with
colleague
you.
will be speaking
Yeah.
as well. I appreciate.
I can follow up with you in my round of questions, so you can talk about that more. Go ahead.
Thank you.
Ms. Bennett.
Well, good morning, Madam Chairwoman. I am Chelsea Bennett. I lead the Eastern U.S. State Government Relations for StubHub. And as we've heard here today, attending your favorite live events is something that is personal and emotional to residents of the district. And that's why our platform provides a safe, secure, and regulated marketplace for fan buyers and sellers. Founded 25 years ago, we were the first to have a Fan Protect guarantee. And that is every order is backed by our Fan Protect guarantee. If you have an issue with the ticket with your order, we will find a similar or better ticket, provide a 100% refund, or for those avid StubHub users, 120% credit to be used on our website. What's most importantly to highlight as a part of this conversation, as you've heard a lot today from those on the other side, is that on our platform, less than 0.2%, let me repeat that, less than 0.2% of fans ever have an issue with their tickets at the door. You heard my colleague outline a few issues with the current version of the Resale Act. So let's talk about what real ticketing reform should look like and what's really best for the customers of the district, what will promote competition, transparency, and actual fairness. And so what we proposed is guaranteed transferability. Fans should have the freedom to use, give away, or resell the tickets they buy just like any other product they purchase. True ticket transferability protects consumers by allowing them to share tickets with friends or family or resell them safely if plans change. It's life and we're human. We should also require, you all should also require holdback disclosures. It should be disclosed to fans how tickets will be allocated for sale to the general public, as well as transparency on how tickets will be priced. That is a way to truly allow consumers to make informed purchasing decisions. You all should promote open ticketing, which will allow verified ticket data to move securely between ticketing platforms to detect fraud, curtail bots, which we've heard a lot about today, as well as help to curtail speculative ticketing. Most importantly, with open ticketing, it will empower consumer choice so that fans can get into the live events that they desperately love and the artists that they want to see. You all should prohibit long-term exclusive contracts. Primary ticket sellers, like Ticketmaster, thrive off of exclusive contracts. Real reform would limit exclusive ticketing deals between venues and primary sellers to foster competition. You should strengthen the anti-bot enforcement. Listen, we share the frustrations with tickets being scooped up by bots. We want to ensure that tickets are in the hands of consumers so that they can see the artists, bands, and groups that they love. And so we agree with the foundation that started in the current Resale Act. However, we believe that it can be strengthened. And it can be strengthened by including a provision that requires ticket issuers to report incidents of known bot usage to the Attorney General to enforce enhancement. We see this in other areas such as with data breach. Lastly, adopt right of entry protections. Let's guarantee that fans cannot be denied admission or restricted from reselling their tickets on the platform of their choice solely because they use a lawful resale marketplace. I thank you for the opportunity to highlight StubHub's Fan Protect Guarantee, the fact that less than 0.2% of our fans have issues at the gate, and what we believe real ticketing reform should look like. We have met with many of you and your staff and want to reiterate that we are here to work with you. And so we support you as you pass and craft a bill that will best support the residents of the district and their ability to buy and resell tickets as they desire. Thank you. I'm available to answer any questions you might have.
Thank you very much. Mr. Freeman?
Thank you, Chair Nadeau. Councilman Allen, really appreciate the opportunity to speak here today. Joe Freeman, Vice President, Government Relations at SeatGeek. Councilman Allen, I particularly appreciated the chance to meet and chat with you yesterday. Greatly beneficial, educational for me as well. We're so thankful, the committee, Councilman Allen, you've chosen to focus on consumer protection for district residents. We agree with much, but as you know, respectfully, not all, especially on the issue of caps, what's in the bill. Your focus on all-in pricing, on barring spec tickets, reasonable refund provisions becoming mandatory, avoiding deceptive URLs, I can go on. Could not agree more. I urge the members of the committee to look really closely, not just at Maryland, which looked very closely at very identical issues, and we think ultimately landed last year in just about the perfect place in terms of policy. And some of the voices you've heard from here today, they're very influential in Maryland. They're scrappy, they know how to connect with people. Same thing in Minnesota. These exact issues were presented last year. Your peers, your counterparts in those states, they stared into the abyss of price caps. The lure, the siren song of price caps, they knew better than to go down that path, and we can talk about it. I urge you respectfully to exercise the discretion and the caution and the judgment that they used. You heard a reference to the state of Maine. Maine did pass a law. You didn't hear until a few moments ago the example of the Commonwealth of Massachusetts, which a year ago, after looking at this so closely, also stepped back from that abyss and overturned its, I think, 105-year-old law. I urge you to engage with the Attorney General's office up there, with your counterparts in the legislature. There's some very important lessons to learn. I want to talk about SeatGeek for a brief moment. We're a bit of a unicorn. We're a bit of an outlier. We're proud to host a leading resale platform, but we're also very much enmeshed in the primary ticketing world. In 2016, we made the decision to take on Ticketmaster directly. We've gotten a lot of antitrust headaches as a result, but we are a primary ticketer as well. We ticket the Commanders, the primary ticketer, and concerts that come into Northwest Stadium. We ticket the Baltimore Ravens. We have a deal with Major League Baseball that allows us to help season ticket holders resell tickets for Nationals and Orioles game. We're an official partner of the University of Maryland. In short, we're deeply embedded in the DMV. We have a passionate interest in the arts, sports, concerts flourishing in the district. So much of what the predecessor said in support of the bill, I actually agree with. We want them to flourish. They're not our opponents. We're trying to reach out. We're trying to work more constructively with them. There are problems we can all solve, but please do not minimize how dominant Live Nation Ticketmaster is in the District of Columbia. They ticket every event at the IMP venues, if I'm correct, Audi Field, the Capital One Arena. The fact that they're in favor of this bill, the fact that Michael Rapino now speaks out in favor of resale price caps should tell you almost everything you need to know about that issue. The data from Europe is overwhelming. It's an avalanche of data about how bad fraud and scams have been, how much consumers have suffered. We'll be appending that to our materials. Anecdotal conversations, quite frankly, don't cut it. The truth is in the data. I want to focus really quickly on an upcoming event that I mentioned to you yesterday, Councilman Allen. On my way out to DC, I was talking with my 20-something-year-old aspiring musician nephew in California. He told me I'd be crazy if I don't go see an artist I'd never heard of before. I can't make this up. A 20-something-year-old Icelandic Chinese cellist who's almost sold out the Cap One Arena on Thursday night. I won't pronounce her name correctly, Leve, I believe. I went on to Ticketmaster. One time I looked, there were like 3 or 5 ticket listings left, primary. When I went back to look at primary and Ticketmaster on Saturday, they were all gone. Lo and behold, I looked at Ticketmaster resale. Yeah, there were a lot of tickets. I went on to SeatGeek, lots of tickets at all price ranges, lower and higher. I had a choice. Do not please deprive consumers, concert goers of choice. Consumers are smart. This is not the 1950s. I'm old enough to remember having to go talk to the guy on the street corner outside the venue, handing him some hard-earned money and being turned away at the venue. These are not abstract issues. Don't move us backwards in time. Lastly, I just want to say there's so many ways we can be making ticketing better. To its credit, the Federal Trade Commission, 7 state AGs, including 2 Democratic ones, they're beginning to identify the issues. There's so much transformative activity happening in the industry. I tip my hat with immense respect to General Schwab, leading the way along with 39 other bipartisan AGs to try to improve this industry, joining first with the Biden administration DOJ, and now the current administration to try to make ticketing fair. I appreciate the opportunity to speak and look forward to answering your questions.
Thank you. We'll now hear from Brian Barry.
Good afternoon. My name is Brian Barry. I serve as the Executive Director of the Ticket Policy Forum, a new organization of the nation's leading marketplaces that includes StubHub, SeatGeek, Vivid Seats, TickPick, Game Time, and Events Ticket Center. Our forum was recently created to advocate for our marketplace members, protect our customers, and promote real competition in ticketing. Now to the bill. There are several positive elements that we think are good, such as the refund requirements and transparency provisions, especially if they're aligned with the new upfront pricing rules that took effect in May per the FTC. Those are good measures, the good for fans and the good for fairness. However, as you can expect, there are other parts of the bill that would have serious unintended consequences. They really do risk driving out the very marketplaces that have made ticket resale safe, transparent, and consumer-friendly in the district for more than 2 decades. They've been working in the district for over 20 years to make ticketing safe. Specifically in the bill, the transferability provision would effectively give new unchecked powers to venues and artists to strip fans of their current existing rights to use, give away, or resell their tickets as they choose, rights that they have often paid taxes on. And the price and fee caps simply don't work, as you've heard. They may sound good, but they will distort the market and create serious enforcement problems for the district. Plus, as proposed, to clarify something that was said earlier, the cap isn't equitable. It applies only to resale. It doesn't apply to the box office or its ticketer, which is most common, Ticketmaster. Just take a look in DC, it's almost always Ticketmaster. Here in the district, our marketplace members are proud to have served millions of fans over the last 25 years. They're not here complaining today. They make ticket buying accessible, safe, and competitive. It was these resale marketplaces that helped move ticket buying from the shady sidewalk exchanges outside of the old MCI Center, as I would buy for the Caps games, to now a secure, regulated, and guaranteed online experience. There simply is no reason anymore for anyone to buy what they hope is a ticket in a parking lot. And yes, resale tickets can often be offered at a price higher than their original price, but just as often, and that hasn't been talked about today, they're sold for less, a lot less. DC residents saved millions of dollars last year by buying on the resale market, and that's a good thing. And the taxes they paid when they did, well, they're important. I don't need to tell you that. I've personally bought a $7 ticket for a show at the Anthem, a show where the Anthem's original Ticketmaster price was $70. Tonight, I checked, the 930 Club is sold out for an artist, Quedeca, I believe, sold out. I checked before I came up to testify. You could purchase more than 50 tickets for below $9. Below $9, you can go to the show tonight. Let's also be clear about market concentration. Nearly every major venue in the district, as Joe said, Cap One Arena, the Anthem, Audi Field, Warner Theater, Nationals Park, the 930 Club, Dar Constitution Hall, and others, they're all ticketed by Ticketmaster. Just go to the websites and check. That's got to be close to 95% of the market, and that's just an incredible concentration of power. Now, I understand that some local venues and artists don't, they have concerns about fake tickets or speculative listings. Well, guess what? We share those concerns too. Our marketplace members agree that deceptive speculative tickets have no place in the systems. Listings must either be within constructive possession of the seller or clearly labeled as a procurement service. Likewise, deceptive websites, let's get rid of those too. Those steal business away from our marketplace members. The reality is, the best way to keep fraud in check is to support legitimate resale, not by restricting resale or restricting transferability. Every jurisdiction has tried it and seen fraud gone up, as you've heard today. So what happens? Yeah, it goes to Craigslist. It goes to Facebook Marketplace. That's where people get scammed, robbed, and hurt. The 10% cap on resale fees also misunderstands how marketplaces operate. Unlike Ticketmaster, which profits from the base price and a long list of other fees, the fees that marketplaces charge, they do pay for fraud prevention, customer support, order fulfillment, and the guarantees that insured fans get in. That's important. They're not excessive. They're essential to keeping the system safe and fair. Neighboring jurisdictions in the DMV have already faced a lot of these questions, as you've heard today. Both Virginia and Maryland chose to protect transfer rights, not impose caps. Virginia passed a law ensuring fans can use or transfer their tickets freely. And guess what? Maryland rejected proposals for price and fee caps after realizing they'd harm consumers. DC shouldn't go that way. We've seen that movie before, and it doesn't end well. In closing, and I mean this seriously, our goal is not to frustrate you or to oppose you. It's to work with you and to make a bill work for our marketplace members, protect the market, and keep them here. These are the companies that cleaned up resale. They did the district a big favor. I hope you will embrace them and work with us. Thank you.
Thank you. We'll do 10-minute rounds of questions. For StubHub and SeatGeek, to the best of your knowledge, what percentage of sales on your platform are by scalper or brokers?
I'm not sure that I have a percentage, but the majority of our sellers are fan sellers, so a little over 99%.
Okay.
I'd have to look into that as well. I know in the context of a Major League Baseball team like the Orioles and the Nationals, a large portion are fan season ticket holders. And again, we're working with teams like the Commanders and Ravens. A very significant portion of our sales come directly from the team when we're serving as the primary server. We submitted information to the Maryland AG's office last year as part of their legislation that I think Chair Nadeau gets at your question, and happy to share that information with you as well.
And how do you know that their fans are ticket holders?
So in some cases, they would have multiple sales. Season ticket holders tend to have multiple sales, so we're able to at least understand that they're, that they are season ticket holders selling a similar set of seats on virtual multiple occasions. But for the most part, we're talking about average folks who are selling, I don't want to put a number on it, but 20, 30, 50, even sometimes 100, up to 100 tickets, and would not consider themselves, a business that's making it. We don't have to issue, say, a 1099K to those types of sellers.
And we have relationships with leading broker groups. We don't shy away from that. Most of them have direct relationships themselves with professional sports teams to serve, in a sense, as a retail distribution for what are, in that sports context, wholesale relationships. So we know who the players are. It's part of the reason we're so confident about trying not to host spec, trying to fight fraud because we work with reputable folks. We haven't built a business, let alone tried to compete and gain a foothold against Ticketmaster by leaving consumers holding the ball or having a bad taste in their mouth. To the contrary.
Sorry, just to Joe's point, similarly, StubHub, we also work with some teams, venues, as well as, other commercial partners who, aren't in the ticketing space, but they might actually be rights holders or event organizers. And so they too might leverage our site to sell directly to consumers as well. They might have leverage to be able to enter into that sort of arrangement with us to sell at the same price that they would through their own means, but as a way of amplifying their ability to reach consumers through our marketplace. This is something that we did highlight in our S1, as was referenced earlier, of direct issuance, where, working directly with a venue, with a team, in some cases, it might be other theater groups and so on, that they are able to take advantage of, the customer base and actually meet customers to where they are coming so that they are able to fill their venues. And because of that partnership and arrangement, they're able to get, information on customers that we may have that are attending their events so that they could continue to build their relationship directly with that customer.
100 tickets per year still feels kind of high for like a, regular person. Am I just not understanding this?
No, I think from a season ticket holder perspective, you'll see that. I know certainly the bill here doesn't, carves out sports per se, but you'll see those season ticket holders also get access to concert tickets depending on the venue. And so they might sell those concert tickets to offset their costs to, say have premium seats, for the Caps or the Nats.
Got it.
If I could add, if you have the chance to look at some of the screenshots included in our written testimony
Sure.
for the concert this Thursday night, or tomorrow night, I should say, at one moment, all the tickets available on Ticketmaster were in the upper resale bowl. Our site has tons of tickets available in the upper resale bowl. That's not where the professional resellers are going. There are countless instances of fans buying for and for whatever reason reselling to. Maybe someone cancels, maybe they see it as a way to make back some of the costs they're expending out of pocket.
Okay. So you have to issue 1099-Ks to professional brokers. That's the way it works.
So the federal government requires it's 200 transactions and $20,000 in order to be issued. There was recent legislation that Congress enacted earlier this year to shift it back to, this is federal requirement, but there are different state requirements depending, on the jurisdiction, which are lower. Maryland, I believe, has a lower one. Virginia might as well. I think there are a few.
And is it possible that scalpers are selling tickets under multiple accounts so they appear to be fans? Is it possible that scalpers are selling tickets under multiple accounts so they appear to be fans?
It's possible. We try like heck to police our site. Any transaction that enters the realm, shall I say, of skullduggery is such an expense, a hassle, and frankly, a potential lost consumer for us. We try to move mountains to prevent the misleading things you're alluding to from happening.
Right, just as we have an obligation to verify a seller, we would have some more visibility into knowing if they are trying to skirt or not deal with that. I'd say it could happen. I don't know the instance of that happening.
So where scalpers are, you believe, a small percentage of the folks that are doing business on your site. Where do you think they are selling, if not on your platforms?
Can you clarify what you mean by scalpers? Are you referring to brokers?
Yeah, let's say brokers.
I think there's, the way the term has been described a little bit today is, people who are selling for more than face value, which I think could be any individual seller as well. But a broker, I think as Joe mentioned, the brokers are, for his platform, certainly for us too, they are a part of the ecosystem. They're certainly, working with other partners as well and listing across different platforms. Nearly every resale platform has brokers certainly to some degree. I don't think we're denying that. I just don't have the exact number of what that might be.
Yeah, and I did not mean to imply, forgive any miscommunication, that professional resellers are a trivial or de minimis part of activity on our platform. That's not the case. There's also an extremely significant portion of fan-to-fan resale, and especially on the sports side on our platform.
Chair Nadeau, if I might.
Sure.
The only thing that I would add here, having been in the industry for about 10 years, is that whether it's a professional selling tickets or an individual selling tickets, it kind of doesn't matter. What matters is that it's safe. Just like if you go on Amazon or eBay and there's professional companies selling products there too. There may be many in the hearing room today who object with professional resale, and that's fine. That's truly an opinion, and it's everyone's entitled to that. But so long as, it's not illegal, it could be objectionable. Professional companies selling on eBay, I might take issue with as well. It matters that it's safe. And I just want to go back to that point. I was the guy in 1999 buying Caps tickets, at the corner of the MCI Center. And I got ripped off sometimes. That doesn't happen anymore. That's great. We need to celebrate that. DC has done a great job at taking, scams off the streets and making it a safe experience now. I do worry. This is one of the few cities that is so heavily dominated by one company operating box offices. The bill written today does have that inequity. I remember speaking to some staff in August about that, where right now it would only apply to resale. So if the box office today, and I'm not talking about really small venues, sub 100 or so, but generally speaking in the District of Columbia, and we work across the entire country, we haven't seen a market that is so controlled by one company at the box office. So if that company is still allowed to raise prices up and down and there's no place else to shop except Craigslist or Facebook Marketplace, I think the district will then, understand and appreciate the problem that could come about. And that I think is worth sometimes. It's a trade-off with allowing resale where the seller sets the price. That is, so long as it is safe and there's accountability, that's the trade-off to allowing that seller to set the price, that safety and trust is maintained.
I'm going to do a second round, so why don't you go ahead and come back?
Thanks. I wanted to maybe jump in a little bit on the issues around ticket transferability, because I think I heard a couple of you raise that issue. So first off, let's just make sure we establish what we're talking about. Legally, a ticket to a live event, it is a license or it is your physical property?
Say some states have defined it differently.
How is it in
I'd
DC?
say we would view it as you bought it, you own it.
But that's not what the law says.
Which law? Here in the US, here in Washington, DC?
Here in
or
DC.
DC, it's undefined, I believe. I believe the Resale Act defines it as a license. And while I certainly agree with, preserving the ability to, the venue to maintain control as well, I think there have been times where consumers don't have the ability to negotiate the terms of a license. So you will see tickets being canceled.
Well,
or you
in
will
DC, I got to keep moving here. In the district, a ticket under contract law is a license. It is not your property. You may want it to be your property,
right?
But it is a license.
Fair point. Yeah.
I'm going to be traveling for the holidays. I'm going to buy an airplane ticket. Is there a secondary market where I can go put the seat on my flight? Can I list that on StubHub and sell my airline ticket on Delta?
No.
No, I cannot.
Actually, sir, Southwest Airlines was the first airline in the industry to introduce pay a little bit more for a fully transferable ticket to someone else. It's a pretty novel concept.
Appreciate that, but that's not the question I asked. So that's not what we have. It is a license to be able to do that. It is not your physical property. I think if we were to go down the road of saying that a ticket and a seat in a venue, I think it's a slippery slope. And I think we actually encourage even more scalping if we go down that road. Let me talk a little bit, another issue that came up on some of our earlier rounds, and that's an issue of speculative ticketing. And I appreciate when I've sat down and talked to several of you, you agree you don't want to see that either. The example that we were given earlier this morning, and I think we've heard it in other places, where a speculative ticket, even the pre-sales haven't opened up yet, but a ticket for a event is already listed on your platform. Is that what, when we're using the phrase speculative ticketing, would you agree that's what we're talking about? They don't have it. No one's bought the ticket yet. Pre-sale hasn't even opened yet. And yet I could go online and try to purchase something and it's listed there.
Can't speak to that specific instance. Like you said, I know the presale happened, but I think there can be occasions where you have the rights to tickets, and it's certainly not one size fits all to that situation. But if you have the rights to a set of tickets.
I'm not going to put you on the spot to answer a specific example that you haven't had a chance to actually probably check in, right?
Fair
But I'm going to talk about my hypothetical, which is
Please.
your pre-sales have not opened up yet, but you can go online and I can find a ticket for that event that does not exist yet. And I think based on my conversations, we would all agree we don't want that. And that's one of the things I think I've heard you say when we've met. You support ending speculative ticketing.
Correct.
Is that a yes or a no?
Councilman Allen?
Yeah.
We are thrilled with the provision in Maryland that both bans spec and requires a specific seat listing attached to the ticket. We are thrilled with the provision in Minnesota law that seeks to outlaw the early listing of tickets, which is what I think you're alluding to, having a ticket that is not yet even available for resale, unless it's in the season ticket holder's, constructive possession already. I would say we police our site as aggressively as possible to prevent just those early listings that I think Ms. Fix-Schaefer mentioned earlier. We would love nothing more, and we're trying to work with them. Send us a monthly email.
I'm trying to give you a win with this question.
I'm
that you agree we don't want speculative ticketing.
Sir, I'm trying to hand you a win. Please let folks try to work with us. We want to solve problems. Send us a list of what your on sales are the coming month and when they go on sale. We're going to police it. We want to work with these sites to solve the problem, and we're trying to do on our own to the best of our ability.
Take it as a yes. We all want to end speculative ticketing. The reason why I want to make sure it's clear, because the idea of concern around fraudulent tickets has been talked about a lot. A speculative ticket, if there's a ticket listed on your sites or any platform that doesn't actually exist yet, that is a fraudulent ticket. That is fraud. And we do not want it. I'm going to go ahead and assume all of us are on the same page. We are not wanting to see that happen. But there are fraudulent tickets that exist on our platforms right now, and we do not want that. And I take you at your word. You want to police that and shut that down. That is one element of the law that we're trying to get at. The part that I'm also trying to understand is when we talk about forcing people into back alleys to go try to find 2 tickets, you're pretending like this law is going to have you cease to exist. You've said you have a resale platform that a large number, maybe you said majority of tickets, are sold at a face value or below. There is no floor that this law says. So for ticket values to go down, it is simply the price cap. And I think, I think I've chatted with all of you about this, you really don't support a price cap. But the way you keep talking about fraud, or that this is going to send people into a back alley to go try to find 2 tickets from somebody in the deep, dark hole of internet somewhere, is you're pretending that your legitimate platform doesn't exist anymore. I believe that, I'm somebody who has both sold and bought tickets on your platforms. I believe that it is a space where you can actually have a trusted interchange of, my plans changed, and now I have 2 tickets to an event I can no longer go to, and so I want to be able to see if I can have somebody be able to sell them. I don't think there's anything illegitimate about that. And that doesn't change under this law. Your platform, and I'm going to assume the credibility you've worked hard to build up as individual platforms, still exist.
I wish Ticketmaster were here today to testify. When they impose a price cap function on resale, they also install a price floor. And in those over 50% of events where consumers currently have access to some level, some amount of below initial price, face price tickets, it's a huge consumer benefit. We just know that you cannot legislate away legitimate consumer demand. In that unicorn situation where Taylor Swift comes to town, people are going to mortgage their home. I'm being facetious to get a hold of a ticket if their daughter or spouse or they themselves want it. What we also know, though, Member Henderson, you'd alluded to this, I can provide media where on our site, you could get $20, $30 tickets for Beyonce leading up to the show because not every human being can sell out the last 10 rows of the building.
Mr. Councilman, I'd also note that, the idea of a fee cap on the marketplaces is a fundamental misunderstanding of how the business operates. So you are correct. Could a business still operate in DC? Could it elect to operate in DC under a 10% fee cap? Perhaps. Would it likely fail? Most likely. Marketplaces don't feed off of those line items that you see up and down the Ticketmaster. They don't get part of the venue fee when they manage. They don't get part of the delivery fee. They don't get part of the base ticket price if it's a Live Nation managed artist. I mean, if you look down the vertical line of a Ticketmaster or Live Nation managed artist and a Live Nation managed venue, they feed off of every one of those. So they can charge a 10% fee, a service fee on a ticket, because they're feeding off the rest. But for a StubHub or a TickPick or a Game Time, that is the only way that those companies operate in order to provide the service they do, to take the shady offers offline and onto their trustworthy marketplaces. They accept that, yes, there will be sellers who sell higher than they paid. I personally, as a fan, I don't go to 40 shows per year, ma'am. I go to 50 to 80. I go every week. And I often buy 4 because that's the limit I'm allowed to buy, and I sell 2. I've showed my son the art of, let's go for free tonight. And, we'll buy the tickets now, and it's a safe way. The buyer who buys the tickets from me is protected. I'm the seller in that case. I'm protected. And, that costs money. That's not free, and 10% doesn't cut it. So that's why I think there's an opportunity to talk with you.
True and free market. Let me try to wrap up with my last questions here, though. Nope, I've got 50 seconds left. Do you remember StubHub said they're still in Maine, even though they have a 10% cap? But I did want to check with one last question, Mr. Freeman. You're the primary seller for Commanders in Northwest Stadium, correct?
Yes, sir.
Okay. So when 2 nights Beyonce were hosted this summer, did you see any scalping or bot behavior in the ticket sales?
We see bot behavior, people trying to cut the line almost all the time we do a high event on sale. We invest tremendous resources to try to combat that. We're very good at it. We're not perfect, but we're very, very good at it. But it's a very real issue. It's one of the few things I'd agree with Ticketmaster on when they talk about how challenging it is, but we try hard to fight it.
But doesn't
when you say
the secondary market undercut your primary market?
In no way whatsoever. It's two distinct issues. When we're ticketing a building, we're the agent serving on behalf of a principal of the building, who's in turn contractually obligated, typically to the concert promoter. There's no contradiction.
So you're good with
I'd argue that supplement.
selling a face value ticket and then seeing it for 10 times over on StubHub's platform. No problem whatsoever with that.
That's with all respect, sir, a misdepiction of the issue and how any company in our shoes look at it. We're there to serve a client at a primary venue. We wish we had more. It's not a competitive playing field in that industry yet. But if someone chooses to resell or someone lawfully acquired the ticket, we think in that context, as long as they're not violating any other rules, it's their right to do it, whether it's on our site, StubHub, or Ticketmaster's resale site.
They may have a right to do it, but that's what this law is trying to change, because it's not right for the person who's trying to go see the show.
And we just urge you to not go down the path of price caps for that reason. It's counterproductive.
Thank you both. Appreciate that. Councilmember Henderson for your round.
Thanks. Hello, I'm back. I've been watching. There was another hearing. I was eating my lunch, but I have been watching the conversation here. So I just want to ask some questions. For hold on, Mr. Freeman and Mr. Callahan, on the issue of speculative tickets. Let's say a venue reached out and said, hey, we see on your website there are tickets that are for sale that have not been on sale. What's the process? What happens?
We would take them down. We try to proactively monitor that. We're good, but we're not perfect. In Minnesota, we have a whole program in place designed to prevent that very thing from happening. Is a challenge when you're talking about smaller venues that, let alone no back-end integration of the systems. It's really challenging. But we think the point about premature resale is an issue, and we try to abstain from it as much as possible. I would add that back-end integration and a leveling of the playing field, and Ticketmaster above all, opening up its systems would do great things with respect to potentially being able to solve that problem.
Okay.
Plus one on the point of the integration there, but to your initial question, yes, and we certainly do hear from
Ms. Schaefer as well as others occasionally when there are allegations of it. And so similarly to SeatGeek, we would investigate and review. At times, we do request a little bit more information from the venue to better understand. Is it a speculative ticket, or is it just they don't like us, right, and want to pull down that inventory? Assuming that it is a speculative ticket, we would pull down the listings as well as investigate that seller and find out what happened.
Okay.
Are they trying to skirt our policies, in which case we would remove them?
Okay, similarly on
On
that,
occasion, we find it's the complaining venue's own season ticket holder. That happens too.
okay. Similarly on that, let's say you receive a complaint around a fraudulent ticket that was sold on the platform. What are the consequences to the seller of that fraudulent ticket beyond now you have to pay? Do I get to stay? Do I get to keep selling fake tickets? What if it becomes pattern and practice? What is that process?
Yeah, generally, it would be to investigate that seller and what actually transpired. I think there's this assumption that someone selling a ticket that didn't scan through is that they are being nefarious. However, that's not always the case. As I mentioned and Ms. Bennett mentioned in her testimony, the majority of our sellers are fans. And so at times, because if we did not initiate the initial transaction for that ticket to purchase it, we have to direct people to a third party platform. And at times it can not function as well as we would hope. And so certainly there can be times where something has happened or the seller sent the wrong ticket that was already scanned in by somebody else. It can happen depending on the service.
If I'm a seller, can I have multiple accounts on your platform?
If you are a seller, can you have multiple? I'm not certain.
I'm a professional
If you're
reseller, like
a business,
you know, an account 1, account 2. If you block 1 and 2, I can go to my account 4 and 5.
I suppose it would still have the domain, but if it is that seller and they are a bad seller, we want them off.
We know who our sellers are, at least, the professional ones, and we police it mightily. And the ones who are rogue or specialize in fraudulent tickets, they're off of our system so fast because they're our worst enemy. We then have to go take care of our consumer, try to make everything right. I would add, sorry to be repetitive, but as I said to Mr. Allen in our meeting yesterday, there's no reason this industry should not look like hotels or airlines in the following way. You can go to 20 different websites tomorrow to buy an airline ticket or to book a hotel room, knowing full well you're going to get a real hotel room and a real airline ticket.
Y'all gotta talk to Ticketmaster. I would love if you operated like Expedia.
We
with all of the integrations, as you said, the
beauty of
open ticketing, et cetera, but a little bit beyond the
Councilmember,
scope.
from your mouth to the ticketing god's ears, we put that exact proposal in our submission to the federal government when they solicited public comment on the pending executive order.
Yeah.
And we've been trying to do that within the industry for a very long time. I won't repeat the response we got. It was not polite.
It was not polite. Okay. I will say this, right? They're not here, but I got issues with Ticketmaster. I've got issues with SeatGeek. I've got it. Well, I don't have issues with StubHub because usually if I come to you, it's pretty solid. And it's usually on sporting types of things, which again, I feel like sporting events are a little bit different because if I don't get it for that one game, they got 90 something games in the season. I'm going to figure it out. It is those one-time events where it's like, I need that part. And, I would just say, because I know you're about to get defensive, but my issues with you guys it has nothing to do within the scope of the bill. I don't like dynamic pricing. And I definitely don't like fees. But that's everybody. I feel like as a consumer, right? You get the ticket and you're like, wait, but the ticket was $100, but I paid $400 because of the artist fee and the venue fee and the person's fee and the taxes. Again, that is not necessarily part of this. So I just want to sort of be very clear on that. But I think it's around how do we level the playing field? Mr. Freeman, or not Mr. Freeman, sorry, Mr. Berry, you said something downstairs. Well, when I was downstairs, you said something about if it's safe, it's okay if you've paid more or something to that effect. And in some ways, as a fan, I feel like for the experience of for a safe product, you have to pay 4 times more, I feel like that's a hard one for me to swallow
Sure.
from a consumer protection standpoint, because some of them, it feels straight up price gouging.
Sure,
My
but
staffer here, Gabrielle, she went to a show, Howard Theater, small venue.
beautiful theater.
Beautiful venue. It's got some, as a for
Great
fan
acoustics.
experience. The tickets originally were $15. She had to buy it for $60.
Mm.
Right? I feel like then standing next to a fan who paid the 15, but you got the 60. So I feel we're getting the same product at the end of the day, but is there not something predatory about that?
You know, when I paid $70 to go see Arcade Fire at the Anthem on a Friday or a Saturday, and then I spent $7 to take my kids there the next night, I was happy about that. So it is a two-sided coin. That's the reality of the resale market. It is. I admit it. I fully embrace it. Sometimes I pay more. Sometimes I pay less, a lot less. There is a sold-out show tonight at the 930 Club. Let's all go. It's only $9 on SeatGeek right now. That's incredible. So it really is a two-sided coin. Today, we've heard a lot about a one-sided story, but it's not that. In the district, DC residents saved millions of dollars last year compared to the box office Ticketmaster price. And here's why. There's been a trend, and Ticketmaster is the primary ticketer, the dominant ticketer in the District of Columbia, unfortunately. We need to change that. Hopefully, other companies will. But there's a trend of overpricing at the on sale. So we're hearing a lot of independent voices today, but for the vast majority of large touring artists and large venues, if you listen to the earnings calls of Live Nation, they're overpricing. So what does that mean? The venues aren't selling out. And that's also one of the questions I've had when I've met with staff on the council is what problem are we trying to solve? If I look at a calendar of 31 days, for the vast majority of the venues in DC, there's still tickets at the box office when the show has begun. So we shouldn't, not every show is Beyonce or Taylor Swift, and it's sold out, and the only place you can go is to the marketplaces. Now, there are hundreds of thousands of fans who go to the resale market every year because they prefer to. Maybe they get coupons from SeatGeek or TickPick, and they come back and they're able to get discounted tickets. But there's a preference, there's an affinity for them. They're not forced to these places to buy, Madam Council. They're choosing to. But as for price gouging, for every ticket you see higher priced or higher than its original price where the venue was paid, these are not stolen tickets. Every single ticket on the secondary market was paid for, full asking price. Every single one was already purchased. Now, you might find them higher and you might find them lower. And if we've taken fake tickets off the streets and where there was no accountability, I was one of the victims of it.
No.
And now today you have
What I'm saying
accountability.
is the suggestion is, though, there is no one being scammed is just false. There are people who show up to venues thinking they have a ticket that does not exist.
And that's the problem we need to solve for. If your ticket, Virginia passed a law, as Ms. Bennett testified earlier, that makes it illegal to deny your entry based upon the basis that your ticket was a resold ticket. There are some of these anecdotes that are being shared with the council where these are not illegitimate tickets. They're simply not allowing them in because they were sold by a different ticketer, but it was already sold by them originally. So to the extent there are truly fake tickets, let's solve them. They harm everyone. But to the extent it's a ticket sold by a competitor, that's no reason to deny a fan.
Okay. I'm doing a second round, so if you guys want to, you can too. Okay. I want to point out something you've all said multiple times. You know who the professional sellers are. You know who the scalpers are. So you know who the sellers are who have partnerships with Ticketmaster to get tickets that the general public can't get, but you're doing nothing to keep them off your platform. Is that correct?
I don't know anything about a professional reseller's relationship with Ticketmaster. I know what I've read in the FTC complaint. And this notion that we're somehow in on this inside conspiracy somehow, with all respect, it's not the world we live in.
Similar, yeah.
Okay, so then you don't know who the professional sellers are?
Not at all what I said. We have relationships with the sellers on our The professional sellers on our platform, we know who they are. We need to know who they are. We need them to be trustworthy and reliable and do what it is they're saying they're going to do on our platform, namely post real tickets and deliver them as promised.
Then you just don't, then you're saying you don't know if they have a relationship with Ticketmaster.
I don't know if they have a relationship with Ticketmaster. I know some of them have relationships with professional teams in the buildings, but what they do with Ticketmaster is their and Ticketmaster's proprietary information.
I would just say if the ticket was issued through Ticketmaster, then, you know, of course they would have some relationship with Ticketmaster. In fact, you know, just given that 80% of the tickets sold on the primary market are through Ticketmaster. And since we have to, you know, when someone is reselling a ticket on a site and we have to direct them to Ticketmaster, even though they purchased it, you know, from a seller on our site, then there would be certainly some relationship there. Although I think to the extent of what that relationship is, other than having possession of the ticket, is not really a position that we're in to have.
Okay, but then, okay, but you're not specifically doing anything to stop people who sell large volumes of tickets?
No, I think if someone is listing a number of tickets and they haven't fulfilled tickets in the past, then that would raise some red flags. So we would look into them. If someone's listing a high demand or a high risk type of event where we know that, you know, the primary has reported substantial activity and we need to make sure that we are checking and ensuring that people have tickets. They can provide evidence that they have the tickets, but unless we issued that initial ticket, we couldn't 100% verify that it is an authentic ticket. It's one of the reasons that we've called for an open ticketing concept where we are able to ensure that that type of data is shared, that you can cut down on the use of people who illegally acquire tickets using bots or who are trying to sell speculative tickets, which they do not have ownership of. And so would certainly welcome that type of discussion as well to curtail some of these issues.
We do everything we can to make sure the resellers on our platform are operating lawfully. I think it's important to understand the scale at which the live entertainment industry, now especially sports, until recently the large scale concert side, engages with professional resellers. I think I pointed Councilman Allen to an article published in the industry trade press 6-7 years ago about how a Major League Baseball team had to deal with a leading broker to sell 20,000 tickets per game for each 81 home games. Now, if that reseller then had access to a meaningful number of concert tickets for a show at that stadium, they probably have a contractual right to it too as part of that deal. I don't have access to that deal.
Thank you.
You really need number 12.
Okay. I know that you have some suggestions for the bill today and are not supportive of price caps, but what do you suggest we do about scalpers and high ticket prices?
Well, first and foremost, again, I believe your bill has some provisions relative to the registration of professionals who sell tickets in the district. Other states have done this. Other jurisdictions have done this. That's an idea worth exploring. In terms of high prices, the greater the sources from which you can buy tickets, the greater likelihood you're going to find a range of ticket prices. So, you know, your question was, what can we do about high prices? I would suggest that we first start with how can we ensure that fans in the district maintain more than one place to buy tickets from so that they can choose. You can choose multiple car dealerships to buy a car, and you do better off as a consumer by that. If there was only one, you wouldn't have much choice and the price would likely go higher. There is a deep flaw in the drafting of the bill that would still allow the box office ticketer to adjust prices as high as they want. So think about that. If we cap resale, but Ticketmaster, which is got to have, I mean, I don't have the data on this, but it's got to be 95% of the district's ticketing is all Ticketmaster. Almost all tickets in the district started with Ticketmaster. This is not a mistruth. This is not a scare tactic. This is the reality of the current market because there used to be a company called Ticketfly. They used to ticket some of the local independent venues. They're gone. And Ticketmaster took those box office over as well. So the more choice we have for fans from which to pick, including against StubHub or SeatGeek, the better options they have, and the greater likelihood prices will regulate themselves to a more a modest level, including lower.
If I may add, in the submission to the Maryland AG's office, which we'll share with your office, Madam Chair, we highlighted an issue of ticket transferability. And of all bands, it was Pearl Jam, where they were playing shows in Chicago, I think their hometown. There's a law in Illinois. It's one of the 6 states that do not allow constraints on transferability. You could get in for $20 to see Pearl Jam. It was at Wrigley Field. It wasn't at a small club. By contrast, the next week, there was a show at the new arena up in Baltimore, which I imagine the Cap One Arena wants to take as many shows away from as possible. Maryland doesn't have such a law. And yeah, it was an arena, not a stadium. Nevertheless, ticket availability on resale was scarce. Prices were through the roof. So there's a lot on the supply and demand side to just be as transparent as possible and give consumers as many choices as possible.
Okay. Did you have something to add?
Just to add on that, and I'll be quick, but it certainly is, that opportunity to inject more, competition, not just in terms of, a resale market, but I think in general of, there are, people do come to sites like StubHub or SeatGeek when they are coming in from out of town, and that last minute opportunity, because they know us, because they have that affinity to us, are we able to work directly, with either small venues or with larger venues as well to meet that demand, so that we are competing on, the cost of our fees, so that the venues are getting, their share of what, and the artist as well, so that we're able to do that. And will that keep costs down, particularly when there are some of those last minute opportunities for people visiting the district?
Okay, so you mentioned fees, so that's where I was going next anyway. So what fees do your platforms charge, and are they flat or percentages? And how do you disclose them?
I believe they're mostly percentages. There may be some flat fees. Forgive me if I've got that wrong. We disclose them as required. They're broken out. We are thrilled since May 12th of this year with the new FTC all-in pricing rule. So a prior witness had something a bit disparaging about it. To our mind, it's a great new world where consumers are seeing the total all-in price, excluding taxes, as required. This was a proposal that came out of the Biden administration FTC. Lena Khan championed it. To their credit, the current FTC has continued to champion and push it very strongly as a high policy priority. It used to be the case, you come to sites and you wouldn't see the full price until the very end, nails on chalkboard for all involved. It's a much, much better world. And respectfully, the focus on fee controls in our mind is misguided, because it's the all-in price that matters, and how the economic pie is being divided among the various players is not the issue that almost all fans care about when they're looking to buy a ticket. They want to know what it's going to cost them to get in the door.
Yeah, it's approximately 20%, and yes, it is. It can vary. Here in the district, it was maybe just 20.1, but certainly it can fluctuate depending on it, depending on the event, how much availability of inventory there is, and how far away from the event. Again, we collect, the only proceeds that we earn are off of the fees that we collect, and not from the actual, charge that a seller might place for their ticket as well.
Okay, so you don't make money based on resale price?
We make the money based on the fees.
The fees.
And I would just add.
But the fees are based on the price, right? Because they're a percentage.
Quite often,
Yeah.
absolutely.
So it is more lucrative for you when the price is higher.
In certain
But only if that ticket sells. And so one of the key pieces of this conversation is that we are marketplaces.
Mhm.
We're marketplaces. So fans have the discretion of the price that they set on our marketplace, but it doesn't mean that there's going to be a buyer on the other end. So oftentimes when you hear these stories in the news about these tickets being thousands of dollars, you see them because that ticket has not been bought. Madam Chairwoman, the other thing I wanted to highlight is, as you asked the question about the fees, is also to keep in mind, as my colleague shared, that is our revenue. And so therefore, that is how we are able to have our Fan Protect guarantee, which includes 24-hour customer service, which includes the fraud protection, which includes that if they ever have an issue and they're a part of that 0.2% of fans on our site, we're able to address that issue when they call in.
I would add fees as well allow us to try to compete with Ticketmaster. They allow us to fight bots. And on a broader level, I'm very friendly and civil with my counterparts from StubHub. In the marketplace, we're trying to put each other out of business almost every day. We're fierce and bitter competitors. And one of the things we compete on is fees because competition works.
That's why I'm sitting.
Clever. Thank you for that. Saves us a lot of time later. Okay, so there's been some discussion of StubHub's debut on the New York Stock Exchange and valuation of as much as 16 billion, and that StubHub spends 14 times more on marketing than operations. So it seemed to me that you do have plenty of funding for important customer services and fraud protection. There are also resale platforms like Twickets and TicketSwap that offer the same services while also capping resale prices. So it does seem like it could be done with caps. So is this really, I mean, this is about profit specifically, like cutting into profits?
And this kind of goes to what I wanted to answer with Councilman Allen earlier, is that when he talked about the marketplaces and if a price cap would put us out of business, I think my colleague, shared, there's more for us to look at. But what's important for a price cap that I just want to ensure that the council remembers is the fact that while a marketplace like StubHub may continue to exist, there may be changes to the services, et cetera, that we may even be able to offer, as I've shared with you, how our revenue and how the fees impact. It's the fact that there are district residents here who buy a ticket to an event, a concert, who's unable to make it, and they will want to sell their ticket for more than 110%. And so therefore, the amount and volume of tickets on the regulated, safe and secure marketplaces will decrease because those sellers will want to get the best bang of their buck. The process and one of the benefits of a marketplace is the fact that fans have the discretion to list the ticket at a price that they believe meets the current demand for that. And so if there's a 10% price cap and there is a Beyonce coming into town, I can guarantee you that people are going to look for there's going to, yes, I love it. Thank you. Teamwork. But district residents who are selling their ticket, they're going to want the best bang for their buck. And so therefore they will end up on those other sites, again, without the protections that a marketplace like a StubHub or SeatGeek can offer.
Chair Nadeau, if I might add to some of the companies that you asked about, the other marketplaces, there have been many startups, and they too might be startups. I've seen some of these startups come into the market, try to offer an altruistic model like that, and they don't last. They go out of business. In fact, one that was operating in DC secretly was marking up and selling at a higher cost tickets for venues without the venue even knowing, because they realized that their model didn't work and it wasn't profitable. They couldn't stay in business. There have been more of those companies that have come and gone. Light. There have been more of those companies that have come and gone over time. The companies that have been here since the year 2000 are the ones who do allow the seller to set the price, but it comes with a great amount of value, both for the market here in the district with the millions of dollars that are paid every year in sales tax on tickets, and those pay for important services that district residents appreciate.
Thank you. Do you want another round?
I hope not to use the entire 10 minutes.
Well, I've taken 25 minutes, so be my guest.
Well, I know we have a lot more people ready to testify later, so I'll try to be less than 10 minutes. One is, I do keep hearing people talk about this as if it were a true market, and this is not a true market. There are many hands on this market, from the point of origination, from a primary selling standpoint, to the number of tickets that someone is allowed to be able to even purchase, to the individuals or the bots or the scalpers who go purchase a lot of them and then create artificial scarcity by when they release them and put them out on the market. So we should not pretend this is a free and open, true market. There are many hands on this market. And I think part of what's driving our conversation is, do we believe we need to have additional hands on this market? I think we'll all agree the market is flawed, and even from the outset, but we are trying to find ways to protect the consumers. And I don't like the answer of saying, if the person wants to get gouged or they want to gouge a neighbor selling a ticket, then they should be able to do that. Having a strategy of, I'm going to teach my kid how to go to a free concert by overcharging somebody else for the face value, I don't like that. I think that's part of the problem, rather than saying, that's a fundamentally different thing than saying, I bought 2 tickets for a show, life happened, got to change of plans and I can't go, so I want to sell those tickets to somebody else. But I wanted to focus on, Ms. Bennett, you had a good comment early on at saying, listen, one of the solutions could be just let's ban exclusive contracts. So let's imagine we're in a world where we can do that. But is StubHub a primary seller at any venues?
We do not own tickets generally, and we don't have any exclusive contracts with venues.
Okay.
Sorry, just to clarify,
Yeah.
we do work with some as a primary seller, yes, but it
Okay.
is more limited.
Got it.
It's certainly been a challenge of the market, as I think Mr. Freeman
Right.
alluded to as well, given kind of the scope and scale. But in general, certainly as Ms. Bennett referenced, we are a resale market, but opening up greater competition. And I think what we envision, as I was alluding to, was an opportunity for you to be able to go to any seller to get the ticket that you want, so that we are competing.
Listen, I love the idea when we talked about the Expedia or Travelocity being able to do that, right? I get the vision of how we, of what that could look like, and I don't disagree with you. That would be a wonderful thing. It's just not the world we're working in. And again, as somebody who supports the antitrust lawsuits against a Live Nation and Ticketmaster, agreed. But that's not the world that I'm in. And as the DC Council, I can't change that, but I can change this. And that's what we're trying to focus on. So let's though imagine our world where we actually have been able to break up and there is no monopoly on that. If we did, why would I say that I don't want to allow a venue, so that independent venue, to be able to make a choice about going into an exclusive contract? Like aren't I creating a harm for that venue if I try to limit what they can contract for?
Councilmember, where this has been proposed.
Brought it up, but
Well, I was just going to say, in other jurisdictions where this has been brought up, it's about a matter of coercion on, that comes down from Live Nation onto the venue.
No, I
So
know, I know you're
banning-
gonna take a
banning the
swing. I
ability
know
for-
you're going to take a swing at Live Nation. I'm trying to ask, like, as StubHub, like, why would you want an entity to not be able to enter into their own contract that they think is their best for their venue?
I think we're suggesting long-term exclusive contracts are what lock in entities, has been an element of the DOJ case, right? And so, if there are harms where because of that is happening, and we understand that, certainly upfront payments are a big part of why a venue might enter into a long-term exclusive contract. That makes a lot of sense, and certainly not begrudging someone be able to enter into that. But you, in your role as a council member, are trying to address kind of an industry, right? And so looking at some of the downstream impacts, but not looking at that upstream. And does that contribute to some of these other problems that may exist? Is there a better way? You said that the council could not do that in your current role, and perhaps not. I think certainly, you're certainly, one who drives hard at policies in which you believe in, council member, as my council member, right? I know you do that. But just observing opportunities to be able to open this up as a market to better improve the situation for consumers, for venues, for artists. I think ultimately we completely agree with that as a method. However, as currently constructed, we don't believe your bill does that necessarily. It's with the downstream focus is our opinion, and why we raised that exclusive contracts and addressing that as a potential avenue for the council to investigate.
Yeah. Okay. I appreciate that. And I know that we have a lot more witnesses that are going to be coming. So I want to make sure we kind of turn the panel over so we can get to that. I do want to thank you, though, because I know that there are elements of this bill that you do support. There's elements of these bills that you've added constructive feedback to. We're going to respectfully disagree on perhaps even core elements of this. But I do appreciate that I've been able to sit down with most of you here at least once. I expect those conversations to continue. And there will be areas where we disagree, but there are going to be some areas that we do agree on. I continue looking forward to working with you on that. So
Thank you, sir.
Okay, you are released.
Thank you.
Thank you to this panel. Trying to chew away from the microphone, Okay. Our next panel includes Brian Hess, Executive Director of Sports Fan Coalition, Eden Iskel, Senior Public Policy Manager, National Consumers League. Aiden Hiskias, Policy Manager, Chamber of Progress. And Colin Mortimer, Washington, DC New Liberals. All right. We'll start with Mr. Hess. Thank you.
Thank you, Chair and members of the committee. My name is Brian Hess, Executive Director of Sports Fans Coalition, representing hundreds of thousands of district sports fans who attend Caps, Nats, Wizards, and United games throughout the year. While we do work on ticketing, we also oppose publicly financed sports stadiums, push for equal pay for women athletes, sports betting consumer protections, which this council has adopted many of the ones that we proposed in the past. And we appreciate the committee's attention to the ticket marketplace practices and the consumer protections that are in this bill. It is no secret that the industry is broken, and it fails to serve fans at all levels of the supply chain. The Resale Act addresses several important issues and can offer much-needed protections to consumers. However, we hope to work with you to strengthen this legislation so it truly serves all of DC's fans. We support all-in pricing, refund guarantees, and the ban on speculative ticketing. We do have concerns about how the all-in pricing language would interact with current regulations by the FTC, or how it would react with the Federal Ticket Act, which passed the House of Representatives 409-15, a more popular bill than funding the government. Our primary concern, though, is actually the bill's exclusion of sports from the definition of tickets. This creates a two-tiered system where DC residents attending a concert at Capitol Arena receive consumer protections, but those attending a Wizards game in the same building do not. This distinction is particularly problematic given that sports tickets are subject to a significantly higher tax rate than other entertainment tickets. Sports fans deserve equal protection under consumer law. Including sports tickets would not only provide fairness, it would also strengthen the bill effectiveness and scope. Our second concern is about the anti-fan price cap on secondary market sales. While we understand the intent, international evidence gives us pause. We've heard some concerns about Ireland, as well as Ontario recently repealed a price cap after they've deemed it, quote, unenforceable. Price caps don't eliminate demand. They merely push consumers from regulated platforms with fraud protections onto the unregulated channels, like social media marketplaces. This increases risk rather than reducing it, and the risks and harms are compounded when law enforcement is not given the appropriations they need to adequately enforce these laws. We've discussed about the opportunity for savings in DC. We've analyzed several million tickets that have been resold since 2017 on the secondary market and found that fans in DC had the opportunity to save $9.1 million in that time. That's $2.5 million for the Nats, $2.5 million for Caps, and $3.9 million for the Wizards. These price caps would eliminate that safe marketplace where those opportunities for lower price tickets are available. Moreover, price caps fundamentally undermine one of the reasons why fans buy season tickets. If you are a Nats fan, I doubt you have ever made a profit on a resold ticket, except for in 2019 when they made a World Series run. We've had members in our coalition who are season ticket holders at Caps, and for every year they've been a season ticket holder and they've resold some games, they've taken losses, but it helps subsidize the cost of that package. They made back a couple extra dollars when they started reselling some tickets for Ovechkin's run to be the record goal scorer, sorry. And similarly, fans in our coalition who are DC United season ticket holders, similar experience, can never make a buck off of resale until Messi comes to town. We do share concerns that this would help Ticketmaster's monopoly in the city. We do believe it can entrench their monopoly given that they are the dominant player. And they also have been calling for this bill, this kind of protection for many years. We do support ticket transferability. We believe that combined with the all-in pricing rules from the FTC can actually empower fans to price shop and find the best price for what they need. I looked at tickets today, and if you in transferable states, you can find tickets below face value. The opportunities for those savings that I mentioned earlier in DC, when you look at states that have professional sports teams and protect ticket transferability, of which there are 4, you find that savings can almost double those opportunities to find below cost tickets. So to close real quickly, we urge you to expand the definition of a ticket to include sports. remove the price cap provision, harmonize the all-in pricing language with the FTC rule, and add robust transferability protections that would enhance consumer rights. We also encourage the council to review the Ticket Buyer Bill of Rights, which was developed by more than a dozen of the leading consumer groups in state and national levels, including the National Consumers League, Consumer Federation of America. It also offers some of the very similar protections that complement the Resale Act's efforts. We thank you for your time, and I'm happy to answer any questions.
Thank you very much. Eden Isco.
Good afternoon, Chair Nadeau and Councilmember Allen. My name is Eden Eastrel, and I'm here on behalf of the National Consumers League, the nation's oldest consumer advocacy organization. NCL is a DC-based independent nonprofit, and I'm a district resident. NCL was one of the leading voices opposing the Ticketmaster merger in 2008, and last year we were the first organization to support the AG's lawsuit against StubHub. We also run fraud.org, where we receive thousands of consumer complaints each year and offer assistance to scam victims. We are grateful for this committee's work to make the ticket buying experience better for consumers. The all-in pricing requirement is long overdue and directly addresses the problem of hidden fees that have long plagued the ticket buying experience. The ban on speculative ticketing is very important and will do much to prevent consumer harm and confusion. The refund protections, particularly in the event of fraud, are also a welcome advancement. There are, however, a number of ways this legislation should be strengthened to better protect consumers. First, tickets should be fully refundable until the day of the event if transferability is restricted. Currently, the legislation as written would allow for tickets to be both non-transferable and non-refundable. This combination leaves a consumer on the hook for significant losses if an unexpected life event occurs that prevents the fan from attending an event they bought a ticket for months in advance. Second, the carve-out for sporting events should be removed. Consumers deserve basic protections for their tickets, whether they are attending a concert or a football game. Indeed, NCL is currently suing the Washington Nationals under the DC Consumer Protection Procedures Act over the use of hidden junk fees that fans must pay to attend baseball games. Fans are also unlikely to be aware that certain events are exempted from DC's legal protections. Reasonable consumers would expect that all live event tickets enjoy the same safeguards regardless of event type. Third, the district should examine how it might realistically enforce resale price caps. To be clear, we do not oppose price caps, but the data out of Ireland and Australia is concerning to us. I believe also 300 banks in the UK have raised similar concerns. We cannot ignore this as an anti-fraud nonprofit. As fraud rates nationwide have reached billion-dollar highs, we want to avoid making that epidemic worse. The council and the AG should consider how they can realistically implement and enforce the planned price caps while also preventing a surge in unregulated ticket sales. This will likely require greater resources for enforcement and coordination with private platforms where bad actors are likely to move to, actions that maybe were not taken overseas. Ticketmaster continues to be a dominant monopoly force, one that NCL, the DCAG, and many other industry participants believe is illegally anti-competitive. According to the federal government's monopolization lawsuit, Ticketmaster handles 80% of the primary ticketing for major venues in the nation, and it represents a growing share of the resale market as well. Here at home, DC's most popular performance venues use Ticketmaster for their primary ticketing. Last month's lawsuit by the FTC against Live Nation brought to light a litany of outright lies by the company. In congressional testimony and regulatory filings, Live Nation stated that it, quote, does not turn a blind eye, unquote, to illegal resale practices, that it takes significant actions to stop bot activity. Yet federal investigators found that in practice, Live Nation has been doing the exact opposite, with an internal email admitting that the monopoly, quote, turns a blind eye as a matter of policy, unquote, assisting lawbreakers at the expense of everyday consumers. Given the context of Live Nation's repeated monopolistic and law-breaking behavior, we are concerned about potential unintended anti-competitive impacts resulting from components of this bill. For example, allowing ticketers to curate their own transferability terms could allow Ticketmaster to restrict the transferability of tickets to its own resale platform and no others. Additionally, continuing to allow ticket resale but capping prices could push out competitor exchanges that cannot operate under the reduced fee structure, while Ticketmaster's secondary marketplace could remain in business as the rest of its monopoly operation is able to subsidize any underperformance in resale. NCL appreciates the DC Council's attention to the issues in live event ticketing. We look forward to working with you to ensure this legislation protects consumers to the fullest extent possible. Thank you.
Thank you. Aiden Hiskas.
Thank you. Good afternoon, Chair Nadeau and members of the committee. My name is Aiden Skass, and I serve as a policy manager at Chamber of Progress. On behalf of Chamber of Progress, a tech industry association supporting public policies to build a more inclusive society in which we all benefit from technological advancements, I respectfully urge you to oppose, or at the very least, amend the Resale Amendment Act. I first do want to say thank you to Councilman Allen's office meeting with our team and hearing our concerns. And I should also say that although we do have partners like StubHub and Vivid Seats, they don't have a vote on or veto over any of our positions, and our testimony remain independent. First, ensuring ticket transferability protects consumer choice is essential. Tickets are often only made available by primary sellers for short periods of time, far in advance of the actual event. For fans unable to purchase tickets during that short period or who may not have the schedule flexibility to guarantee they will be able to attend an event far in advance, ticket resale marketplaces provide an alternative option. For fans who can purchase tickets from primary sellers but can no longer attend the event, ticket resale marketplaces allow them to recoup the costs. Polling shows that consumers overwhelmingly support the right to transfer or resell their ticket. Over 80% of respondents in a 2021 survey agreed that if you purchase a ticket to an event, you own it, and rules should require that you have the flexibility to give it away or resell it if you choose. Second, in the dynamic and competitive online ticketing industry, consumers benefit greatly from a wide array of resale options. This is advantageous for consumers who may not have the ideal circumstances to purchase tickets within the limited timeframes offered by original ticket sellers like Ticketmaster. Consequently, the online ticket resale market has emerged as a vital platform catering to a much broader consumer base than the incumbent sellers. As such, a ban of the sale of speculative tickets could stifle innovation in the ticketing marketplace that creates better options for consumers, such as ticketing procurement services that allow consumers to avoid the primary sale process. Rather than an outright ban, we encourage the bill to require a disclosure of speculative ticket sales. We are concerned that this bill may end valuable ticket procurement services for these reasons, which allow consumers to pay third parties to wait in line to purchase a ticket for them. Ticket procurement services benefit hardworking DC residents whose jobs do not permit them to line up the moment tickets go on sale. A better approach is to protect a consumer's right to transfer or resell a ticket that they have purchased. Third, price caps are arbitrary and effective. I know we've heard today all the different sort of sides of price caps, but here are some other studies that we have found. A 2018 report by the U.S. Government Accountability Office highlighted the difficulty in enforcing these caps, making them largely unsuccessful. The report also referenced a study by the New York Department of State, which found no definitive evidence that price caps impacted the availability of tickets for resale or resulted in lower resale prices. A 2010 analysis from the Cato Institute, which looked at resale prices across 3 seasons of the National Hockey League, found no significant difference in ticket prices between markets with price caps and those without. Repealing resale price caps had zero change in prices, indicating that such policies are largely ineffective. Worse, in some cases, price caps can harm consumers. For instance, in June 2023, the resale restrictions for Taylor Swift's Eras Tour in Australia highlighted how price caps drove fans to unverified websites and social media platforms, exposing them to scams and fraud. Police reports show that over $260,000 were lost to scams related to counterfeit tickets for just one tour. Fans who saw alternative channels were left without recourse when their tickets turned out to be fake, demonstrating how price caps can drive transactions into untrustworthy environments where consumer protections are non-existent. Lastly, the value of a ticket should be what a consumer places on it. At the core of consumer rights is the freedom to enjoy and utilize their purchased ticket. For example, season ticket holders can sell their tickets to sports games they can't attend or if their team isn't doing well. If their team is playing a premium opponent, the resale of the ticket helps offset the costs of increasingly expensive season tickets. We have provided additional points in our written testimony, which has been submitted, and I'm happy to follow up with any other resources to your office or to anyone on this committee. But for these reasons, we respectfully again urge you to oppose the Resale Amendment Act. Thank you.
Thank you. Colin Mortimer.
Thank you. Good afternoon, council members. My name is Colin Mortimer. I'm here on behalf of the Center for New Liberalism, an international network of pragmatic progressives advocating for evidence-based policy But in this specific case, our local chapter, the DC New Liberals, I've been a resident of DC for over half a decade. I've lived in both of your districts at some point. I'm very proud to live here and love this city a lot. I want to speak a little bit from personal experience when it comes to ticketing. I have a frequent concert goer here in DC. I just actually bought tickets for Kishibashi while sitting over there because they just came up on sale for Lincoln Theater. The fees were eye-watering. And I really applaud the council for taking up this issue and trying to figure out a way forward. I think there's been a lot of constructive conversations, and we're happy to be a part of that. We actually also have personal experiences from the international examples that have been brought up today. So first off, I'll start with I'm a huge soccer fan. I go to the UK often, and every time I'm there, I try to buy tickets to matches. Because of the regulations there, you can't buy them online. And I have had many, many weird meetings with people in basements of pubs trying to buy tickets, and it's not a fun experience, and they're probably 10 times over face value. It hasn't worked in the UK. We also, as an international network, have chapters in Melbourne and Dublin, and our chapters there have seen the ramifications of the legislation that has been passed there, and the fact that those governments are trying to walk back some provisions in those bills because they have blown back. I was actually in Australia last week meeting with the Minister of Finance for the state of Victoria, and I mentioned that we were doing work on this here in the United States. And he mentioned that while they are happy that they passed some rules and regulations, that they were also trying to fix some of the more troublesome parts of it because they have seen an increase in organized crime as a result of the restrictions in the state. The measures today proposed are mostly good. We are in support of the all-in pricing model, and we think that's great. But some measures will limit fans' ability to buy tickets, not expand it. The primary ticketing market, which we've heard many times, is dominated by Live Nation Ticketmaster, already burdens fans with excessive fees, poor service, and frequent system failures. Yet, instead of addressing these problems, the act targets the secondary resale market, the one place where consumers still have some alternatives to that monopoly. Everywhere, as I mentioned, similar legislation has appeared. Live Nation Ticketmaster has lobbied aggressively to entrench its dominance, often joined by venues tied to the platform. I'm not here to argue that the venues are here on the behest of Live Nation Ticketmaster, as Chairman Allen brought up earlier, Mr. Allen brought up earlier, but that there is a close relationship between the two. Price caps also don't stop price gouging, as I mentioned. It just drives it underground. The study's been mentioned. I've talked about the personal experience and the anecdotes that I have heard. And we're also too familiar with in-person ticket scalpers. Obviously, it's much less common than it used to be, but it is still something that we see, even though it is illegal in DC to scalp tickets on event grounds. It has happened in the past, and we believe it'll become more common if this legislation is passed. The part that we are most concerned about in this legislation is the restrictions on transferability. This is just a blatant move to make it harder for consumers to give tickets to others and entrench Live Nation Ticketmaster's monopoly. It doesn't stop scalpers. It just punishes fans who want to give tickets to others. And I know we talked a little bit about license versus whether tickets are licenses or property. We believe tickets should work just like any other product. If I buy a car or I buy furniture and I want to resell it at a later date, I could do so on an online marketplace, and we believe tickets should work the same. So as a local concert goer myself, I know how vital a free and competitive market is in keeping live events more accessible. I urge the council to reconsider certain portions of this bill, but we do hope in the end that they will pass a modified version of it that maintains consumer protections and makes the ticketing market more fair and more free. Thank you.
Thank you all very much for your testimony. Did you have any questions for this panel? Sure, go ahead.
Thanks, I appreciate it. And I apologize, I have to step away at 3:15 to go to another meeting, and then we'll find my way back here in a little bit. First off, thank you all very much for your testimony. Mr. Hess, you correctly point out the difference with the way that sports events are handled with proposed legislation versus a live concert, for example. And part of that simply was just the way that people often purchase sporting event tickets. So with, I don't buy a season ticket package to the Anthem or a season ticket package to the 930 Club. Usually people are saying, I want to go for a discrete event for a certain artist that I want to go to, whereas sports work differently. That said, I take your point around trying to make sure we have protections in place no matter where you're going. So certainly we'll take that into consideration. I think that the distinction between the way that sporting events and season ticket packages work compared to live entertainment events, like a concert or a theater performance, are just different. And so that's why you see it reflected differently within the legislation. But I hear your points around making sure protections are across the board. So we'll definitely take that back, and I appreciate it. A couple of you mentioned data and reports, especially from Ireland. I will say it wasn't a study, it was a poll that was done, paid for by StubHub. So I do want data. I think we've heard both. We had a witness earlier on a panel who said, here's what they believe the data said in Ireland, which was completely contradictory to the other evidence. People said, well, here's what this poll found in Ireland. I do think we will all be better policymakers by getting good data. So I welcome that, would love to get that feedback from Ireland, from Australia, from other places to help inform the decisions that we make. Because I think, not my first rodeo, we're gonna have people to kind of trot out reports on showing what they want it to show, and I really want to hear that feedback. Were you able to jump in?
If I may, yes, I agree with you. The Bradshaw report is, I think, a good jumping off point, and it does provide some concerning information and data. But it's really the first study in years, and I think one of the first that I have seen in my nearly a decade of ticketing policy that starts to really pick at this, because price caps are a new policy proposal, or they're coming. There were some anti-scalping laws that had price caps that were almost entirely repealed. When we talked about Massachusetts being repealed last year, they've not become a popular policy proposal until very recently. And we've seen more and more crop up in the last year or so. I do think that we need to be researching this topic more. And I think that a report out of the city, and I don't know which body within the city government would be the best one to do such a report on, would there be more fraud, would be a good idea, and kind of a way to get that information so we are making informed policymaking decisions.
Agreed. We can probably agree that just a poll probably isn't the type of data that we actually need, though, that we actually need.
Yeah, so we need economic data.
Yeah. Ms. Hiskias, did I pronounce that correctly?
SCAS.
Hiskias, sorry. You had mentioned in your testimony you wanted to amend the speculative ticket ban for ticket procurement services. What's the company that would do that?
Can you repeat the question?
You mentioned in your testimony that you would want to amend the speculative ticketing ban to allow for ticket procurement services.
Yeah, so we just wanted clarification. We understand the fear of speculative tickets, particularly with bad individual actors. But for those like StubHub and Vivid Seats that provide refund, that provide sort of the consumer protections, we would like some type of exemption or exception if possible that carves out that they're not part of that, if that's something that you're interested in. Essentially, that consumers should still have the choice of going to all the different platforms and having that competition amongst the marketplace. And so if that's something that they're willing to go to, knowing that it's a safe space for them to buy tickets, that is reflected in the bill.
But I mean, my concern would be how do I have a StubHub or a Vivid Seats? How can they guarantee that someone's going to get a ticket to an event before the ticket actually goes on sale?
That's a conversation with StubHub and Vivid Seats. I can't speak on their platforms, but I'm sure that's something that they could discuss on sort of guaranteeing some type of consumer choice protections.
They can't guarantee a thing they don't have. I think a speculative ticket's a fraudulent ticket. It doesn't exist. No one's actually gotten it yet. And so that's why I think we've heard pretty across the board people all saying like the idea of speculative tickets is just not a good idea.
I think we view it as like constructive possession. So although it's not necessarily in someone's hand, there might be a bucket of tickets already available. But then
they'd be in their hand.
Not necessarily in their hand, it would be, online.
I think it's a dangerous can of worms to open to try to allow that. And I think frankly, we heard from some of the folks in the resale market themselves saying, we don't think that's a really good practice. That we heard those representatives saying, we try to shut it down when we find it. So I don't think that's the right way to go. Let me talk for a second about the ticket transferability provision. Under our contract law, it's a license, right? So that's the contract that they say you have a license to the seat. It's not an actual piece of property yourself, right? Much in the same way, again, I jump on a flight or I'm going to go catch a train ride up to New York. I can't just hawk that off somewhere else. And there's a reason why we have those seats as licenses. There's another reason that didn't come up today, but it did a little bit from the standpoint of we want to create a safe environment for everyone to go out to and enjoy a show, no matter where they are. Many of our venues, there are individuals who have gone to those venues before, and they are not permitted to come back. They have either acted in ways violently in the space, they have sexually assaulted or harassed members of the staff or others there. There's a reason why certain individuals say, you're not allowed to come here. If we do away with a license and just move to pure ticket transferability, the venue itself no longer actually is able to say, that person's not allowed here. They've sexually assaulted the staff. They have started a fight in here, and we have decided that person cannot come into this space. So I think for a variety of reasons, I'm really concerned about that. I'm going to, again, level set an assumption that every single person in this room does not want to see somebody who has committed sexual assault or violence. You're not advocating for that. I don't want that to be the takeaway here. But that's one of the collateral consequences I'm concerned about with just pure ticket transferability, is that the venue itself no longer has control or the ability to say who's coming and going inside their space, especially with someone who maybe has actually caused harm or violence in that space.
May I respond to that? 100% agree with you. Virginia's law allows for venues to not allow people to enter who are either on that list of people who have mistreated staff or just banned from the premises for whatever reason, or being underage, which is another concern. We support that. We do believe the venue should have control over the policing that happens for the behavior in their venue. I'm not going to argue with that. Where, to me, it starts to get a little loose when they talk about how transferability won't let them do that. I don't know the last time I've walked into a venue and given them my ID and had them run me against a list. You know, usually it's either if I'm going to a 21 and up event, they check that my driver's license is horizontal, and I go about my day. I have a Virginia license. I don't know if DC's 21 and up are horizontal. So that's where, like, whereas if we did have the transferability protections, they would still be empowered to enforce that if they had, you know, the Facebook of, you know, here are all the people who are banned from the venue, and they had the bouncer who knew the people. They would still be well within their rights under the Virginia law to enforce that. I think I want to echo, though, what my colleague here said about refundability. You know, the idea that the company's going to choose to restrict a consumer's ability to transfer their ticket, and then not give them any kind of recourse for the day of. I mean, it's if something happens the day of the event, we had, you know, if you got food poisoning in the morning of, right, you can't come to the event. It's going to be hard to resell that ticket and recoup that money that day of the event. But at least under a transferable law, there's an opportunity for that. If you're going to restrict that, you should give that fan the ability to get their refund and get their money back. You know, you don't want people who have COVID feeling that they need to go to an event because they spent $200 to get that ticket. So that's one way where I do think.
I think that hits the refundability to others. So I have to step away at this point because I'm going to run to another meeting here. So I'm going to hand it back to the chair. Take your point, though, on the refundability piece. So again, appreciate everybody's testimony today. Thank you very much. Thank you, Madam Chair.
Thank you, council member. Thank you very much to this panel. Okay. Our next panel is our last in-person panel, and then we'll switch to our witnesses online. It includes Carly Harvey, Cynthia Johnson, Dustin Brighton, Director of Government Relations, Coalition for Ticket Fairness, and City Tour. Thank you for letting me know. I know, long day. Okay, so if there's anybody else here in the room that wishes to testify in person, that either you didn't hear your name called earlier or you didn't sign up, but you're here now and you really want to do it, now is the last call. So we're not going to do any more in-person witnesses once we switch to Zoom. Okay. Right. Do we have Carly here? No. Cynthia? No. We have Dustin? Dustin Brighton, okay. And then who are you, sir?
I'm City Torre.
You're City Troy.
yeah, thank
Okay,
you.
Cynthia. Okay, got it. Very good. Misheard over there. Thank you.
Thank you, Madam Chair. Good afternoon, Madam Chair, members of the committee. My name is Dusty Brighton, and I am here on behalf of the Coalition for Ticket Fairness, which is a coalition of supporters, platforms, and others who wish for open transferability with regard to tickets. Thank you for the opportunity to testify today on Bill 26-224. We applaud the Council's pro-consumer focus and commitment to ensuring fair access to live entertainment. These are goals we strongly share, and we would welcome the opportunity to work with the Council to develop balanced pro-consumer policies that truly expand fairness. Although well-intended, certain provisions within the Resale Act will have significant unintended consequences, most notably cementing Ticketmaster's indisputable monopoly in the ticketing market. To be sure, unless this legislation addresses the broader anti-competitive realities of the ticketing marketplace, in particular, Ticketmaster's overwhelming dominance, it will certainly inflict additional harm on the very consumers that this legislation was intended to protect. For context, the ticketing market is adversely dominated by one actor, as I've stated, which is owned by Live Entertainment, Inc. Live Nation has a market capitalization of approximately $36 billion and currently controls 80% of the primary ticketing market in the United States. This percentage of control is almost certainly higher in the district where Ticketmaster manages the ticketing services for IMP, which owns the 930 Club, the Lincoln Theater, the Atlantis, and the Anthem. Because of this dominance, Ticketmaster not only manages the vast majority of initial ticket sales, but also dictates the terms of those sales, what fees are charged, whether tickets can be transferred, and whether venues may work with the competing platform. With its market share, Ticketmaster pressures artists and venues into exclusive contracts that foreclose rivals, reduce consumer choice, and inflate prices, again, enforcing its monopolistic power. Between 2019 and 2024, consumers spent more than $82 billion on Ticketmaster's tickets, including $16.4 billion in fees alone. In short, when it comes to manipulating the ticket market and injuring consumers, there is no single entity here more culpable than Ticketmaster. And I would reference, as Mr. Freeman said before, there's a reason they're probably supporting this, and they're not here to talk. This is not just our view. It's the basis of multiple federal actions. In May 2024, under President Biden, the U.S. Department of Justice joined the attorneys general of 30 states, including the District of Columbia, where they filed suit against Live Nation, alleging, among other matters, that Live Nation is guilty of excessive fees and price inflation, restricting ticket transferability, and restricting competition. In addition, just last month, the Federal Trade Commission, joined by 7 states, brought yet another lawsuit against Live Nation, alleging deceptive and anti-competitive resale practices aimed at suppressing competition and leaving consumers with fewer choices and higher prices. Specifically, the FTC alleges that Live Nation engages in hidden fees and deceptive pricing, conspires with select brokers to circumvent its own stated limitations on ticket purchases, which pushes consumers out of the primary market, fails to enforce the requirements of the Federal Better Online Ticket Sales, or the BOTS Act of 2016, even though it has the ability to do so. Together, these lawsuits allege, among other things, a long pattern of deceptive pricing, profiting from the reseller market and bots, exclusionary contracts, and other forms of anti-competitive conduct. As drafted, this legislation will do nothing to reduce Ticketmaster's market power. Indeed, it risks cementing this power by codifying policies that ultimately raise costs for fans while limiting alternatives. Now, I'd like to turn my attention to certain provisions within the Resale Act, including the discussion of price caps. One of the central provisions of the Resale Act is the imposition of a 10% cap on resale on the total price of the initial ticket. At first glance, this may sound consumer-friendly, but in reality, it does nothing to address the true driver of inflated costs, Ticketmaster's fees. As drafted, the 10% cap only to resellers and only on the total price of the initial ticket. This leaves Ticketmaster free to add unlimited fees on top of the initial ticket price. According to the FTC lawsuit filed after the introduction of the Resale Act, Ticketmaster's fees can reach 44% on top of the initial ticket price. That means resellers are capped at 10%, but Ticketmaster can still tack on fees 4 times higher, leaving fans with no protection against the real source of inflated prices. As a result, the bill locks in Ticketmaster's broken pricing model. Consumers would remain exposed to unchecked charges while independent resellers are pushed under limits that do not apply to the dominant player. In this hearing, you will hear later from Professors Jennings and Happel, who will explain why price caps do not work, including how they drive consumers to unregulated platforms that fail to protect consumers. True consumer protection depends on free markets and transferability. That means ensuring fans can transfer retail tickets without restriction. Unfortunately, the bill's current structure opens the door for Ticketmaster to manipulate that process using their market power to restrict or pressure venues. The CTF is also open to a meaningful and appropriate registration system that applies to both primary sellers and resellers. However, the current language does not allow that. On bots and speculative ticketing, resale, we support going after bad actors that utilize bots. As far as speculative tickets, we would urge you to look at the federal act that has been proposed, which states that with regard to speculative ticketing, there has to be a disclosure that it's a speculative ticket, and there are penalties if that order is not fulfilled. Thank you very much.
Okay, thank you so much. Mr. Toure?
Hi, I'm Mr. Torre. I'm a longtime DC area resident, musician, and former cybersecurity IT consultant. So I just wanted to speak on behalf of people who understand the dangers of bad software in general and bad economic policies. Overall, today we've heard a lot about Ticketmaster and Live Nation, and it seems that we've put up a seemingly walled-off garden of false choices between the prevailing market conditions in ticket sales in DC and what could be a better future if this legislation is passed. So we had heard earlier about fees and whether they're parts or not parts of the revenue streams by StubHub and these other ticket resellers. And I can give you a personal example from 2018 where a ticket I had bought was $6, another ticket was $6, and the processing fee was $12.70. So that's right there, 100%. And so if we're going to have an economic system where what some will call dynamic pricing, it's frankly price discrimination. We have that in airlines already. We have that in hotels, where the market price is not presented, but the shadow price is presented within the offices of these corporate executives and predators in, frankly, every aspect of life. It's becoming unbearable, frankly, if you are someone who likes to do math and understands math, that you see effectively derivative trading in every aspect of life. So the specific example of tickets is that were we on Wall Street, okay? An asset is priced at a certain level. An asset is priced with fixed conditions and fixed terms, okay? So if we have the example of Wall Street and we talk about ticket prices going from any number, any reason, any number to any other number, frankly, we can't call that a market. It's no longer a market. It's just not the rules of a market. Markets generally have conditions, and this concept that a free market in this regard, and we've heard others talk about comparing it to automobiles, and these are not congruous products. We're going to end up in a situation where consumers have absolutely nothing left to go on, where, again, every single transaction has been swallowed up by corporate software. And this is, a great example of a place where we can start to use these tools, as in price caps, and move that along to other parts of the DC market that are not, let's be real, not as important necessarily as the housing integrity we talked about earlier or the CPBA from earlier. That's all I really wanted to say in general, but I see this as a great opportunity to start targeting industries that have been engaged in market manipulation, price gouging, And frankly, again, using one bad actor, Ticketmaster Live Nation, against another bad actor is not necessarily the way we can, fix our issues here in the arts, culture, and sports community in DC.
Thank you. Thank you both very much for your testimony. I appreciate it.
Thank you.
Okay. We're going to move now to the Zoom portion of our hearing. We are on witness number 56. We are pressing on. Our first panel online includes Bill Spieler, owner of the DC9 nightclub, Will Eastman, U Street Music Hall Presents, Alicia Edmondson, Songbird DC, Kareem Karefa, the Lincoln Theater, Sam Myers, the Association of Performing Arts Professionals, and Sharon Tapper, Executive Director of Music Managers Forum, US. And it feels a little bit like being back on ANC 1B with this lineup, which was not a bad time, so that's okay. All right, Mr. Spieler, you may begin.
Can you hear me okay?
Yes.
Thank you, Chairman and the Council, for allowing me to give my testimony today on this great legislation. I want to let everyone know that I sat on a roundtable of the Federal Trade Commission back, I think, 6 or 7 years ago, where they had Live Nation, Eventbrite, StubHub, and many other ticketing companies. And I thought when I was going there, I was going to hear the Federal Trade Commission's idea on how to combat exorbitant ticket prices that were on their platforms. Instead, really, all they wanted to focus on was all-in pricing, which we now have, and I think is a great idea. Unfortunately, they didn't really tackle the ability of prices going out of the roof, which is why we're here today. I want to tell you a story that happened in DC9 2 weeks ago, where a father and daughter came to a show. They had purchased tickets on StubHub because that was the first platform that they saw the tickets available on. They came to the show, didn't realize that it wasn't our platform, and went on to try to get their tickets downloaded from StubHub. I ended up hanging with them for about 20 minutes trying to get the tickets available to them with no luck. I ended up selling one of our tickets to them because there were tickets available on our platform, and came to find that our $20 tickets they had purchased for $40 each. Which they had no problem paying. I told them to get with StubHub, that because they will refund their tickets, because they weren't able to get them. So I'm sure they got their money back because StubHub is really good at that. What concerns me is with them paying $80 instead of $40 for my ticket, that the father might have been in a quandary of if the daughter wanted to buy a $30 t-shirt from the band, that maybe they couldn't afford it with their $80 tickets if they had actually been able to use them. And for that band that was selling that $30 t-shirt, that could mean the difference between getting a hotel that night or not. So when prices of tickets are really high, people have to juggle whether spending money at the venue or buying merchandise for the band, whether they are able to do that or not. And that's about all I have. And I thank you for your time.
Thank you for your testimony. Next, we have Will Eastman.
Hi, can you hear me? Thank you for allowing me to speak today about this important legislation. And my name's Will Eastman. I've been an independent promoter in DC for 28 years. The music that we champion is left of center. It's stuff that might not come to DC if it weren't for promoters like myself who take the risk to bring it here. I did prepare a statement and testimony that I submitted, but I'm not going to read it. I would like to speak from the heart and respond to some of the comments from the previous 3 panels. Don't let StubHub and the other resellers gaslight you. They are massively capitalized to dictate the terms by which they can steal equity from DC constituents. We heard from members in these previous 3 councils, scary terms like black market, black alley resellers. One of them even mentioned organized crime, lack of consumer protections, and detrimental unintended consequences. What they're saying is basically disregard the evident and obvious black market because something worse could happen. Now, I want to push back against this. StubHub representative earlier literally said, we do not own tickets. Selling something you don't own is fraud. That's theft. They're stealing from the artists and hardworking businesses in DC. Now look, the total value of US live concert ticket sales in 2024 is estimated to be $6 billion. StubHub is now a public company. They went public last month, and their current market capitalization is $6.6 billion. Their annual sales for 2024 were approximately $8 billion. That's a 27% increase from the previous year. So they could be $10 or $12 billion next year. Now, they also have $2.4 billion of leveraged debt. This is incredible capitalization that they can use, right, to buy massive web tracking campaigns. This is Google. When you search for an artist, Keoki, DC, 930 Club, does the 930 Club link show up? No, the StubHub link shows up, right? They're stealing the visibility from promoters like myself who take the risk and sometimes lose money on these shows, right? We lose money on a show and we need to do another show to make it up. But if that other show doesn't make the money, then we're hurt. Now, look, here's the way that predatory ticket resellers hurt the live music industry, okay? When reseller bots purchase bulk tickets and jack up the price, now the audience doesn't blame the reseller, they blame the artist and the promoter. That's reputation damaging, okay? When an illegitimate ticket is sold, that equity goes into the pocket of the reseller, does not go into the pocket of the artist or the promoter, right? And the fan base goes from a egalitarian, first come, first served environment to an elitist environment. Like that college student who can maybe afford that $40 ticket isn't going to get to that show because the stockbroker paid $400 for that ticket. Now that's not fair. The artist in the venue should be able to dictate who can come to their event. And I heard a lot of these people earlier talking about widget sort of stuff. Like a live performance is a car or a house. It's not. It's a spiritual, temporal thing, right? Artists today rely on live performance to earn their living. In the Spotify world, right? You get less income. You got to go on the road. You got to earn money. These predatory ticket resellers steal equity from artists. They steal equity from venues and promoters who hire the stagehands, the bartenders, the people who live in DC, your constituents. They eat in DC. They pay rent in DC. They fight for equity and justice in DC. They're your constituents and they're ours. Let's do what's right for them. Thank you for your time. Thank you for bringing this legislation. It's important. It could change the whole game. It could spread around America. I hope it does. Thank you.
Thank you very much for your testimony. We'll now hear from Alicia Edmondson.
Hi, my name is Alicia Edmondson. I'd like to first say, can everyone hear me? Okay. I'd like to first say thank you, Council, for taking this on and for listening to this very long testimony. I'm one of the owners of Songbird Music House in Northeast DC, and I'm testifying not because it's really hurting our venue in the direct sense, because I do use a ticket platform that does keep most ticket bots away, but it does hurt our fans and our ecosystem, which then involuntarily does hurt all venues. And when we're talking about third-party ticketing, we're actually talking about like an industrial scale profiteering of scalpers using bots to buy up tickets, spec tickets, and creating a false sense of scarcity and duping fans into actually buying tickets, not on the primary market, but on the secondary market, when there's still plenty of tickets that are affordable for the consumer. And what this does is it creates a fake sense of scarcity. It creates a higher ticket price. And ultimately, the higher the ticket price is, like if a customer goes and buys a $1,000 ticket at the Anthem, through third party, they can't afford my $20 up and coming artist. And if they can afford to go into debt and still buy a ticket to one of my shows, they're not going to feed into our music economy. They're not going to buy that ticket, that t-shirt, like Bill said. They're not going to eat or drink at my place. They're not going to eat or drink at a restaurant next to me. They literally spent all of their money on that really expensive ticket. And I heard a lot about StubHub, or I think Bill even said that they refund tickets. I'll tell you something that happened 2 weeks ago at my venue. We don't often get scalp or fake tickets, and they all are fake because we do use Dice and we have a peer-to-peer ticket sale system, and any ticket that's coming in outside of our system is fake. This person came in, they had bought a $99 ticket from StubHub for a sold out show. We couldn't let them in. And then they actually told us that it wasn't that they bought the ticket. It was a refund that they got or a credit they got because they had already purchased a fake ticket through StubHub, and they used the credit to buy another fake ticket to our show. So they had to basically get an Uber twice because they went to 2 fake shows just from trying to buy a ticket on StubHub. It's just really disheartening. And I heard a lot today about how these third-party companies are talking about how this is going to help Ticketmaster. No one here is a Ticketmaster or Live Nation venue. We're all independent venues. These are independent consumers that are being hurt. I don't think that probably maybe 1/4 of all venues in DC sell with Ticketmaster, and that's probably all stadiums. Most tickets are going to be independent. So this isn't helping anybody except for the consumer and for these small venues that just want to be able to sell affordable tickets and have a whole ecosystem where people can afford to buy band shirts and people can afford to consume products when they're in our space. I also heard a lot about how there's all these studies that talk about how 10% cap, doesn't work and creates all this fake tickets. Those are all, there's no credible independent study that says that. These are all paid for by StubHub and other third-party members that are saying these scare tactics that aren't true. If you look at Australia and most of the European countries, 10% cap creates very viable, thriving markets where consumers can pay affordable prices for shows and then feed into the whole ecosystem that shows provide. I also heard some stuff about how they wouldn't be able to survive if they paid 10% cap. Tixer is one that does do a 10% cap. They survive. They make millions of dollars in net every year. So what's survivability? How much profit do these companies need to make off of everybody else's work? This argument that they won't be able to survive with the 10% cap, I don't think anyone on this Zoom call is making 10% profit. It's crazy to think that a 10% cap is this horrible thing that we're asking for. It just means that it's going to consumers and that we're protecting the consumers that love live music. I think my time's up, so I'll end there. I had some other things to say, but I don't want to, it's been a long day.
Thank you. I appreciate your self-awareness and your testimony. All right. Kareem Khalifa.
Can you guys hear me?
Yes.
Okay, great. Thank you for taking the time to listen to my testimony. As you spoke before, I am an employee of IMP who runs the Lincoln Theater. And the Lincoln Theater is very specific because it is a seated theater, 1,200 seats, and we do a variety of shows. We do concerts, we do podcasts, We do some community events as well. And trying to navigate, as Bill mentioned, operationally, it falls differently when you have to deal with someone who has been issued a ticket that is either fake, a duplicate, or some other circumstance in real time. And a lot of times what that is that they come to the window. I have a ticket. They go to the door. It doesn't scan. They go to the window, say, hey, I have this ticket. It's not scanning. Well, you didn't get that ticket from our website or through, direct links connected to the Lincoln Theater. You got that from a second or third party seller. And when you Google tickets for a specific concert, a lot of times, if it's at the Lincoln Theater or the 930 Club, the Lincoln Theater or 930 Club is not the first option that comes up. It might be the fourth or fifth option. So a lot of these other second-hand resellers are coming up in searches before the actual primary venue that's actually hosting the concert. So with Lincoln in particular, a lot of times it comes down to seating issues. We have, duplicate tickets and we have one seat. So two people, for a concert have a ticket for seat 101 in row K. How do we solve that in real time? How do we accommodate both parties now that they are both in the building? Both want to be sat, both want to make sure they have a good sight line. And if it's a sold out show, how do we accommodate these two people and have them satisfied by not sticking one in the back of the house in the balcony when they assume that they have a ticket that's in orchestra, maybe 3 rows back from the stage? So these are the things that happen in real time operationally when we are trying to deal with these ticket issues. And I think that there needs to be more regulation for it because we those of us who are operators have to manage this, as I said, in real time. I understand that there are different vantage points about how this should be done, but for those of us who are boots on the ground, this is a problem that we see just about every show. And it impacts the artists as well. If a bot grabs 100 or 200 tickets and the artist assumes that those tickets have been sold, and when the artist shows up and their show is not filled, they have questions for us. Why does the room look like this? Why are we not, the amount of tickets sold doesn't match what's in the room. Now, we do understand at times there's always a portion of people who do not show up to concerts because they can't. Things happen in life, but it impacts the artists as well. And they're not happy when they, feel that the tickets have been sold or put out in the market, but it's not showing up in real time when it's time for them to perform. So these are some of the things that we go through, as well as we also deal with some promoters and clients from underserved communities who put on productions or plays and may not have the capital to take a loss or a hit of 100 tickets being grabbed from their production and kept in a cart or being sold on another platform. And it undermines their marketing dollars. It undermines their ability to break even or even make a profit because they are a smaller production, a smaller company who's doing business with us, and they don't have the capital to actually take a hit like that. So it affects a lot of different people when these different ticket issues come up for us in particular. So those are just a few examples of what we have to deal with in real time as operators when we have these ticketing issues, whether it be bots, secondhand sellers, and even if they do provide refunds, it's still an inconvenience for the person who is standing at the venue wanting to get in. And it's not just a singular person. Sometimes it's 5 a night, it could be 10 a night. That's quite a handful of people to have to say, I'm sorry, we can't honor your ticket because it's actually not a valid ticket and we're sorry to send you away. We don't want to do that, but we have to. And also it's also an issue of capacity. We have to be careful to make sure that the tickets that are sold match what we allow in the building. So there are different things that we have to keep an eye on. That is my time. Thank you for hearing me.
Thank you very much. Sam Myers.
Good afternoon, Chair Nadeau and members of the council. Thank you for the opportunity to be here. My name is Sam Myers. I'm speaking on behalf of the Association of Performing Arts Professionals, or APAP. Established 70 years ago, next year we are a DC-based national service organization representing thousands of arts presenters, venues, artists, and agents who connect audiences with live performance. We are here in strong support of the Resale Amendment Act of 2025 because this bill tackles predatory, deceptive ticket resale, which is one of the most damaging and least visible threats to live performance. One example, here in the district, one of our members witnessed the ticketing app Fever Labs sell tickets to their show and then refuse to pay the artist's share. That isn't entrepreneurship, that's exploitation. It cheats the artist, it misleads audiences, it drains money from our local creative economy, and it's not an isolated case. A few more examples. In California, Livermore Valley Performing Arts Center routinely finds its own listings buried under search engine ads from third-party resellers charging 5 to 10 times the real price. Audiences walk away incorrectly thinking the programming is not for them. In Utah, a Cache Valley Center for the Arts patron paid $600 for tickets that were really $14 each because the fake sellers' branding intentionally looked identical to the venues. And in Michigan, the Wharton Center loses thousands every year to resellers who buy tickets, resell them, then file false chargebacks after the show. Different zip codes, the same story of companies using bots and deceptive websites to intercept real tickets before they ever reach the box office. These are digital shell games, profitable only because enforcement hasn't kept up. Every fraudulent transaction undermines audience confidence and comes with a human and economic cost. Families show up at the door with fake or overpriced tickets and are turned away in tears. Small nonprofits often comp these patrons out of pocket just to protect their reputation. It demoralizes patron trust and stains the experience. And there are ripple effects. Fewer repeat buyers, lost donations, higher barriers to access, especially for low-income residents, seniors, and young audiences. When a $30 ticket becomes $150, it's not just a personal loss, it's a cultural accessibility issue that prices people out of DC's vibrant arts life. The Resale Act gives the district the tools to fix what the federal government and most states have not. It caps resale prices at no more than 10% above face value. It bans speculative tickets or the sale of seats that don't even exist. It requires reseller registration, transparency, and all-in pricing so buyers know exactly what they're getting. And it holds platforms accountable for blocking the bots driving these gray markets. These are not radical ideas. They are consumer protections that legitimate ticketing companies and artists already support, and how DC can go much further to set the gold standard for fairness and live entertainment. This city is home to world-class venues like the Anthem, the 930 Club, the Lincoln Theater, and historic neighborhood theaters, jazz clubs, and community stages. We are the birthplace of go-go, a cradle for jazz legends, and the city that helped move punk rock from violence to personal responsibility. DC's creative pulse runs deep, and we can continue to show that. By enacting the Resale Act, the district can show that it values transparency, culture, and vitality in creative labor. In closing, every legitimate ticket sale supports more than a seat in a theater. It pays a sound engineer, a stagehand, a bartender, a metro ride, a restaurant check, and more. It keeps the lights on for artists and for small businesses that thrive around live events. But without decisive action, these predatory resellers will continue to drain millions from the district's live performance economy, not by creating value, but by fostering and exploiting confusion and chaos. With your leadership, the district can restore fairness and trust and ensure that the joy of live performance remains accessible to visiting consumers and those who call DC home. Thank you for your time and for standing up for our audiences, our venues, and our artists.
Thank you very much. Sharon Tapper?
Thank you. My name is Sharon Tapper. I'm the Executive Director of the Music Managers Forum, US. We were established in 1993, and we are the leading trade association for professional artist managers and self-managed artists in the US. We are a registered 501c6 nonprofit, and our mission is to educate, connect, and advocate on behalf of the artist management community. We support professional development, fostering collaboration, and advancing fair and transparent industry practices. I'm here today because we represent a nationwide community of more than 14,000 members and affiliates, and reflect the voices of artist managers and self-managed artists across all genres and all stages of career development. We have 8 active chapters nationwide, with more proliferating. We're in LA, New York, Nashville, Miami, Chicago, Austin, Boston, and Atlanta. As artists and members of the music community, we rely on touring for our livelihood, and we value music fans above all else. The current ticketing system is broken. Scalpers and secondary platforms engage in predatory and deceptive ticketing practices to inflate ticket prices and deprive fans of the chance to see their favorite artists at a fair price. No one cares more about fans than the artists. And when artists lose the ability to set the price a fan pays for a ticket, they suffer. Scalpers do not care about the relationship that the artists and fans share. They care about siphoning money off from the ecosystem for their sole benefit. None of that money from those inflated prices go back to the artist, the venue, or those who are responsible for the creation of the show itself. Scalpers have gone unregulated, or they use illegal bots, speculative ticket listings, sophisticated pricing algorithms, and deceitful advertising, and all of this causes real harm. The relationship between artist and fan, which forms the backbone of the entire music industry, is severed because of this. And it takes many, many years to foster these relationships and a moment to break it. Fans are locked out of tickets at initial on sale or forced to turn to secondary pay inflated prices. They're lured in by deceptive URLs and advertising tactics which disguise resale and trick consumers into paying many, many times its face value, while often the face value of the tickets are still available from the venue itself. And they also illegally use the name and image and likeness of the artist or the venue. When a scalper lists tickets for a show before they even go on sale and doesn't even have the ticket in hand, it is intentionally deceitful. These predatory practices are hated by consumers and artists alike. The scalpers invest nothing in creating a great live experience and take money from fans without compensating the artist or those who make the show possible. On behalf of our members, we strongly support the Resale Act. Ticketing reform is long overdue. We need to protect fans and also safeguard the livelihoods of artists and their teams. Unregulated resale markets and speculative ticketing practice undermine both fan trust and artist revenue, distorting access to live music experiences for everybody at all levels. We frequently hear from our community whose artists face fan backlash over ticketing pricing and availability, problems caused by hidden fees, all of these things we've talked about. The provisions outlined by the Ticket Resale Act, banning speculative tickets, requiring transparent fee disclosures, setting reasonable limits on resale pricing and ensuring timely refunds for cancelled events, and mandating registration for large resellers represent essential steps for restoring fairness and accountability to the live event marketplace. Thank you for giving us time to make these arguments with you, and thank you.
Thank you very much, everyone, for your testimony. Truly appreciate it. Okay. Next panel. Okay. Our next panel includes Donald Cohen, Executive Director, Fan Alliance, Gary Adler, Executive Director at the National Association of Ticket Brokers, Diana Moss, Vice President and Director of Competition Policy, Progressive Policy Institute, Bruce Morris, Director of Government Affairs, Ticket Network, Inc., and Jason Webb, co-founder of Tixel. Just give us a second while we impanel everybody. Right, just to round out this panel, David, I'm also going to promote Christopher Gowan, adjunct professor of law at American University, and Stephen Happel. Do we need Donald Cohen to accept the promotion? What's going on? Yes, Donald Cohen, you are next. You should have received an invitation to join the panel. Need to accept that so that you can, there you go. All right, great. So then of those who are present, it'll be Donald Cohen, Diana Moss, Bruce Morris, Jason Webb, and then Stephen Happel. Okay, Donald Cohen, you may begin.
Okay, and I am both seen and heard because I can't figure it out. Okay.
You're doing great. We can hear you and see you.
Okay, cool. All right, well, so my name is Donald Cohen. I'm the founder and executive director of Fan Alliance. And what Fan Alliance is a national independent grassroots organization, nonprofit, and an organization of fans dedicated to creating a sustainable music ecosystem. As distinct from other so-called fan organizations, Fan Alliance is truly independent. We take no funds from industry sources. We represent thousands of actual fans in every state in the country. Ticketing reform is urgently needed. We hear from fans about ticket buying problems that you've been hearing about all day. So I'm not going to repeat those. Fake tickets, spec tickets, high prices, et cetera, et cetera. I'm not going to do that. I'll tell a couple of stories. So you can overstate the importance of anecdotes, listening to, one of the persons testifying earlier. But when you hear the same stories over and over again, it becomes clear that we need enforceable rules. So I'll talk about one experience as a fan that I had. I live in Los Angeles. I have been up since 6:30 watching. I tried to buy tickets to go to a show at the Troubadour in LA. I went to the Troubadour site, sold out. But then I Googled and found a ton of tickets on reseller sites for pretty high prices. It was clear that these were not individual fans reselling tickets that they couldn't make the show. There was something else going on. I'll mention one thing about spec tickets. Fans are, I travel around the country a lot. I talk to lots of people. Fans are literally anybody I speak with when I describe spec tickets. They're shocked and often speechless, actually. So I think the point I want to make is that these are not sold as bets that let buyers take a risk on whether they'll get a ticket or not. They're actually buying a ticket. So that's important. So I've also, as I said, I've been watching all morning. I commend your stamina, council members. I've been able to go get some food. So I want to make one point about why I think Live Nation supports resale caps. So Live Nation is very unpopular among fans. They are under a lot of antitrust scrutiny, as we all know, and it is important for them to be seen as supportive of both the artist and fan community. We've seen that play out in the press this month. We, Fan Alliance, supported the Maryland bill. Artist groups came together, and fan groups and artist groups came together in support of price caps in that bill for the first time. Live Nation was not involved. Months later, Live Nation CEOs started suggesting that they support price caps, but of course, a cap at a much higher level. I just think it's important to mention that about what how Live Nation plays in this, because it's a large part of the discussion from some of the reselling companies. So finally, I want to say something real clear. It is a myth that fans want choice. They want tickets at reasonable prices. That's it. And we want our dollars to go to the artists we love and want to support, not siphoned off into the profits of those that are not involved in actually creating the experience. The Resale Act goes a long way in solving these problems that in fact impact both fans and artists and the independent venues we're hearing today. So I urge you to support the Resale Act. Thank you.
Thank you so much. Okay, so before we go to our next witness, Diana, we're having a technical situation here. So of the 30 attendees who are not on the panel, about 15 of them right now are named Scott Friedman, which means when it is Scott Friedman's turn to be promoted to the panel, we will not know which one to grab. I'm assuming maybe Scott just shared his link with a bunch of people. So what I'm asking is everybody who is an attendee right now in the Zoom, if you could look at the way you're displaying, click on your name and update it to make sure it's actually your name so that we know you're here and we can promote you when it is your turn to testify. Otherwise, I'm not sure how we're going to proceed. So otherwise, we may just have to kick everybody out named Scott Friedman and have the real Scott Friedman sign in again. So you are warned. You have until the end of this panel to figure it out. And now we will continue with Diana Moss. Thank you.
Thank you. Thank you. Thank you, Madam Chair and members of the committee. I appreciate this opportunity to testify. PPI opposes the Resale Amendment Act in its current form. We encourage the DC Council to focus instead on promoting genuine consumer protection goals such as price transparency, which the Act currently does, and bans on speculative ticketing and bots. At the same time, PPI urges the DC Council to remove the price caps and conditional ticket transfer provisions from the legislation. These measures would decidedly stifle competition in resale. Live Nation Ticketmaster is the subject of a major federal and state antitrust monopolization case to which the District of Columbia has signed on. Yet, Live Nation continues to protect its double monopoly over exclusive contracts with venues and ticketing by supporting the regulation of resale ticketing while the primary market remains completely unregulated. As it stands, the proposed legislation is assuredly not consumer protection legislation. Ticket resale has been criticized by a number of witnesses here today, but basic economics make clear why regulation of resale will hurt competition, will hurt consumers, and will hurt artists. First, resale provides an important opportunity for ticket sellers and buyers to buy a ticket that they could not otherwise get in the primary market. Resale matches up more fans with more artists, growing the demand for live events. Second, resale is the last frontier of competition because Live Nation Ticketmaster continues to dominate primary ticketing and is quickly growing its share of resale. Third, price caps will disrupt the operation of the resale market, sending fans back to fraudulent shadow markets and disincentivizing participation in the resale market. Fourth, the conditional transferability provision in the legislation gives consumers no additional power. This is because even if they agree to the transfer restrictions on Ticketmaster's monopoly SafeTix platform, their only choice is to go back to Ticketmaster. Finally, regulation of resale ticketing will interfere with DOJ's antitrust case. By distorting prices, enforcers will be unable to determine the extent of the harm that Live Nation Ticketmaster has imposed on consumers. Regulation of resale could also immunize certain conduct from antitrust liability, for example, under the state action doctrine. All of this will hand even more market power to Live Nation because fans will be less able or unable to access the resale market, but have no place to go other than back to the Ticketmaster monopoly. In light of these basic concerns and economics, PPI urges the DC Council to remove the price caps and conditional transferability provisions from the legislation. Our testimony and other state proceedings has been instrumental in preventing regulation of resale and in protecting competition, consumers, and artists. My written testimony filed in this docket cites to several of those. I thank you, and I'm very happy to answer your questions.
Thank you very much for your testimony. We'll now hear from Bruce Morris.
Good afternoon, Chairperson Nadeau and members of the committee. My name is Bruce Morris, and I serve as Director of Government Affairs for Ticket Network, an online marketplace that connects millions of fans to live events across the country including many right here in the district. First, I want to thank the council for its attention to consumer protection and transparency in ticketing. We fully support the intent of this legislation to make buying the tickets fairer, clearer, and safer for fans. There are several areas where we strongly agree with your approach. We support all-in pricing for the first price a fan sees, including all mandatory fees and taxes. Aligning DC's language with the Federal Ticket Act will give consumers a consistent experience nationwide. We also support clear refund rights for canceled or counterfeit tickets and reasonable technology standards to combat automated bot purchases, so long as enforcement aligns with the existing Federal Bots Act to avoid duplication. We agree that deceptive speculative listings should be prohibited, but the better solution is to follow the model put forward in the Ticket Act, require clear labeling and guaranteed refunds rather than banning legitimate procurement services entirely. Now, one area that needs more attention is transferability. The current bill technically prohibits restrictions unless disclosed, which means the biggest ticketing companies can continue locking tickets inside their app as long as they bury that condition in fine print. That's not real consumer protection. Every ticket should be available at no extra cost in at least one freely transferable format, like a standard barcode or PDF, so fans can use, transfer, resell, or give away tickets as they choose once they've paid for them. Our primary concern is with Section 8's 10% resale price cap. Ample evidence shows price caps don't make tickets cheaper in practice. They just shrink legitimate supply. When lawful resale is constrained, consumers end up on unregulated social media or parking lot markets where fraud risk skyrockets and tax revenue disappears. Meanwhile, the dominant primary platforms own quote unquote dynamic pricing and fees remain completely unconstrained. The result is less competition and higher total costs for fans. There are other provisions that also raise red flags, requiring marketplaces to verify every reseller's bond, report detailed transaction data every 6 months, and police non-compliant sellers while simultaneously limiting their revenue would make compliance impossible for many independent exchanges. And the broad conduct or behavior clause in Section 4 could allow venues to deny entry to a paying customer simply for wearing a shirt or hat with an unpopular message without refund. That language should be narrowed to prevent abuse. Finally, the district should consider the economic impact. When resale markets are open and regulated, more seats are filled and more fans spend money at local restaurants, hotels, and transit. Pushing buyers underground would shrink that taxable activity and reduce revenue for DC programs. In closing, Ticket Network shares the council's consumer protection goals. We respectfully urge you to strike the resale cap, align disclosure rules with federal models, guarantee portability, coordinate bot enforcement with the FTC, and ensure balanced registration requirements that apply fairly across the market. That approach would make the ticketing system in DC transparent, enforceable, and genuinely pro-consumer. Thank you for your time and the opportunity to testify today. I've included more extensive detailed writing in my written submission. I'd be happy to answer any questions.
Thank you for your testimony. Jason Webb.
Chairperson and members of the committee, thank you for the opportunity to testify. My name is Jason Webb, and I'm speaking on behalf of Tixel, a global fan-to-fan ticket exchange. And we partner closely with promoters, venues, artists to keep ticketing fair, transparent, and safe. Tixel exists to help fans attend more shows and to help artists and venues build healthier and more sustainable live ecosystems. Since I co-founded Tixel 8 years ago in Australia, we have operated a ticket resale marketplace with built-in consumer protections. So we've got price caps that are tied to the original purchase price. We've got proactive blocks and speculative listings, and technology and partnerships that are designed to align align our incentives with the people who create and host live events, not against them. The market and the current state of the market in DC does not have to be this way. Others have already fixed it. The state of Maine just passed the country's strongest standard that you'd all be very familiar with. Maryland outlawed speculative tickets and hidden fees. And in Australia, fan first rules like 10% above face value price caps and strict anti-spec listing provisions have been enforced for years. You might have actually heard some people earlier on in this hearing suggest that these provisions haven't worked in Australia, and quoting some studies and secondhand information about the market. But having operated in that market for 8 years, I can assure you that these provisions have worked. DC has the opportunity to set a fan-first standard for the capital of live culture with policy that decommodifies the ticket and makes attending live events fair again. So on behalf of TIXL, we believe that the Resale Amendment Act is a pragmatic, pro-fan, pro-artist, pro-venue bill. It's going to cap resale prices at face value plus 10%. It's going to ban the spec listings, which is perhaps the most insidious practice that the secondary platforms allow. And it requires the all-in pricing and clear disclosures to fans to provide transparency about what they're buying and who they're buying it from and where that price originated from. And it'll also hold high volume resellers accountable by forcing them to register. And so you might wonder, what is the importance of all this? And you've heard this example a couple of times today, but it really is so visceral. When a $50 ticket is flipped for $500 on a predatory resale site, the fan can't afford to go to 10 shows. They can afford to go to 1. That's fewer nights out, that's fewer bar tabs, that's fewer merch sales, that's less revenue circulating through the local venues and neighborhoods. And these proposed amendments will add those nights back to DC's live entertainment economy. So I want to just reiterate why TIXL's perspective matters on this issue. And it's because we've already operated in this world for many, many years. And not all secondary platforms are built the same. TIXL automatically caps prices, it rejects spec listings and fakes, it provides transparency to fans and works with the live industry. And across global markets, we see that when these protections are standard, that fans attend more shows and artists and venues benefit. So the Resale Act essentially encodes guardrails that have already been proven workable. And so success for DC is going to lead to more fans through the doors because prices reflect reality, not artificial scarcity. More shows per fan, strengthening venue economics and local cultural life. A fair marketplace where casual transfers between real fans remain easy, but commercial operators are accountable for their actions. And so on behalf of TIXL, I urge you to pass the Resale Amendment Act and place DC on the side of fans, artists, venues, where tickets are real, prices are honest, and the music wins. So thank you for your time and consideration.
Thank you very much for your testimony. Stephen Happel.
Can you hear me?
Yes.
My name's Stephen Happel. I'm an emeritus professor of economics at Arizona State University. Since 1988, my colleague Mary Ann Jennings and I have studied secondary ticket markets. Since 1994, when the National Association of Ticket Brokers was formed, we have done pro bono testimony in various states arguing against price caps: Arizona, Texas, Kansas, New Jersey, New York, just to name a few. As an economist, I know that anytime legislation is passed, there are going to be winners and there are going to be losers. One of the mistakes that people make is they point to a few winners or they point to a few losers, and they conclude that that applies to everybody. So let me point out the most basic fact in much of the conversation that has taken place today. The fundamental reason there are problems in the ticket market today is that for many events, ticket prices are set too low. They are simply set too low. Now, you can go into reasons why. One is that people want sellouts. Another is that they're going to make money on their holds by restricting the sale initially of tickets that drives up the demand for tickets afterwards. But the primary reason you hear ticket prices are so low is people want to be fair. There is no more dangerous word in economics, phrase in economics than fair pricing. Who's to determine what's fair? A group of people sitting at a table saying, well, here's what we should charge for the event. This is fair. Well, what's fair is what the market will bear. So you have this situation where ticket prices have been set too low. One possibility is that venues begin to charge higher prices. There's been talk about how various people associated with the concert or sporting event also should be paid. We'll set prices to cover all that. Learn from the fact that, excuse me, that you started out with initial prices that were too low and resell. And another possibility is a Dutch auction, where you started out with high prices and come down over time. You don't see Dutch auctions at all because, again, I think people feel it's not fair. But the thing that Marianne Jennings and I have showed, and we have documented since 1850 on, is that price controls in general hurt consumers. They lead to black markets, they lead to counterfeit tickets. It's harder to buy tickets near the event. They have simply failed for the general public. Even though there are winners at times, in general, they have failed for the general public. If I had my way, I'd make the legislation state that people must state their holds when they're holding tickets back and allow the free transfer of tickets through bearer instruments. That way, the consumer is protected. It's amazing to me that people say, oh, I'm a true fan, but I don't want to pay more than $40 a ticket, but I'm a true fan. I really love these. And yet somebody that's willing to pay $1,200 is often derailed, is not a true fan. I think the true fan is the person that's willing to pay what the market will bear. Suppose, just as an example, I really love Mercedes-Benz. I know everything about Mercedes-Benz. So I'm a true fan of Mercedes-Benz. Should I be allowed to buy a Mercedes-Benz at a lower price than other people are willing to pay in the open market? And I just see real problems with that. So again, I think that the answer is make tickets bearer instruments, break up Live Nation and Ticketmaster vertical monopoly, and allow the free transfer tickets. I'll say one last thing and then I'll stop. Going back to where you have a Dutch auction, one of the complaints is a Dutch auction would mean only the rich can go to the event. Well, we have proposed, Marianne and I have proposed a situation where you let people line up anytime before the event. You have the price stated. As they go in, they get one ticket and they're escorted to their seat. And so you can set off a wonderful area of the venue for people that don't want to pay the going market rate, your true fans, but they can't resell the ticket. They can't trade it to anybody else. That is the only way you can guarantee that true fans actually occupy most of the seats that you've set aside. Thank you very much for the opportunity to speak today.
Thank you very much for your testimony. Okay, thank you to this panel. A couple questions for Jason Webb. We heard earlier the resale platforms with caps are often startups that only last a few years. How long has Tixel been in business and how many tickets have been resold on the platform?
So we've been in business for 8 years. And we've had millions of tickets transfer on the platform. And there is a way that this can be done profitably. And so the suggestion that startups come up and they come and go, I think that was a suggestion that was made by, if I remember correctly, the people representing StubHub. And so you can read into what their agenda might be, but their reference to a startup isn't really valid because there weren't price caps associated with that startup that they mentioned.
And what does TICSIL do to prevent fraud and protect consumers?
We do lots. We've developed technology that can detect whether a ticket is real or fake and whether it exists or it doesn't exist. And so we block fake tickets, and we only allow people to create listings, or fans to create listings of tickets when they actually hold the ticket. So we require proof of ownership of the ticket. We read all the information off the ticket to determine what the face value is, and we can apply a price cap to that face value automatically at scale. It doesn't need manual moderation. These are all protections that are inbuilt into the platform. And then we monitor the usage, so we can track if fans are reselling suspicious volumes of tickets, if there's suspicious behavior on the platform. One thing that is really interesting about the information in StubHub's S1 filing is that on average, their sellers sell 40 tickets per year. And I can tell you that that is not real fan behavior. That is organized, sophisticated, professional activity. Fans, on average, attend a handful of shows per year, and they might resell fewer than those amount of tickets per year. So, yeah, there's with the technology that we built, we're able to monitor what's happening on the marketplace at scale and identify any anomalies, block fraud, and make sure that all participants in the marketplace have a transparent view of what's happening in the market. So you're buying a ticket off a real person, the original purchase price of that ticket, who issued that ticket, exactly where it's seated. And so, yeah, that's how we protect the consumer's interests.
Thank you very much. Thank you again to this panel. Okay, although we do have a number of people signed up for the remainder of the hearing, there are only a handful of them in the Zoom. Even so, I will call everybody's name just to make sure we don't miss anybody. If you are in the Zoom right now and you're not getting the promotion invite and you do believe that you're supposed to testify, please raise your hand. It may be that you're named incorrectly. So, okay. Marianne Jennings, Sean Hendry, Andrew Mudd, Wendy Sherritt, Beatrice Evans, Jennifer Garlich, Scott Friedman, the real Scott Friedman, we found him, Andrew McMahon, Randy Nichols, Graham Evans, Hannah Johnson, Melanie Thurston, Matthew Gillen, Jared Oppenheim, Robert Crane, Jeffrey Stepp, Eric Fuller, Elise Watkins, Julia Leffler, Heather Laffey, Robin Bugos, Bill Hoydas, Glenn Sanders, Dave Kay, Jenny Roque Martinez, Clara Huff, Gideon Foreman, Matthew Bankovich, Cassandra Diamond, AJ Silva, Kevin Vermillion, Misha Nash. Okay. Again, if you signed up to testify in the Zoom and you've not been promoted, this will be our last Zoom panel. Please raise your hand in the Zoom and we will make sure that you get promoted to this panel before we move on to the government witnesses. So we'll continue now with Marianne Jennings. Each of the witnesses on this panel has 3 minutes. If you could please keep an eye on your time. Thank you.
Hi, I'm Professor Happel's colleague, and we have been at this research for nearly 40 years. And there are two things that are very clear to us. One is that price controls do not work. They haven't worked since the days of Shakespeare. And the second thing is that we really don't know the market supply. And although I have, and put this in my testimony, no objections to the usual controls that you would have in the market, which would be registration of sellers, no speculation. You can have fines, all of that. We have no problem with that. Markets are regulated. Our stock markets are an example of that. But what happens is we think that the price controls will take care of things. What we really don't know, and I don't believe we will ever know, is the number of tickets that are out there, because our research has shown that time and again, the primary sellers hold back. And indeed, there are deals that are made with companies to have an allocation of tickets, and they use those in the promotion of credit cards and whatever else is going on. So that there are always these tickets. It can be the performers, it can be their families, and they're not going to fall under the regulation. And what we know is that when people can't get full information, then they resort to, the black markets, and that has always existed. But what you have to have is a situation where people can assess, is it possible to get a ticket? What's the supply of the tickets? Who's selling the tickets? Are they licensed, registered? All of that needs to be transparent, because that's what gets an open and free and fair market. I will tell you that when Professor Happel and I began our research together, we had serious arguments because I was on the other side with price controls. But as the research progressed, I began to see, and we have studied the history since Shakespearean time. Every time we're going back primitively to price controls. And what you have now is vertical monopolies between the primary sellers and their sites for secondary sales, and that controls prices in and of itself. So not everybody has access to tickets. So if you want to create a free and open and transparent market, you go ahead, have your regulation, but the price controls will be the thing that will defeat anything else that you do to protect consumers. And I'm staying within my time limit, and I appreciate your time.
Thank you so much for your testimony. I appreciate it. Scott Friedman.
You guys hear me?
Yes.
Thanks for coming on. Thanks for having me. I've enjoyed listening to everyone's testimony all day, and I applaud you for staying. It looks like most of the DC council left for the afternoon, which I think is extremely inappropriate. I think it's extremely disgraceful. Specifically, Alan just like leaving the meeting when we're like working hard, testifying, whether we oppose this or whether we go after it, and it's just disrespectful to everybody. So in my opinion, the code of the law 1-116 2.00, they should be removed from DC council effective immediately for really disrespecting everyone that attended this meeting. In regards to resale, I want to make this clear. I want you guys to envision a world where there is 10% resale cap in all 50 states. What will happen is everyone will be forced to go on the black market. StubHub, Vivid, SeatGeek will be out of business. Ticketmaster will have a full-blown monopoly, and fans will pay more for their tickets. That's what will happen when DC enforces the 10% resale cap. It'll be over. And I have all these venues, the Anthem, all these clubs whining, I can't make it. Then your ticket prices, there's better business practices with these secondary channels that will help you move more value and help your bottom lines for the company. It's not rocket science, my friends. There's opportunity for everybody. Yes, we need to get rid of the bots, the horrific bad actors. I got bad actors suing me. I'm fighting my own legal costs for the greatness of this industry, but we cannot enforce resale caps whatsoever. And thank you guys for having me. Thank you for everyone that spoke on either side of the bill. I appreciate everyone's enthusiasm. And thank you, Chairman, for letting me speak. And shame on all the other council members that left the hearing early. Shame on them. Goodbye.
Thank you. Randy Nichols.
Thank you for your time today. As you said, I am Randy Nichols. I'm on the board of the National Independent Talent Organization, where I lead our ticketing policy, and I'm also an artist manager who manages global touring artists. One thing I want to point out quickly here is if you notice throughout all the testimony today, not one person associated with artists, venues, or true fans is against this bill. Only the AstroTurf groups and the scalper lobbyists are against this. There's a reason for that. I want to also point out that while I'm not a fan of Ticketmaster, the scalpers and their lobbyists lied today and stated that they don't have speculative tickets on their platform. There are multiple platforms that actually have services to support their speculative sellers. And there's other services, for instance, with Vivid Seat, where they call it their concierge service. StubHub calls this zone seating. Anytime you see zone seating, it means there's not a real ticket available. I'd also like to point out that StubHub, Vivid Seats, Ticket Network, etc., calls themselves competitors of Ticketmaster, yet they don't offer a primary ticket service for venues, so they're not competitors. By definition, they're not competitors. Moving along, this bill is to protect fans, artists, and venues, not the private equity-backed multi-billion-dollar scalping industry. This is not a cottage industry. This is a sophisticated global enterprise. StubHub alone spent $850 million on marketing last year and $60 million on operations. That's not a service. That's a predatory ad machine designed to keep fans trapped within their ecosystem. In my last minute here, I want to point out that the rock band The Cure on a recent tour, they worked with fan exchanges and kept ticket prices extremely low. On their tour in Los Angeles, where they were able to have restrictions, only 20 tickets were sold on StubHub for their Los Angeles show. In New York, where it's illegal to do that, unfortunately, there were 3,875 tickets sold for a $519,000 profit for scalpers. And in the state of Maryland, where there's also protections, there were only 3 tickets resold. These numbers expose the truth that scalpers lose money most of the time. Well, sorry, I'm losing my point here, but these points expose the fact that scalpers claim they're saving customers money. It is impossible to be a multi-billion-dollar industry and consistently lose. If they're not lying, they're laundering. And I will turn it back to you. And I can't wait to hear from my friend Eric Fuller.
Excellent. We also do have Robert Crane, who I think needs to accept the invitation to the panel. But we will go ahead with Eric Fuller until that time.
Thank you for having me. It's a pleasure. Hi, Randy. Good to see you. And I, as always, I'm going to go on the other side of what you have to say. Here's how I see it. I've been in this industry a long time. I've advised everybody on all sides of it. I've written dozens of stories for publication. So I have a pretty good understanding of what's going on. First and foremost, consumers are smart, and they don't need government to tell them how to make decisions. Consumers in every area of competitive goods have to deal with price. Price is what limits how you make supply and demand work. And ticketing is no different. There is absolutely no reason that everybody in the 50 United States and from all over the world has to be subjected to a random law in the District of Columbia if they want to go to a show there, and they have a capped price that keeps them from being able to sell the ticket that they don't get or being able to access it where there's a market with inventory. It's just silly, it's unnecessary, and it isn't well thought through. If you look at the District of Columbia, we look at the 930 Club, where Audrey Fix-Schaefer is very, very advocating against all sorts of intervention. You'll see that they have, through the end of March 2026, 86 shows scheduled. The 930 Club likes to complain that the ticket people are bothering them. Of those 86 shows, 65 of them are not sold out. You could buy the tickets right now on their website. So it's all kind of a false problem. By the way, beers in these clubs are now $20. So if you have 2 beers each and you're with your friend or your partner, with a tip, you're $100 for beer, but there doesn't seem to be any stress to contain the markup on beer, which is 20x. There are lots and lots of things that we could talk about in this space. But the most important thing is, and nobody's touched it, I have heard from 3/4 of the people today about scalpers and scalping and scalping and scalpers. That's a pejorative, terrible word. Nobody's out there with a tomahawk cutting your head off, taking your hair. It's preposterous. I mean, you as a council wouldn't possibly deal with intellectually challenged people by passing the retard bill. And we go around talking about how we're going to help retards. I mean, scalping is a horrible word, and it denigrates tens of thousands of people all across this country that work very hard to make sure that consumers get into events that they want to see, that they have a mechanism to get rid of seats that they can't use or to trade into better seats. It works at scale, and it doesn't need every single state to have a differentiated rule kit so that we make sure that things don't work well. Everybody should probably just take a breath and understand that consumer goods trade on supply and demand. And you get the benefit of discounts with the system that we have now. Without it, you won't get them. You'll pay full price. Thank you.
Thank you. And finally, we'll hear from Bob Crane.
All right. Can you hear me?
Yes.
All right. Thank you. Well, thank you for the opportunity to testify. I will say I certainly learned a lot about the different perspectives on this real important issue. I'm a longtime concert goer. I don't know how much money I spend in the District of Columbia, but it's a substantial amount, going in, having dinner, watching shows and everything. But I do support what's in this bill. And I do want to point out there are innovative ways to keep this kind of thing on track. The IMP production folks did a very cool thing when they opened the Atlantis Club, and they made all of the tickets a lottery, and all of the tickets could be resold, but they had to be resold within the folks who actually purchased those tickets. So I'm not saying that's a solution for everything here, but it's really well founded that there are ways to implement controls on the resale of tickets and really still flourish. So with that, thank you very much for the opportunity.
Thank you very much to all of you for your testimony. Really appreciate you taking the time and sticking it out this afternoon. And that will conclude the public testimony on the Resale Act. We will now hear from our government witnesses. The only two. Okay, so what we're going to do is first have government testimony on the Consumer Protection Act. Okay. Yes, excellent. Self-select, please. All right, so that's Kevin Vermillion from the who is the Director of Consumer Protection at the Office of Attorney General, and April Randall, Chief of Legislative Affairs and Policy Officer, Department of Licensing and Consumer Protection, and
Anissa Crosby, Chief Enforcement Officer at DLCP.
Very good. Okay, so first we're going to swear you all in, and then you can decide what order you'd like to give any oral testimony. Okay. If you could raise your right hands, if you swear, do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth?
I do.
I do. I do.
Okay, great. Who's going to go first?
You know what? We're all friends here. I don't mind.
Doesn't matter to me. I got to sit here either way, so.
No problem. Good afternoon, Chairperson Nadeau, committee members, and staff. I am April Randall, Legislative Director with the Department of Licensing and Consumer Protection. It's a pleasure to appear before the Committee on Public Works and Operations along with colleagues Kevin Vermillion here from the Office of Attorney General, my colleague Anissa Crosby, Chief of the Office of Enforcement with DLCP, and later on with my colleagues Ryan Nichols from DMPED, as well as Keith Parsons from the Department of Buildings. Although there are several bills before the committee today, I will only be testifying on two of those. The Bill 26-174, the Enhancing Consumer Protection Procedures Amendment Act, and Bill 26-287, the Housing with Integrity Amendment Act of 2025. My colleague Ryan Nichols from DMPED will testify on the resale bill, but as well as Ms. Crosby, will be available to answer questions as they relate to DLCP. DLCP became a standalone agency in 2022. On October 1st, we were very happy to celebrate our third anniversary of promoting economic growth and development and protecting the financial interests of business residents and visitors of the District of Columbia by issuing business licenses, occupational professional licenses, while also ensuring that consumers are protected from unfair and deceptive trade practices. We achieve this by aggressively investigating and enforcing the CPPA. The bills before us, both Bill 26-174 and Bill 26-287, align with DLCP's mission of protecting the economic interests of businesses, residents, and visitors of the district. So I am happy to appear before the committee today. Beginning with Bill 26-174, the Enhancing Consumer Procedures Protection Act, I will focus on its impact to DLCP. Please know that I align myself with OAG and the additional enforcement mechanisms that it provides to them. It was a pleasure working with them in the working group and drafting the bill before you. But as it relates to DLCP, it will grant additional enforcement authority to the agency, affirm that unlawful and abusive trade practices are prohibited, clearly clarify the complaint process, add additional grounds for unfair and deceptive practices, increase the penalty for violating the CPPA, and remove the requirement that the Chief of Enforcement be a member of the DC Bar. Again, DLCP fully supports this bill as it will expand our enforcement authority with additional grounds for unfair and deceptive trade practices. DLCP worked very closely with OAG and stakeholders, many of whom that you heard earlier today, and we appreciate the collaboration on working on this bill that's before us. Since the bill was introduced, DLCP has addressed and faced additional matters, hence why we have presented a red line to give us this ability to revisit the bill, to add additional revisions that we believe that will further protect consumers and district residents and enhance our enforcement mechanisms. To that end, along with this testimony, as I mentioned, we have a red line bill, which I have shared with the committee, as well as OAG and the stakeholders. The additional provisions that are highlighted of note in that red line is the adding of additional grounds for unfair and deceptive trade practices, including violating the district's construction codes as set forth in Title 12 of the District of Columbia Municipal Regulations, and the failure to conspicuously post prices. We've heard a lot about the posting of prices today, and that is one item that we are particularly concerned about. The construction codes as it relates to the home improvement cases that we have, although council has passed the general contractor bill, that bill is not yet funded. So we believe this will give us some additional authority to take action against those individuals, as well as give DLCP the authority to summarily close an establishment where unfair and deceptive trade practice presents an imminent threat to the health, safety, and welfare of the public. As it relates to the fine, although the bill proposes an increase to the fine amount for a CPPA violation, we will also propose that they allow for an adjustment to those fine amounts based on the Consumer Price Index. This exists as it relates to other fines in the code, particularly in the regulations, particularly those set forth in 16 DCMR 3301 through 3313. So we will recommend having language akin to that to allow for adjustments to the fine amounts. Further revise the complaint process. We do agree with and support everything that's in the bill already. What we are proposing here in our red line is to align the complaint process with our actual procedures for handling CPPA complaints. The current code still refers to a hearing officer, suggesting that there are internal hearings at DLCP, and there aren't any. When we issue NOIs and one appeals those NOIs, they're handled by the Office of Administrative Hearings. So we revised the language further to include that process, but kept everything else that was initially in the bill. And so that we can align with that and avoid any confusion to the public. DLCP thanks Councilmember Nadeau and staff that worked on this bill and introducing it today, and we look forward to answering any questions that you may have.
Thank you.
Good afternoon, Chairperson Nadeau. My name is Kevin Vermillion, and I serve as the Director of the Office of Consumer Protection at the Office of the Attorney General for the District of Columbia. I am here today to express OAG's strong support for the Enhancing Consumer Protection Procedures Amendment Act of 2025, or what I will call, for ease, the CPPA amendments. These amendments would modernize, strengthen, and clarify the district's consumer protection framework, ensuring that our laws keep pace with today's marketplace, provide clarity for district businesses, and allow our office at OAG to more efficiently protect district residents from unfair and deceptive trade practices. While the majority of my testimony today is going to focus on these CPPA amendments, I do want to state OAG's support for the other two bills that are before the committee, the Resale Act as well as the Housing with Integrity Act. My colleague Beth Mellon will be here to answer questions about the Housing with Integrity Act a little bit later. As I said, the CPPA amendments would enhance and modernize the district's consumer protection laws. OAG enforces the CPPA to protect district consumers from unfair and deceptive trade practices, enforce tenants' rights to safe and affordable housing, ensure that gig economy workers are fairly compensated, and protect the health and safety of district residents, among other things. Since 2023, OAG's enforcement has secured tens of millions of dollars in restitution, which is money that goes back to consumers' pockets, penalties, and remediation funds. This enforcement has had a direct impact on the lives of district residents, from combating predatory lenders that charge usurious interest rates and trap consumers in cycles of debt, and to obtaining rent refunds for tenants who have been forced to live in terrible housing conditions. The CPPA, while it is a powerful tool, has not had a comprehensive update in over a decade. This bill provides this much needed update. And over the last 2 years, as Ms. Randall just said, a working group that has included relevant district agencies, legal service providers, and key stakeholders has worked to draft the core provisions of this bill. These provisions would help OAG continue to do its work more effectively while also giving district businesses clearer guidance and expectations. I'm happy to answer any questions about any of the bill's provisions, but I would like to highlight a few specific provisions and give examples of how they will assist OAG in its important work. First, this bill would add a prohibition on abusive practices, which are practices that materially interfere with the consumer's ability to understand a transaction or that take unreasonable advantage of a consumer's lack of knowledge or understanding of a product or transaction. This provision would align the CPPA with other state consumer protection laws that have added similar prohibitions, as well as the Federal Consumer Financial Protection Act. It would also ensure that the CPPA adapts to the changing ways that consumers interact with businesses. For example, as almost all of our transactions now occur online or through apps, consumers are increasingly encountering the use of digital dark patterns, which are design tricks used to manipulate and confuse users. A prohibition on abusive practices would make it easier for OAG to combat these manipulative practices, including practices that trick consumers into signing up for unwanted services that they never intended to do, or that make it nearly impossible to cancel subscriptions. In addition, an abusiveness prohibition could protect against financial products that set consumers up to fail, which is actually one of the reasons it was included in the Consumer Financial Protection Act that was passed after the 2008 financial crisis. As consumers see increasingly more aspects of their lives financialized, tools that effectively combat predatory financial products are becoming even more important. And there is an important distinction between abusive practices and unfair practices, which are already prohibited under the CPPA. in that abusiveness requires no showing of substantial injury to establish liability and does not allow businesses to defend otherwise harmful practices because they may have some other benefit to consumers or competition. This acknowledges that obscuring important features of a product or service or taking unreasonable advantage of consumers are presumed to be harmful in and of themselves, and allows for more efficient enforcement to stop these practices. Second, this bill would make OAG's investigations of potential CPPA violations more efficient for both OAG and the targets of those investigations. One way the bill does this is by allowing OAG to include interrogatories in its investigatory subpoenas, which will require the recipient of the subpoena to answer questions under oath. This is a less time and resource-intensive approach for both OAG and any business that is answering those questions, as it allows the target of an investigation to answer questions instead of requiring OAG and the business to spend resources collecting, transmitting, and reviewing voluminous amounts of documents to find what could just be a simple answer, which is what we often find ourselves doing now. For example, there are many questions that we ask at the beginning of an investigation that can narrow and focus it, such as simple things like how many district residents have you done business with and how much have they paid you? Answering that question through documents is often quite burdensome to the business itself, as they have to query multiple databases, compile those into something that is easy to transmit to the OAG, give it to us, and then we often have to parse through what is likely a large spreadsheet to come up with these answers, when it would often be just much easier to ask, how many people have you done business with in DC and how much money have they given you? While some business do provide this information voluntarily, not all businesses agree to do so by just answering the question, and this bill would ensure that OAG can get information such as that in the format that most efficiently advances investigations. Other provisions of the bill would strengthen OAG's ability to enforce subpoenas in court, thereby incentivizing compliance. Investigations into harmful conduct can often drag out for far too long because there is little incentive for bad actors to comply with the subpoena. Giving OAG more tools to enforce subpoenas will allow our office to conserve resources and move investigations further without undue delay by disincentivizing bad actors from obstructing an investigation. And not only would this bill make OAG's enforcement of the CPPA more efficient, but would also grant DLCP updated administrative tools, allowing the agency to be more agile in its enforcement of the CPPA. As Ms. Randall mentioned, for example, it would strengthen DLCP's ability to issue cease and desist orders and summarily suspend licenses when businesses put the public at risk of immediate and irreparable harm. These types of tools and providing them to DLCP will complement OAG's investigatory and litigation tools, which take time and are not always well suited to isolated problems or those that need immediate resolution, and allowing DLCP to address those will be complementary to our work. In summary, this bill would adapt the CPPA to address modern consumer protection issues while allowing OAG and DLCP to use our limited resources more nimbly and efficiently to protect district residents from unfair, deceptive, and abusive practices. We're grateful to the committee for your dedication to advance the amendments to the CPPA, and we are proud of the work undertaken by the working group, which included other government partners and public stakeholders, and we came to a consensus and we're able to think through these issues, and I'm happy to answer any questions that you may have.
Thank you. Okay. Just starting with a few background questions on DLCP's current enforcement of the CPPA and consumer protection work. Can you describe DLCP's current role in enforcing the Consumer Protection Procedures Act?
Sure, absolutely. As the primary consumer protection agency of the district, when DLCP investigates all the complaints that it receives, if we receive them online and we review those complaints, if they do not fall within our purview, we do send them to other agencies such as OAG or another agency that it may be applicable. But we definitely always assess the complaint to determine if it may have any aspect of the CPPA that we can enforce or another violation, whether it's licensing or some other matter, before we then refer it to another agency. We do that thorough review. We also engage in education. Consumer protection also requires educating the public about what constitutes a consumer protection complaint and how to file that complaint. So we work on that to a great extent, either going out to stakeholder meetings, issuing advisory notices, because it's also essential that we are informing and educating the public about what their rights are as well.
And how many staff are part of the consumer protection team at DLCP?
There are 30 staff members a part of the Consumer Protection Unit.
Do they work full-time on consumer protection?
I'll let Ms. Crosby do the breakdown, provide you the breakdown.
So we have, within the 30, they're handling all case types that DLCP may receive. So it could be consumer protection. It also is licensing matters and regulatory matters that are under the agency's purview. So of that 30, we have 22 investigators that are investigating all, the majority of the case types that come in. And then we have support staff and managers as well. So they're not only working on specifically violations of the Consumer Protection Procedures Act, but they are investigating all case types that fall under the agency's purview and then identifying violations of the Consumer Protection Procedures Act within the cases that they're investigating.
And how many consumer protection complaints does DLCP get per year?
So in FY25, we had 231 that were submitted from the complainant, identifying that there was a deceptive trade practice. So that was the number of cases. In FY24, there were 124. So we had a slight increase from fiscal year to fiscal year.
And what's the most common type of complaint?
So most common type of complaint that the agency receives is going to be about unlicensed activity. And then within those cases, we identify Consumer Protection Procedure Act violations. So it may be that someone is advertising on their website that they are licensed, but they're not.
Mhm.
So that's being deceptive and misrepresenting yourself. So most of our cases, the complaints that come in are about unlicensed business activity. And then within those cases, we identify violations of the CPPA.
And if I may, Councilmember, also add on to that. Also, when we may receive a complaint about an occupational professional license, as a part of that investigation, you may see either the unlicensed activity as the operating within that profession or some other violation, but also there may be a discovery of a CPA violation as well. So yes, Ms. Crosby did provide the number of CPPA direct complaints that we have, but we oftentimes see them in other complaints that we are handling. So they can come up a different way. So it's actually more CPPA violations, but those direct complaints are the numbers that she provided.
Do those get quantified in some way eventually?
We are enhancing our case management system to do a more granular count of the different types. And as we get there, we will be able to do that. But we are able to, if we were to go back, to have to look case by case, but we're hoping to, with these new enhancements, to do get a more seamless count for reporting.
What are the current enforcement options that DLCP has?
The most common one is issuing a notice of infraction. In more egregious cases, we can then issue an order to cease and desist, and we've done that at times. And essentially, that's just telling the business to stop to do that, do not do that any longer, hoping that they come into compliance. If they do not, unfortunately, we do not have injunction authority, so we do have to refer those cases to OAG for injunction. We can also suspend or revoke a license as well. Those are our primary enforcement tools.
How often is DLCP able to bring a business into compliance or mediate a favorable outcome for a consumer?
Generally about 70% of the cases when we were reviewing our statistics and going through the count. So in about 70% either by mediation or reaching by the NOI process.
And what percentage of complaints does DLCP act on?
When you say act on, are you saying actually investigate or take some type of enforcement action?
Could you do both for me?
One of the things that we did assess was that of the complaints that we received, 94% of our complaints go to an investigation. Only 6% were actually closed during the admin intake process, which is identifying that maybe it's outside of our jurisdiction or there's another agency that might be better suited for resolving it. But 94% of our cases we investigate.
Okay.
I can follow up with you in regards to how many of those cases resulted in some type of enforcement action, so we can follow up on that.
Thank you. What is the most common outcome of DLCP investigations?
The most common outcome is compliance. That's the first thing that we push for is compliance. A lot of times if it's an unlicensed case, which is a lot of the top case that we receive, in some instances, it may be that the business didn't renew their license. So we get them into the process of renewing their license. In some of our CPPA cases, it's mediating and trying to get a resolution. So we do have a lot of cases that enter a favorable result, but we also have a high number as well that results in an NOI issuance. And that's the top enforcement action that we take is issuing the NOI. So we can also follow up with the exact percentages that have resulted in an NOI to help with that, answering this question.
Thank you. What is the biggest challenge for DLCP in pursuing action in cases?
Some of the biggest challenges, resources, for one, just being able to handle the volume. Luckily, we are able, and if warranted, refer them to other agencies to handle those particular matters, and we do utilize that as an option. Also, just enforcement tools. As you heard, our primary enforcement tools are issuing an NOI, the cease and desist, but there are more egregious situations. And so to try to get those businesses into compliance while also trying to ensure that we're protecting the public, greater enforcement is needed. So that's in part why we're seeking the additional authority to summarily suspend a license. If there's also the threat of imminent threat to health, safety, and welfare. But we also recognize, and this is why we had this in the red line amendment to summarily close, because oftentimes many of those businesses are not licensed. And if you're not licensed, there's nothing for us to take
right
in that situation. So resources and the enforcement tools that we currently do have to bring businesses into compliance.
So what happens to the remaining 30% of cases where the business does not come into compliance? Are those referred to OAG, or is there some other way a consumer can pursue action?
We do send some of we tried the cease and desist, that does not work, and we have to send it to OAG for an injunction. We do tell them about their other their other options. Yes, the private cause of action is another one as well.
Okay. Okay, so just want to go through some of the individual provisions that relate to DLCP in the bill, starting with some of the expanded enforcement provisions. Okay, so how will this change DLCP's ability to revoke or suspend licenses? We've heard frustration from members of the public and council members that there are not real consequences for disobeying the terms of a license.
Thank you for the question. And I will say, yes, we are able to suspend or revoke a license that we do not use on a regular basis, because that obviously we want people to be in business, right? That helps our economy. That's adverse to the mayor's growth agenda. But there are times, and in certain circumstances, depending on the facts, greater enforcement action is necessary besides just issuing an NOI. And so that's when we try to utilize those additional enforcement tools. As it relates to the additional enhancements that we're seeking as it relates to the summarily suspending licenses and closures, Ms. Crosby can add on to this. We have had several cases. Councilmember Louis George is not here right now, but it has come up numerous times at the director's oversight hearing about the SOS Tire Shop on Georgia Avenue. Does not have a license. We have issued NOIs. That hasn't resulted in their coming into compliance. We issue a cease and desist. That didn't result in compliance. We have referred to OAG, and they're handling it on their end and seeking the injunction. But that's going further down the line. Now you have to wait to Superior Court to docket it and then to go into that process. If we had the authority to summarily close that establishment which is presenting definitely an imminent threat to the health. It's the tire shop. There's environmental concerns to the community. We're continuing to get complaints. There are times when greater enforcement is necessary, and that's why we are seeking this additional authority, and that's how the bill can help us.
Sounds like 12 is answered. In that example. Okay. All right, so we're going to get to the housing integrity bill in a bit, but how might the CPPA bill also help address poor housing conditions or landlords who refuse to get licensed or adhere to other laws?
Well, adding the provision about the noncompliance violating any district or federal law could definitely help in that realm. We can utilize that authority on that provision for issuing a CPPA violation. So that would definitely help there. If they're not licensed or otherwise misadvertising. So the additional teeth that the CPPA Enhancement Act is providing will help us in that realm as well.
I'm thinking about a case where no one seemed to have authority, and it's maybe more of a DOB thing, but now I'm thinking about it because of the way you just talked about that. So it's a rental property where they're advertising the building as ADA compliant, but it's not. Would that fall under CPPA?
We would have to look up, but you're misrepresenting. So yes, it's a very good possibility.
I'll tuck that away until after the bill is passed. Okay, thank you. Okay, in your testimony, you mentioned some additional changes that you would like to see from the bill. How did DLCP arrive at these recommendations?
Well, the summarily closure, I'm taking them out of order, just is a build on this summarily suspended license. So if there's no license, that's the next one. Adjusting the fines based on a consumer price index, we do that on the business licensing side. Those fines under 16 DCMR 3301 to 3313. So this will align, that would not be different for us. Even though the bill would increase the fines for CPP violations, they're still relatively low. And we want to discourage businesses from thinking it's just the price of doing business. So being able to adjust them by the consumer price index will help in that regard. And also that we won't always have to amend the law to do that. In terms of the identifying the prices, you heard a little bit about it today as it relates to the resale bill. Even before the resale bill was introduced, we had conversations from the spring with the tourists that were overcharged for the ice cream. Many of those trucks did not have the prices listed. Now, we were able to use the current unfair and deceptive practices for investigating those complaints and issuing NOIs if we were able to do so. But being very clear and transparent about this is a requirement. You are required to push your prices, can help in that regard, and it levels the playing field for all businesses.
Oh man, you guys in those food trucks, it's like the white whale, you know?
Well, I'm not going there. Everybody will have to post their prices.
Okay, I'd like to ask you a bit more. Let's see, hold on. I think we got to this. Can we do 15? Okay. First, you requested violating the DC construction codes as an unfair and deceptive trade practice. As you mentioned, we're still waiting for funding for the General Contractor Licensing Amendment Act the council passed, but my office is continuing to hear from constituents about issues with contractors. How would this support enforcement and help consumers?
Well, we added that in part for that reason, so that would now make it a consumer protection violation. Also, the amendment that violating any district law or district federal law can also help in that regard. It will require more education. It will require multiple different tools to bring the homeowners whole, but this is actually now would help to hold the general contractors accountable till that bill is funded.
And would that cause any conflicts with provisions passed in the General Contractor Licensing Amendment Act?
I do not believe so, but we can I do not believe so because that's focusing on the licensing and the certification requirements. But we can take another look, but I do not believe it would.
Okay. Yeah. And how will the authority to close establishments that present an imminent threat to health, safety, and welfare be used?
in the most egregious situations. We gave one example with the SOS tire shops, and there are a few others. That would be a last course of action, because again, closing a business is very grave, but when the violations also present a grave harm to the residents and the public and the community, graver action is necessary.
Great. Thank you. And Mr. Vermillion, thank you for your testimony. I had the opportunity to hear from your predecessor on this bill. We had that roundtable, so I don't have too many additional questions for you today, but I'm interested in the digital dark patterns you mentioned in your testimony. Can you share more about what these are and how the CPPA will help OAG stop them?
Yeah, absolutely. So it's a broad term. It's a term of art, but it is a term that is becoming more commonly used. The FTC has previously issued guidance and other interpretations regarding the use of dark patterns, but dark patterns are basically tricks, usually online, that get a consumer to do something that they did not mean to do or that they didn't want to do. One example is, a pre-checked box, right? When you're going through the checkout process, and maybe it's something as simple as a checkbox to sign you up for emails, but maybe it's something more nefarious that is signing you up for a recurring subscription when you thought that you were only buying something once. And they have now used the design of that checkout process to get you to sign up to that when you maybe didn't intend to. There are other types of dark patterns. For instance, there was a lot of talk today in the Resale Act testimony about the process that you have to go through when you're buying a ticket. Depending on the platform that you are on, there are platforms that may have countdown timers that are trying to instill a sense of scarcity. So maybe you're not paying attention to those fees and how much those fees, because you think that they're maybe running out of tickets and you need to act quickly when that may or may not be true.
That's helpful. Thank you. And how will it help the OAG address subscriptions that are almost impossible to cancel?
Well, part of it is that, so the abusiveness, I think, is the part that I had said would make it easier to address this. And so that is, there. Right now we have deception and unfairness prohibited under the CPPA. And at the time that someone is signing up for a subscription, there may be no deception occurring. They know that they're signing up for the subscription. So deceptiveness wouldn't be an appropriate angle there. And we could go after it under unfairness potentially, but under unfairness doctrine as it works right now, businesses will often argue, well, the consumer wasn't harmed. They were still getting the thing that they signed up for. We would say that they didn't want it, but they may argue that, well, they were still getting the product. Or they may argue another prong of the unfairness test is whether there are countervailing benefits to consumers or competition. We usually think those arguments are unpersuasive, but that is something that we still have to overcome. Whereas those are not arguments that a business can make in an abusiveness claim. So it'd be much easier and more efficient and just a clearer path for an investigation and enforcement action, and for the businesses to know what they need to do to have just a straightforward abusiveness standard.
Great. California's automatic renewal law requires businesses to provide clear and easy ways for consumers to cancel subscriptions. Would this type of explicit rule also support consumer protection?
Yes, and DC does have an auto renewal law already in effect that is somewhat similar to California's law. And a violation of the Auto Renewal Act here in DC is a violation of the Consumer Protection Procedures Act. But abusiveness would add to our ability to address things that may not fall under the auto renewal law, which is fairly narrow in some aspects and only applies to certain kinds of subscriptions that auto renew.
And I also talked earlier today about California's data privacy law, and we heard these additional protections are also important. Could you share how this bill will help OAG protect data privacy and if additional protections are needed?
I think that it will help in the data privacy actions that we take under the CPPA as it exists because of the efficiencies that this will introduce in making our investigations move forward more quickly. And I think it will also help in the sense that this bill would add a minimum penalty for CPPA violations, which should encourage businesses to take proactive measures to appropriately handle consumers' data. I do think that additional privacy legislation and protections are necessary. The CPPA is a general unfair, deceptive, abusive acts and practices statute, which every state has, but now, as was mentioned earlier today, dozens of states have adopted comprehensive privacy laws that specifically tackle data privacy issues. It's a bipartisan group of states, and OAG would be happy to work with you and the council on how DC could do that as well.
Great, thank you. Okay, so that's all we have on that bill. So now we want to rotate and bring up everybody for the housing bill, the Housing with Integrity Amendment Act. So I believe we are also going to be joined by Beth Mellon, Assistant Deputy Attorney General in the Public Advocacy Division and Senior Counsel for Housing Protections and Affordability at the OAG, as well as Keith Parsons, Strategic Enforcement Administrator at Department of Buildings. We still have enough chairs, I think. Good. Okay. We will swear you two in. Raise your right hand, please. Do you swear or affirm under penalty of perjury that the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Okay. Who now wants to give testimony? Just Keith? April, do you have any more? You want to do more too?
Yes, on this bill.
Okay. Why don't you go ahead?
Okay.
And then we'll do Mr. Parsons. And Ms. Mellon, do you have any oral testimony? You have a little. Okay, so we'll go in that order.
Okay.
Okay.
I would not start from the beginning, but I would be remiss if I didn't acknowledge the testimony that we heard earlier today, particularly from Mr. and Mrs. Hunter L. and their experience at their former residence, and Ms. Powell, who testified earlier about her mother who passed away within 30 days and moving into her unit. We never want to hear stories like that, and so definitely sorry to hear about their experiences and thank them for appearing today. Now, turning to Bill 26287, the Housing with Integrity Act of 2025, this bill will require DLCP to deny the issuance of a new basic business license to a person, business entity, or beneficial owner with the ownership interest in a rental property with 10 or more units that have uncured Class 1 and Class 2 housing code violations affecting 30% or more of the units. It will also require DLCP and DOB to work together to determine whether a basic business license should be denied on those grounds. DLCP supports the intent of the bill, which is to create stronger accountability among the district's rental housing operators and to protect tenants from unsafe living conditions. Ensuring district residents live in safe and healthy living conditions is a goal that the council and DLCP both share. The inclusion of DOB in the bill reflects that DLCP and DOB work in partnership to hold unlawful rental housing operators accountable. Also, the focus on the denial of operators' new business license as opposed to the denial of a renewal license will ensure the district holds rental housing operators with existing violations accountable while adhering to the existing legal requirements. Again, for the betterment of tenants. DLC appreciates the attention the council is giving to rental housing conditions. This is an issue that the agency has been wrestling with and cares greatly about as well. We have been working with other district agencies, DOB, OAG, and several others to hold nefarious rental property owners accountable. The issue is complex and requires the coordination of multiple agencies and stakeholders. Thus, we are grateful for this opportunity to speak with you today, as well as at the roundtable next week. Focusing our attention on DOB and DLCP, the agencies frequently do already work together. We frequently refer cases to one another for enforcement on matters that are within our purview. We regularly receive referrals from DOB for cases involving rental housing operators. The most common referral is for unlicensed business rental activity. In FY25, DOB referred 398 cases to our agency for enforcement action. Similarly, DLCP has received cases from DOB where the property owner had outstanding housing code infractions, and we handled those as well. The number of cases DOB has referred to DLCP has increased 566% since FY24 to F125. And we expect this number to continue to increase as the agencies continue to work together to hold property owners accountable and protect our residents. We have a process in place for referring cases to one another for enforcement. We are continuing to explore other avenues and means of enhancing that and building upon what we are already doing. The agencies have been discussing a new case referral process to address particular issues similar to what is before us today in this bill. We request that the committee give the agencies the opportunity to implement this process so we can see how it is working, to tweak it along the way, and we are happy to also keep the committee abreast of our progress, as I know that will be important to you. Should the committee proceed with the bill, there are a few technical amendments that I will recommend. First, we will recommend that the committee identify what section of the general licensing law ought to be amended. As you're aware, the BEST Act, the council passed and was implemented on October 1st, made several changes to the law, not only the changes to licensing fees and fines, but also realigning certain provisions. And in this particular case, it repealed section 472851.11, which is referenced in the bill. Second, we will recommend striking shall not issue a basic business license and replacing it with may not issue a basic business license in accordance with the director's authority as set forth in DC Official Code section 47-2851.02B. It is important to us that we maintain the director's discretion in handling business license matters. And so that will be our recommendation to adhere to that, to remove the mandatory denial to make it discretionary. And we will work with the committee as well on any additional alternative wording that will be helpful. And lastly, we will recommend clarifying the type of basic business license an apartment house applicant will receive. One of the hallmarks of the BEST Act, is that it streamlines our business categories and endorsements from over to 100 to 13. The category that will apply here will be the housing and lodging services license. And so we would just recommend just for that clarification, as I think that will also align with the intent of the bill that is really focused on preventing the property owners, the nefarious ones, from getting another business license to operate an apartment complex as opposed to any type of business license. Again, I would like to thank the committee again for allowing me to testify today and for your ongoing efforts in addressing this critical matter. We look forward to answering any questions that you may have. Thank you.
Good evening, Chairperson Nadeau, fellow council members, and staff. I am Keith Parsons, Strategic Enforcement Administrator for the DC Department of Buildings, or DOB. Thank you for the opportunity to be here today to discuss the Housing with Integrity Amendment Act of 2025. At DOB, our mission is simple but essential. We protect the safety of residents, businesses, and visitors of the district, and we help shape a built environment that's safe, sustainable, and moving forward. Everything we do ties back to those goals. We support legislation that aligns with this mission, and we appreciate the intent behind this bill. It reflects the same values that guide our work every day, making sure every district resident has a safe, code-compliant home that's properly maintained. DOB has always made housing integrity a top priority. Our Office of Strategic Code Enforcement focuses on properties that are chronically non-compliant, meaning they have serious or repeated code issues, and we work closely with owners to get them back into compliance. In fiscal year 24 alone, DOB inspectors identified more than 35,000 violations and achieved abatement on roughly half within the same year. We also collected more than $2.6 million in fines. This legislation builds on those ideas, strengthening code enforcement, improving living conditions, and holding violators accountable. We support these goals wholeheartedly. However, some provisions of this bill in their current form could stretch our available resources or inadvertently complicate enforcement. With a few refinements, we believe this legislation could more effectively and sustainably achieve its goals. First, we recommend focusing the bill by targeting fewer violations. The legislation in review today proposes calculating penalty thresholds using what district regulations refer to as Class 1 and Class 2 violations. In the district regulations, every civil violation is given a numbered class that controls the fine amount for the violation. Generally, Class 1 are the worst violations with the highest fines. We recommend that this bill only target Class 1 violations, which represent the most severe risks, such as life safety, structural, or habitability hazards. Including lower classes of violations unnecessarily complicates enforcement administration and risks diluting the legislation's impact by spreading its requirements to properties with lower priority issues. Based on DOB data, the bill as written would impact approximately the worst 6% of units in the district. This means 18,000 units at about 900 properties would be targeted. A narrower focus on the worst 2 to 3%, those with persistent high-risk violations, would achieve the intended accountability while maintaining operational feasibility and fairness. Second, the proposed complication of the tiered inspection structure in the unfunded proactive inspection law is excessive. The current law proposes a two-tier system. Tier 1 properties are those at highest risk and inspected every 2 years, and Tier 2 properties are inspected every 6 years. This already exceeds DOB's current resources, leading to the proactive inspection law's substantial unfunded fiscal impact of about $2 million per fiscal year. Introducing a new Super Tier 1 requiring twice yearly inspections would nearly double the fiscal impact to execute the program. Without appropriate funding and staffing, the tier system envisioned by the Housing with Integrity Amendment Act cannot function as intended. Our inspectors already balance scheduled proactive visits, complaint-based inspections, and follow-up enforcement actions. The proposed inspection frequency would require more new proactive inspections than DOB currently performs in an entire year. DOB conducts approximately 30,000 proactive inspections annually. The proposed twice-yearly inspections applied to the 18,500 units targeted by the bill would require an additional 37,000 inspections, an increase that we cannot absorb without 17 new inspectors, in addition to more managers, attorneys, and support staff. While we appreciate the Council's desire for stronger oversight, quadrupling Tier 1's inspection frequency without additional resources could result in longer turnaround times, slower follow-ups, and diminished attention to the most critical cases. A phased or targeted approach, beginning with the highest risk properties, is more realistic and sustainable. Third, as already testified to by my colleagues, DOB already collaborates closely with the Department of Licensing and Consumer Protection to improve the safety and integrity of rental housing. The yearly strategic enforcement reports produced by my office demonstrate how coordinated inspections, data sharing, and joint actions can drive accountability and compliance. While we support codifying strong interagency partnerships, DOB recommends retaining discretionary flexibility in how this coordination occurs. A rigid statutory framework could limit our ability to adapt enforcement strategies based on emerging patterns or resource shifts. Maintaining flexible collaboration allows both agencies to respond swiftly to changing conditions. Several provisions of the bill would give DLCP authority it already possesses under existing law, such as the ability to deny a basic business license to landlords with unresolved housing code violations. Instead of duplicating authority, we recommend that Council focus on strengthening and resourcing existing enforcement tools, particularly those that have already proven effective when paired with DOB's inspection data. DOB's strategic enforcement team continues to prioritize enforcement against the worst repeat offenders who are responsible for a disproportionate share of code violations across the district. This data-driven approach directs enforcement where it has the greatest impact, improving living conditions for tenants and focusing limited resources where they can do the most good. We believe that continuing this targeted model, supported by adequate funding and interagency cooperation, will advance the spirit of the Housing with Integrity Act more effectively than a broad one-size-fits-all inspection mandate. In closing, DOB supports the intent of the Housing with Integrity Amendment Act to strengthen enforcement, protect residents, and promote accountability among property owners. We respectfully urge the Council to consider these practical adjustments, focus violation thresholds on Class 1 infractions, and increase thresholds to target closer to 2% of units and addresses. Maintain the current two-tiered proactive inspection structure and frequency. Secure funding for proactive inspections under the current unfunded law before expanding scope. And avoid redundancy by leveraging existing discretionary DLCP authorities while supporting targeted enforcement against the district's most persistent violators. With these refinements, we believe the legislation can achieve its goals in a way that is effective, equitable, and operationally sustainable. Thank you for the opportunity to testify, and I look forward to answering your questions.
Good evening, Chairperson Nadeau. I'll be brief. The Office of Attorney General, as you know, our role in the housing conditions enforcement ecosystem, which is how I'd like to frame up the conversation. I know the council has been focused on the housing ecosystem overall, is on investigations and litigation involving systemic building-wide conditions, the worst of the worst actors. Because we can only address a small number of cases, and I know we will get into that, a strong administrative enforcement scheme and partnership with the agencies here today and other district agencies is critical to the work we do as well. Thank you.
Thank you very much. Starting with DOB, how many reports of housing code violations did DOB receive in FY24 and FY25?
In fiscal year 24, we received 8,381 distinct complaint-based housing code cases. And in fiscal year 25, we received 11,202 cases.
Okay, and I should note we're doing 10-minute rounds. Councilmember Lewis George will have a round after me. Okay, what is the investigation and enforcement process after a report has been made?
After a complaint-based request is made, an inspection is scheduled for the property that the complaint was made about. An inspector goes out, looks at the property, determines what's broken, if anything, and a notice of infraction is generated and served on the property owner. Once the notice of infraction is served, if the property owner abates the violation within some time periods, the NOI will simply be closed. If it takes longer, we will attempt to settle it with the property owner. And if the property owner insists, or if the violations are not abated, it will be adjudicated and DOB will seek payment of the fines.
And how many total violations remain unaddressed of the ones that we've been talking about?
I believe the total unaddressed violations for all time is around 53,000 on the dashboard.
Wow, okay.
That is since 2018, which is the start of our good data window.
All right, so that is not even a decade, though. Any idea how many remain open from the last 2 fiscal years or 1 fiscal year at a time?
Yes. For fiscal year 24 violations, as of right now, 37.2% are still unabated. And for fiscal year 25, as of right now, 61.1% are unabated.
And how about unpaid fines?
In fiscal year 24, the original fine amount of served NOIs was about $17 million, but the amount invoiced was only $615,000, of which $203,000 was paid. So 33% invoiced or paid. And the distinction here is that we can write the number on a piece of paper and issue an original fine, but until it is invoiced, that's the status that indicates we had a ruling and could collect.
Okay.
So we collected 33% of what we were entitled to collect. For fiscal year 25, face value was about $5,100,000. Invoiced amount, $344,000, of which 91,000 has been paid. So about 26.5% of invoiced fines have been paid.
Thanks. Okay. Could you explain the difference between Class 1 and Class 2 violations?
Generally speaking, as I said in my testimony, the Class 1 are just worse. Whenever the regulations were promulgated, the people who were promulgating them at that time created the classes. They controlled the amount of the fine, and they chose which ones to put in Class 1 and which ones to put in Class 2.
In your testimony, you recommended only targeting Class 1 violations, which is about 2 to 3% of buildings in the district, or roughly around 7,000 units. However, the number of unresolved housing code violations is much higher than 7,000. How does adjusting the applicable violations help address all of the violations?
Well, I take it that the intent of the bill is to focus on some definition of the worst properties. So if you're trying to fix all the violations with an equal level of focus, you're not really focusing at all. So the suggestion to use Class 1 just increases the focus of the bill. And because Class 1 are already the worst as determined by the class system, it's an easy way to provide that focus.
According to the testimony we heard earlier, Class 1 doesn't even cover missing or broken locks on doors, which I think we can agree is an egregious safety issue. Is the solution to update what constitutes a Class 1 violation?
I mean, I don't have a strong opinion on whether any particular violation should be 1 or 2. If the bill were revised to target Class 1 and the council thought that there were violations that were missing from Class 1, obviously that could also be changed. They could be bumped up. They would have a higher fine and would be included in the targeting mechanism.
Okay. I want to ask about Benning Park Apartments in Ward 7 who've been dealing with deplorable conditions. The tenant association requested that DOB use the nuisance abatement fund, as more than 50 families have been without hot water for as long as over a month. Does DOB plan to use the fund for this property?
The final decision hasn't been made, but I have been investigating the possibility of using the fund. We did get an estimate that it would cost about $58,000 to fix those hot water heaters. So that is under consideration.
Okay. When will you have the decision?
I don't know because it's not only my decision, but we can certainly keep council up to date on where we are.
Yeah, we had a couple people testify today. You probably heard them from the property. Okay. Okay. So now I want to talk about how DOB and DLCP work together on this issue. In your testimony, Ms. Randall, you noted that DOB refers cases to DLCP involving rental housing operators with business licensing issues, including properties with outstanding code violations. How many cases related to outstanding code violations did DOB refer to DLCP in FY25?
I have to get back to you on that. We have to go to that level of granular details.
Okay. Well, in your testimony, you note that unlicensed rentals are the most common referral, and there were 398 of these. So we can assume there are fewer referrals for code violations. This seems low given the number of outstanding violations that DOB currently has. Any idea why it would be so low?
I cannot say, council member, but we are getting referrals from them. We are working. It will require us to also investigate and see what enforcement action we can take, but also recognize that DOB also partners and works for other agencies to address some of those more egregious situations as well. For us, when we do receive them, we do conduct our own investigation, see what action we can take as an agency, aside from issuing NOI, again, the suspending or revoking a license, but recognizing that is very great because you have individuals that are living in those properties. So to revoke the license, now you have individual families in unlicensed properties. But we do also and have flagged in our licensing system, both on the BBL side, and can also put a notation on court so we can try to identify them should they apply again. Because again, although this bill will require the department to deny a license, we can already do that, but we have to know that the violations are there. So that's why further enhancing our coordination and sharing data will be essential. And we're working on that, but we are, to your point, to your question rather, are getting cases from them and handling them within the ability that we can.
Not really. Okay. How does DOB decide to make a referral?
Generally, we refer cases that are in what we see from our side as the sort of bullseye DLCP, CPU jurisdiction, right? Consumer protection cases, unlicensed property cases, and things like that. In the case of multi-unit properties that are in distress, if the property happens to have an active business license, because many distressed properties already don't have an active license. So sometimes when it's a multi-unit property in distress, trying to take action on the license is almost a step backwards. And if we have a licensed party that is responding to us, we can use other hooks than trying to remove the business license.
Okay. I'm going to turn to my colleague from Ward 4 for a round of questions. She's on the Zoom.
Thank you so much, Councilmember Nadeau. And thank you to our government witnesses who are present and who I've seen you all be there all day. And so thank you all so much. As I stated in my opening remarks this morning, I'm constantly receiving calls from constituents dealing with serious health and safety concerns in their homes. And these are tenants who are calling Department of Buildings for help and often do not know whether that call will lead to real impacts on their quality of life. This morning, we also heard from a number of residents with very serious housing code violations in their homes. I think it's alarming to hear of residents calling DOB out to their home 2, 3, 4 times and still struggling to see improvement. I think that speaks to the urgent need for better, strong enforcement mechanism. It's not that DOB is not showing up. It's not that DOB is not there doing their job. And we're grateful for the work DOB does and their responsiveness and community service. I do want to note that. It's been one of the agencies, some of the best in the city. Responsiveness is from an agency I've seen. But I do want to note that I think that the need for them to call you out 2 to 3 times and not see improvement speaks to the urgent need for better, stronger enforcement mechanisms so that when people call DOB, they know that action will be taken. And once an NOI is done, that actually is going to lead to real lasting change and the quality of their homes and lives will improve. For DOB, with current Department of Building practices, our understanding is that the main enforcement tool you employ are fines, correct?
It depends what you mean by main enforcement tool, but we do issue many notices of infraction and many fines. We do lots of other things as well, but numerically, yes.
Yeah. And you stated earlier that of the $17 million in NOIs issued, not even $300,000 have been paid of just 616,000 invoice. Is that the correct number?
Yes, those are the fiscal year 24 numbers. We collected 33% of the invoiced amount.
Why are so few fines invoiced and why are so few fines paid? That is egregious. $17 million in NOIs issued and not even $300,000 have been paid of just the 616,000 invoice. What is happening there?
There are a lot of reasons why a issued fine might not be invoiced. For example, if an issued fine goes out, the NOI goes out, and the landlord promptly abates and qualifies for deferred enforcement, we would close out the case and it would not be invoiced, it would not be collected. Everything that is still going through the adjudication process hasn't been invoiced yet. So all of the things that are in progress there are not going to be invoiced. If there is a settlement, then the invoiced amount will reflect the settlement. So if the original NOI is $10,000 and we settle for $1,000, $9,000 of the decrease could be in there. So there are quite a lot of reasons why the sticker value and the invoice value wouldn't match. The Department of Buildings considers the sticker value as sort of an incentive and a bargaining point to get abatement. It's not a sticker that we are trying to recover the whole amount. We're not trying to get fines. We're trying to get abatement. The reason for the difference between invoiced and paid amounts is, first off, the Department of Buildings is not a collection agency. We do, in fact, collect during a period before fines go to the central collection unit, but it's not like we have any staff dedicated to calling people up or trying to collect from them. So we collect what we can through our ongoing interaction with the customer as the case sort of concludes, right? If we've just won the case and we are owed the money, we will try to get them to pay it. But if they do not in fact pay it, then it would move on to the central collection unit. And you know, in the Wayback Machine, I was an attorney in private practice and tried to collect money out there. And collections is fundamentally a hard
Yeah.
thing to do.
Given your statement earlier about the tens of thousands of violations still left unabated, there's clearly clear bottlenecks there. I wanted to ask if fines aren't an effective enforcement tool, what is? And what would you need in order to ensure compliance with the housing code?
Well, the fines are not right now a complete enforcement tool. I think we need to sort of start by attributing the current level of abatement that we do get in part to the fines as an incentive. The additional tools that we do have escalation options through the Office of the Attorney General and other means, and those are often resource intensive. Some additional tool, one additional tool that I've been looking at, I heard from my colleagues at the Office of the Attorney General about what I've been calling colloquially the LLC death penalty. Under district law, a corporation that is an actual INC corporation can be disbanded by a suit from the Attorney General if it is found to be violating public policy, being a bad business or whatever. A limited liability corporation, an LLC, simply can't do that because they are structured differently in the law. Because most properties that are problem properties are held in single-purpose ownership LLCs, allowing those to be immediately disbanded for public policy reasons in a lawsuit could be a quicker way than some of the existing tools that we work with RAG on, such as receivership cases or nuisance cases. You know, we've tried a number of different angles, and the LLC death penalty might be a more direct road.
Got it. Mr. Parsons, I understand your recommendation to more narrowly focus on the top 2 to 3% of the worst landlords, and that this bill, if enacted, would instead sort of target the top 6%. While I recognize the concerns about whether DOB has sufficient resources, is it truly the department's position that holding just 6% of bad actors in our housing ecosystem accountable would be so overly burdensome as to be infeasible?
Well, I think as I testified earlier, it's a question of focus and how much you want to focus, right? So every property in the district is getting some level of focus. We will respond to a complaint from anybody at any rental property. We will look at that. Where do you want the additional focus to go? And the more focused the additional focus is, the more it's going to be able to actually have the resources to follow through on it. So my suggestion is that a narrower focus will allow more energy to be put into it. It will allow it to be more effective. Obviously, if the bill passes with the current focus or even with a wider focus, as many witnesses asked for, we will have to look at our resources and try to make that happen.
Got it. So thinking about that, how to best focus DOB enforcement, I appreciate that your response. You recommend narrowing the scope of this bill this bill only target Class 1 violations, since Class 1 violations are the most serious and sort of have the highest level of fines. Can you describe what constitutes a Class 2 infractions?
Sure, and I did talk about this a little bit with the chairperson as well. The violations are assigned a class in the regulations. It controls the value of the fine. As far as I can tell, it just reflects the judgment at the time the regulations were passed about how important the violations were.
Got it. So because my question was going to be sort of why violations like failure to provide adequate heat, failure to provide proper utilities, allowing trash to pile up, failure to maintain elevators, things like that aren't considered serious enough for enhanced enforcement. And so I guess that would be a matter of amending that language for those type of violations to be considered a higher class.
It would be possible to move some violations into Class 1 if the bill were targeted as Class 1. That is correct.
Understood. Okay. Would you during public testimony this morning, my time is up and I will finish on the next round. Thanks.
All right. Keep tag teaming here. All right. So what does the current case referral process between DOB and DLCP look like? Is this done via email?
I will defer a little bit to my colleague, but from my side, it is a lot of it either email or using DLCP's sort of normal referral form that the public uses. Referrals go primarily through my division, but they're not limited to it. So everyone at DOB is sort of aware of DLCP as a previous agency that used to be part of the same agency. And if they see something, they say something, they will refer it. So it's not a uniform process. It would primarily probably be email or their complaint form.
I will concur with that, Councilmember Nadeau. That is how that process works. Although we both use Excel, we do not have access to each other's systems within Excel, so we cannot see everything. So it does require an actual email referral or filling out the complaint form of sorts.
Thank you. What does the current, sorry. Yeah, it's okay. What does the new case referral process that you mentioned in your testimony look like?
Well, I'm happy to start, and Mr. Parsons can add on. What we were looking at, we are focusing on the Class 1s and the size of the apartment units, because when they start sending these additional referrals to us, that is going to require additional resources, both for our investigators, the attorneys. So we wanted to have a reasonable number to begin with, and also
Sure.
recognizing that once we start taking action, whether it's the revoking or suspending a license or not approving a future license or renewal, then we're expecting more cases at OAH.
Mhm.
So then again, additional manpower, woman power on behalf of our OGC team. So it's starting with the class 1 cases, class 1 infractions, units at properties of 50 units or more, I think is what we decide on. So we can target the larger apartment units so that we can then investigate those and then determine what sort of action we would then take. But I will also ask my colleague to add on.
Certainly. And, we have the ability to give DLCP whatever they would request to suspend a license or whatever. So if they want to see all the violations that are open on the property, if they want to see all of the actual NOIs, if they want more detailed investigations, those are all things that are possible.
Doesn't DOB need to first send over the properties with violations?
I mean, if that's where DLCP wanted to start, we could certainly start with the data analysis. There's a whole bunch of data already out there on the dashboard as well. But yeah, if we were going to start to try to see, all the properties of 50 units or more with some violation profile, the data team could generate that pretty easily.
Okay. So when is the new procedure going to start? It doesn't sound like it's completely solidified.
We're continuing to have the conversation. We're hoping to roll it out. But again, it's just building on what we're already doing because they can already refer the cases. We're just recognizing how we can now further target and address these more egregious situations to protect our residents. But again, these referrals were already taking place.
How many licenses did DLCP deny due to unaddressed housing conditions in FY24 and FY25?
I will have to get back to you with that number, Councilman.
Do you do it often?
Deny. I'm sorry, repeat the question.
Deny a license due to unaddressed housing conditions.
We would have to know about it. So we don't, it depends on if we have the information. We do not always have the information, but it is something that we have done and can flag. I do not know that exact number, but again, it's dependent on actually having the information of the housing code violations.
Okay, but is it something you seek out when you're doing licensing?
No, it's not an ordinary part of the license process to either at the initial stage or for renewal.
So what do you currently use as the threshold for denial? Is it a certain number of violations or unaddressed violations or other metric?
It's more of a holistic approach because also when you're thinking about the outstanding violations, you also have to see that individual may be trying, the property owner may be trying to address to abate the problems and address the violations. And we don't know if those violations have also been appealed with OAH, in which case we would not want to deny the license then because it's not a final decision. OAH could reverse it. So we definitely want to ensure that we are applying the law, but being cognizant of the fact that there are other ancillary factors that we need to consider.
Do you look at other properties an applicant might own when you're approving their licensure? Licensing them?
I will have to ask the licensing team, but if we would have to track it. We have to use our corporate line, which is all of our systems. But I would have to ask them to give more details about if they then, if one property owner, if they then look at it when they apply for another license. I know we can definitely, they can flag it. We have done that. They have done that. I've talked to them about that. But the frequency and how, I will have to get more details.
How would DLCP use discretion if the language in the bill were to be changed from may to shall?
Similar to how we do it now, council member. So the law states that if one is in compliance with district law, you shall issue the license. Here, we can use the outstanding, interpret not complying with the housing code violations as a basis for not being in compliance with district law and not being a basis for issuing the license. What we're really saying is that the law already allows the director to deny the license. So this is actually somewhat duplicative.
Okay. If DLCP decides to use this discretion to issue a new license despite significant violations, because a property owner is currently working on addressing their housing code violations, my concern is there's no mechanism to ensure those violations are actually addressed. Couldn't someone just stop any efforts once they've gotten their new license?
Anything is possible. We will hope that is not the case. I think that's what all of us will hope. I mean, quite frankly, I'm sure when DOB issues the NOI from the outset, they're hoping that they would pay the NOI and abate the problem. There are always going to be individuals that are not going to comply. But when we're also focusing on making legislative changes, we do not want it to be such that it's adversely affecting those that it could have just been a hard time and they are struggling with correcting the issue, or this is not an ordinary sense, and it's really this, although it's a huge impact, and we heard that from the witnesses today, but that's not the total of the licensee. So we want to be kind of careful with that, and so that's how I will caution it.
Okay. What resources are needed to implement the bill?
I'm happy to speak to it for DLCP's purview. One, you already heard that most of the transfer, if the bill were to pass, most of this, the referrals are by email. So if you want to ensure that the information is being shared timely, possibly even creating a new system, and thus hiring someone, funds to create this new IT system to ensure the sharing of the data in real time. On the enforcement side, additional investigators will be needed there, licensing, at least a licensed specialist or two. And then we are expecting that if this bill should pass, appeals to OAH, so additional attorneys and paralegal staff, so admin staff.
Thank you. I'll now turn to my Ward 4 colleague for another round of questions.
Thank you. Mr. Parsons, I want to go back to sort of understanding regarding who it is this bill targets and the narrowing. One thing I love about not having directors, but having people who've been doing this work a really, really long time is that you guys have some expertise that we can actually pick through to make legislations better. So I wanted to ask you in like your opinion, sort of which class 2 violations you think are not serious enough to be considered in this highest tier for enhanced enforcement.
Well, I haven't gone through the class 2s sort of line by line recently. The suggestion to focus on class 1 violations is based around a desire to focus the bill more and keep it focused at the very worst properties.
Got it. And so I guess when I look at it, hold on.
Yes, ma'am.
I wanted to understand sort of, I guess, how targeting the worst 9,000 units versus the worst 18,000 units would achieve the intent of this bill.
Well, it's about the amount of resources and the amount of effort that DOB is putting out that is sort of not available for discretionary focus.
Understood.
So, you know, if the resources are there, you know, you can make it target as much as you want. It'll require more resources to do more. If the resources are set, the more you lock down in the bill, the less I will have to do other things that may come up.
Got it. In your testimony, you all state that you do 30,000 proactive inspections annually. How many inspectors do you have that complete those 30,000 inspections? Sort of, yeah.
I believe the current proactive team is a manager, 9 inspectors, 1 or 2 support staff. I'm fuzzing this because I don't think they are just expressly dedicated to proactive. They work across the housing inspections team. And I would estimate that the NOIs generated from the proactive workload probably occupy at least 3 attorneys.
Got it. And so in terms of needing to implement this bill, you believe you would need probably double the managers, support staff, attorneys. What would that look like, sort of increased operationally resources?
Well, to implement this bill, the proactive bill that was passed and unfunded would have to be funded. And so that was 17 new inspectors, 2 new managers, 8 new support staff, and 5 new attorneys. And then this would require even more of that. So I haven't prepared a detailed FIS, but I'd say combining with funding proactive, which was about $2 million a year under the old FIS, and this additional volume, you're looking at $3 to $5 million a year.
Got it. And what percentage would you say of the 30,000 annual proactive inspections target the same sort of 6% of bad actors targeted by this bill?
It's a hard question to answer precisely because the sort of current proactive program is based off an algorithm and attempts to cover the entire licensed multi-unit universe. So that's the sort of day-to-day direction of the team. We are looking to actually expand the universe to include unlicensed properties, just because those are probably the worst, since we know they're out of license compliance. But that's still in progress. And then when we do special focused efforts, because we're in a space right now where the proactive bill isn't funded, and so the proactive direction is sort of discretionary with the agency. When we look to do special efforts, we often divert resources from the regular day-to-day algorithm-driven inspections to do those special efforts. So if you've seen some of the press releases we put out over the past year, we very often pulled from that well of resources to do those targeted efforts.
Understood. Ms. Randall, how would DLCP ensure that when DOB identifies a property that meets the threshold this bill sets out, that the property owner will not be able to attain a new basic business license at a new property?
Well, if we get the information, we would identify and flag it in our licensing system to monitor for when they apply. Now, if they apply under a different name, it would require a little bit additional effort, but we will also, and we've done this, we have notified the licensing team so they can flag it in their database, as well as our corporations division so they can identify it in Corp Online. One of the things that we are moving toward, spend a lot of talk about the new Corp Online system, which will launch in December. The next phase is actually to combine our business licensing system with that system. So we will already have that information. So it could actually make it a little bit easier.
Got it. Got it. So what about renewals then? I know because the entity renewing should be the same as the one currently holding the basic business license. So would there be any difficulty in identifying those owners within the new system?
No, but with renewals, I do want to caution, and it's similar to revoking or suspending a license. If we were to deny the renewal of a license, we recognize the egregiousness of this. But we also, I want to put this out there, if we deny the renewal, then you have individuals in an unlicensed property. So what then? And how do we further protect them? Is that what we want to also incentivize? I do not think so. So that's the cautionary tale, or hesitancy around it.
I hear you. And I agree. I hear your concerns about rentals operating without business license. And I saw in your testimony that DOB referred 398 cases regarding unlicensed rentals last fiscal year. Can you tell me the outcomes of those cases? Sort of, did DLCP's intervention result in these properties coming into compliance and receiving a basic business license? Sort of, what are the impacts of a property not having a business license, and what happened with those 398 cases? Because that would be telling to sort of the concerns that you all are raising.
We had to follow with the exact details, but when the referrals do come in, I can talk to you about it high level, but can get back to you on the exact outcomes for some of those cases.
Yeah.
They are then sent to our consumer protection unit, assigned to an investigator for investigation to see what on our side, it may be CPPA violations. If they're unlicensed, they're citing them for operating without a license and other infractions within our purview. We run into some of the same challenges that Mr. Parsons has about getting people to play those NOIs, because then they can also appeal to OAH and getting the waiting for that process to go through. We are looking at other mechanisms for once we get final orders from OAH, and when they still do not comply by paying the license, including the use of liens. But that is a process that we haven't yet used, and we're finalizing that. But I'll get back to you on your exact question about what some of the outcomes are in some of those particular cases. But that is how they are handled when they are referred to us.
Great. I appreciate that follow-up. And do you have a sense of the impacts on tenants living in unlicensed properties?
I'm sorry, Councilmember, would you mind repeating the question?
You have a sense of sort of the impacts on tenants living in unlicensed properties?
Oh, yes. If they're, it's one, we do not want to encourage that, but two, it would, and not in all circumstances, because we're not saying that this happens all the times, but when what does happen in some circumstances, when tenants find out that their property owner is not licensed, they're not inclined to want to pay the rent. And when they're not paying the rent, the property owner cannot make the corrections and abate the violation. So then you run into this cycle that we do not want to encourage.
Got it. Okay, understood. Councilwoman Nadeau, can I ask one more question regarding OAG? So that way, this is my last round. And
yeah, go ahead. Take your time.
Thank you so much. Ms. Mellon, earlier this evening, Mr. Parsons stated that their partnership with OAG is a key part of their enforcement on housing code violations. Can you speak a little more to how it is that OAG and DOB work together to ensure negligent property owners are held accountable? And sort of how many properties is your office able to assist each year to get housing code violations abated?
Yes, happy to answer both. In terms of the partnership, I will say we are in touch with Keith Parsons and his team on a weekly, if not daily basis. Earlier this year, the Attorney General launched the Housing Protection and Affordability Initiative, so we could really focus on housing issues in our office. As part of that, one of our long-term housing members, RG Wetherington, who's been with the district for over 10 years, now has a new title and new responsibility. She is special counsel for Housing Code and Property Maintenance Code Enforcement. So she has been interfacing with DOB, and we've really stepped that up. I will also say that when we get referrals, so we get dozens of referrals every year from multiple sources. One of the first things we do is look at the DOB dashboard to see where that property is. When has DOB been out? What are we seeing show up in recent inspections? And that's a good picture for us. And then depending on what we're seeing, we also will follow up with Mr. Parsons or other contacts at DOB. And I should also mention, we have a consumer mediation program that receives hundreds of complaints every year from tenants that we mediate individual issues with landlords, many of them housing conditions. We are always looking at those complaints to see patterns. You know, are we having multiple tenants from a property who are suddenly coming in with complaints? Are we seeing properties with the same property management company or same owner coming in? And that information is then shared with our housing conditions team so they can follow up. Just to put some numbers on the record, from going back to January 1st, 2023, so looking at that time period, let me take that back. Let me start with right now. So we have 36 open litigation matters in DC Superior Court and the US Bankruptcy Court for the District of Columbia. So we have owners who file for bankruptcy, we litigate those cases as well. We have about 24 additional investigations open right now. If we go back to January 1st, what I would add to that from 2023 is we have resolved 10 litigation or investigation matters. In those 10 matters alone, we were able to get awards for $13.7 million in penalties and tenant restitution, meaning refunds of rent to tenants. So that just gives you some sense. We're working with a much smaller universe when it comes to our investigations and litigation. It starts with really hundreds of complaints that come in either individually through consumer mediation or through a number of other sources, including DOB.
Great. And you said earlier, I think one of the key things is how the work of OAG would also be helped by there being some accountability on and better execution on the executive side. I think that's a key piece because you all can't do all the work, and you're not set up to do all the work, and you're not the right mechanism to do what needs to be done in that case. So I look forward to working with you all and the continued partnership, and appreciate the partnership across the board from DLB to OAG, DLCP. It sounds to me that you guys are really working together, speaking on a daily basis, talking on a daily basis, and I truly appreciate that. So let's get this enforcement mechanism right, and make sure that the right agencies are doing the right things so that we can hold landlords accountable in a way that's actually meaningful and result in corrected actions and a better living condition for tenants. So thank you all, and thank you, Councilmember Nadeau.
Thank you, Councilmember. Okay. All right. So I hear from DLCP and DOB that you're both saying you're already doing some of what this bill mandates, but we have 53,000 unresolved violations. So what do we need to do here to actually address housing quality issues? Because clearly what we're doing now is not sufficient.
Well, I'll jump in there. One of the other things that I am hoping to build more of, we've already talked about at the very start, which is district direct abatement of basically determining that housing violations are nuisances and building capacity within the district to go out, repair the nuisance, and then place a lien on the property. This is actually a pre-existing constitutionally sufficient chain of enforcement. It's different from OAH, and it is faster than OAH and guarantees that the problem got fixed. The big disadvantage is that the district has to front the money to do it and has to build that capacity to accomplish it. So that's one of the things that I am looking to grow the role of the agency in doing that. And I think that can help.
That is existing authority, right? I mean, that's been around for a while, but it hasn't been heavily utilized.
Correct.
Costs.
It's limited by funds, essentially. So
Because you have to assume you're never getting that money back, basically.
Yes, although ironically, the return on these liens is about 50%, which is better than the sticker return on the fines if we assumed we're getting the fines.
Just might be down the road.
Yes, you have to.
You can't really count it in the fiscal plan.
Correct. You have to cast the bread upon the water and wait for it to return to you eventually.
But at a rate of 50%, it's better than some investments we could be making.
That's correct.
Okay. How realistic is it that you could relaunch this given the fiscal situation?
Well, it already exists, right? We already do this for trash and weeds with a lot of regularity. We do it with higher ticket items with less regularity, but enough that it remains in our sort of toolkit, right? If a wall is about to fall over or something, we will step in and abate that sort of large scale nuisance.
Right.
The part to work on and the part to build, and we do have more nuisance abatement money this year than we had last year, so I'm going to use some of that in this direction, is to try to start building that capacity to do these important but smaller scale violations. So we're starting off trying to get our team installing missing smoke detectors, missing carbon monoxide detectors. That's sort of the place where there's a lot of value for relatively less effort. But as we get more success, I hope to be able to report that success and use it to get support for expanding the program.
That's the program that Bending Courts is asking for approval of, right?
Yes, that is correct.
We heard about a case earlier today where a tenant lost their arm in an elevator that had been repeatedly cited by DOB. Failure to maintain elevators is a Class 2 violation, which you suggest removing from this bill. This again also seems dangerous and a threat to health and safety. I know you said earlier you do not have opinions about what should be which type of violation, but as the head of the enforcement arm, it does seem like you should care about these cases that result in such a significant injury. So what would you say about that scenario?
Yeah, so I mean, like I said, if you wanted to make elevator violations a higher class, I don't have a strong opinion. I suspect that the reason it is not is because when you think about building safety, you think about things like fire safety and egress as the most important things. And elevators are, in that context, not appropriate to do egress, right? So you can have a building that has appropriate fire safety, appropriate egress, heat, utilities, et cetera, and it not have an elevator at all. For example, I live in a building that doesn't have one at all. So, I suspect that's probably why whenever they set out the classes, this was not the most important. But if that was to be changed, I don't think it would be a huge, I don't think it would break anything.
What's the role of property managers and property management companies in addressing housing quality issues?
So property managers are sometimes also a person that DOB can call up and try to help enlist in the abatement process. So properties often have a bunch of different parties with nested responsibilities, and DOB's decision to issue NOIs to the property owner is mostly because the property owner is the responsible party, the most basic responsible party. They may have also contracted with a property manager to do all sorts of things. The contract itself can vary probably as much as any other contracts. And there's not, unlike property owners, which are memorialized in public records, there's not an easy way to go and say, hey, what are all the property managers in DC? And even more importantly, what are all the properties that they're managing? So we know sometimes who the property manager is, sometimes that information is available to us and we take advantage of it. The reason they are not more integrated into the regular process is because it's not a uniform bucket of information, so we can't rely on always having it.
But if I may,
Please.
council member, so yes, just to build on or add on to what Mr. Parsons stated. So the property owner is the one that would be held liable, but the property manager has a fiduciary relationship and thus the responsibility to the property owner to notify him or her of material facts as it relates to the property. They're like the day-to-day, the eyes and ears of what's taking place. So if DOB were to conduct an inspection, identify issues that need to be abated, tells the property manager they're responsible for informing the property owner.
And how would requiring the licensing of property management companies as proposed in the Licensing for Accountability of Management of Properties Amendment Act help address housing quality issues and housing code enforcement?
Yes, thank you for the question. So I would say, just as a background, property managers, similar to real estate brokers, real estate agents, they're licensed by our real estate commission. There are certain licensing requirements, certification requirements in order to get a license. Property managers are also licensed by them. Unlike the real estate broker, property management companies, and thus unlike, I should say more so, unlike real estate firms, are not licensed by our real estate commission. So the licensing, the certification requirements, et cetera, those are not in place. And so oftentimes our real estate commission will get complaints from individuals about not only against the property manager, but also against the property management company. Makes sense, property management company has the deeper pockets, but the real estate commission does not have jurisdiction over them. So they would not be able to take enforcement action against the property management company. We would look on the CPU side, whether there's some other infractions we can cite them for, including the CPPA. Some cases OAG has handled, but by requiring that the property management company also get licensed, it increases, one, their accountability, ensures they're in alignment with some of these heightened licensure and certification requirements, gives more enforcement teeth for our real estate commission, who cannot handle those right now, and ultimately would then protect the tenants of these properties.
Okay. We did hear some testimony today that sometimes from AOBA about the need for property management companies to also be points of contact for enforcement. And it seems like that may be a missing link here, that it's just not something we collect.
The information about the property managers, we would have it because we license them.
Okay, but like, do you have them connected to the properties they manage anywhere?
We will have it in our records. Yeah.
Okay, so, but that is not publicly available.
Not publicly available,
Yeah.
but they can request.
The way,
it.
say, like, the owner of the property is when you search online.
Correct.
Okay. Are there any plans to incorporate data from Corp Online on the DOB public dashboard or the rent registry to provide better public data on owners who have violations across multiple properties?
Not currently. I always like to make our dashboards useful and helpful. So some of them do have filters by owner and do allow you to, by choosing an owner, if the exact same owner is the owner of multiple properties, you will see their impact there. We don't have a way to create what we call them aliases for someone, some entity that actually owns a bunch of properties. We don't currently have a way to create aliases reliably, even on the back end, let alone on the public dashboard. But if we get to that point, I would certainly consider putting that out there because I do think it is useful.
And I was just going to say, that wasn't something that we had personally discussed, Councilmember.
So now, of course, we have to talk about beneficial owner disclosure here because this bill relies on us knowing who actually owns properties. As you know, for the past 5 years, DLCP has been collecting data on LLC and other business entity ownership. We've repeatedly discussed this in DLCP's performance oversight hearings because DLCP is only checking for completion of these forms, not accuracy, which has led to reported examples such as company listings. Their office dog is the owner of an LLC that owned a large rental building. Do you think the law on this is operating effectively?
I will answer it in multiple different ways. The new Corp Online system will address many of those problems because you will have to, there is an internal check, so to speak. You have to complete that information in order to go to the next, to keep moving on in the process. I think one of the challenges with the current Corp Online system is that we can only gather one address. So when you're trying to find how to serve the property owner, beneficial owner, and you only have one address, and it may be the business address. In the new system, we'll be able to do business and another street address. Now, yes, entity, a beneficial owner can be a LLC, but that's by, it states a person, and that's just how it's defined. Individuals, a trust, LLC. So that's just how the law is
But not a
defined.
dog.
But not, well, I'm not familiar with that situation, so I can't speak to that.
But how do you check the accuracy of the names being put in?
I will have to speak with the superintendent on the checks, but the new system will have more verifications to help prevent unscrupulous information being entered into the system.
Does DLCP have the information to track housing code violations across different properties owned by different LLCs?
Not currently.
What would DLCP need to proactively enforce ownership disclosures so this could be better tracked?
Well, we would need to know the information, but not only that, we would then have to also connect it with the address as well as the system, the owners itself. It could be done. It's a little bit more complex. I have to get more details around it. But recognizing the gravity and the concern that it has presented, we can explore how and if it can be done.
Okay, I'm coming to OAG, and then we're going to Resale Act, just so everybody knows where we are here. Okay, so what types of complaints is OAG most often able to act on here?
So I want to answer in terms of our systemic litigation investigations and also consumer mediation, just to make sure we keep that in the mix. For systemic building-wide issues, we really look for the most serious violations: mold, water leaks, structural issues, trash not being picked up, fire safety issues, and we're also looking for the bad actors. And so if we see patterns, including a beneficial owner who has multiple single-purpose LLCs, and we are seeing a pattern across the properties in those LLCs, those are cases where we feel like are very resource intensive, as Keith mentioned. Enforcement cases are most appropriate, and those actors also often are somewhat impervious to the administrative enforcement regime that exists. In terms of consumer mediation, we respond to everything. And we're really encouraging tenants in the community, and we are out in community. We can resolve individual issues that are landlord, tenant, and any other merchant, consumer, business consumer transaction. And we do use that to look for patterns, as I mentioned.
What other options are there for tenants if OAG is unable to take on their case?
So there's the administrative enforcements. Of course, we make sure that DOB is aware, that our other government partners are aware. Sometimes that's DLCP, DPW, a number of other agencies. And private enforcement, of course. And I know that I don't have to tell you that legal services organizations, nonprofit, community-based organizations, they do not have the resources to handle all of this.
Has OAG been able to use beneficial ownership data from DLCP to take legal action against property owners or for any other uses?
We definitely have. So it's part of the standard kind of workup that we do when we are looking at building-wide and systemic issues, is to understand who is behind the LLC. We have other ways to look for that to the extent we're not finding it in the DLCP data that we have access to. We also work, of course, cooperatively with both agencies here to get information that may not be available to the public, and it does help us see those patterns. When we have a particularly bad slumlord who has multiple properties across the district, we have several of those now that we are litigating against. That's part of what we're doing, is trying to understand, okay, this individual is behind this LLC at this property, this property, this property. We need to understand the full scope. So let's go use the beneficial ownership information to put that puzzle together. And then part of what we are able to do is then alert other agencies, other partners. This is what we are seeing. And the three of us, these agencies at this table, work cooperatively to say, okay, the kind of portfolio of this particular individual or set of individuals includes these 50 addresses. Let's make sure that we are really looking at those properties. As Keith Parsons mentioned earlier, sometimes DOB will then do a blitz of inspections, for example, at all of those properties to make sure they're all getting eyes and getting coverage.
Okay, what challenges does the lack of accurate ownership data pose in housing condition cases or other housing cases?
We have to find other ways to track it down. I mean, we have to know. When we bring investigations, we are first focused at the owner. We do bring in property management companies or individual property managers where appropriate. That's always going to be fact dependent when we're talking about investigations and litigation. I will say to some of the earlier comments, the property manager or property management company often is the front line for those tenants. And so, for example, in our consumer mediation program, if we have an emergency, if there's no heat, we need a human. We have to get to a person to say, Beth Mellon, you own this property, you need to do something about the heat now.
Yeah.
And so it is really important to have that information and sometimes to know what attorneys work with them and just how can we get to them as quickly as possible.
Great. Thank you very much.
Of course.
Okay, thus concludes the government testimony on this particular bill. Thank you very much. We will now move to the government testimony on the Resale Act, for which we will be joined by Ryan Nicholas, Legislative Director, Office of the Deputy Mayor for Planning and Economic Development. And rejoined by Kevin Vermillion, who has already been sworn in. But Ryan, if you could raise your right hand. Let me find the exact wording to swear you in, although I could probably wing it. Do you swear or affirm under penalty of perjury the testimony you're about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth? Okay. Anybody other than Ryan want to give more oral testimony?
A brief oral testimony on behalf of OAG. Thank you, Council.
All right, you two decide who goes first.
Mine will be short. Thank you. Speaking on behalf of OAG, the Resale Act would enhance transparency in the live entertainment ticketing industry, enabling consumers to know exactly what they're buying and how much they're going to be paying for it. Much of OAG's work focuses on protecting consumers from deceptive practices, and the Resale Act has two provisions that would end misleading practices in the ticketing industry that I would like to focus on briefly: a requirement for all-in pricing and a ban on speculative ticket sales. OAG supports the Resale Act's requirement that ticket listings clearly and conspicuously disclose the total price of the ticket, including all fees and taxes. The advertised ticket price should be what consumers pay. Consumers should not be lured in by a deceptively low price and then have to navigate a burdensome purchase process only to be told at the end that large, unpredictable, and mandatory fees have been added on. This bill's requirement for all-in pricing means that when district consumers find a ticket that they want to buy, the price of that ticket is not going to skyrocket at the very last step of the purchase process. Additionally, the Act's prohibition on speculative ticket sales would also protect consumers from unscrupulous ticket resellers. Speculative ticket sales have led to consumers paying inflated prices for tickets that may never show up or turn out to be fake. Even when the tickets do show up later, consumers often were never told that they were buying a ticket that did not exist. The Resale Act's prohibition on speculative ticket sales means that when a consumer buys a ticket, They know that the seller actually has a ticket to give them. OAG has a big focus on affordability right now, and that is the main focus of the Office of Consumer Protection. And hidden fees are a big focus of that, big part of that focus on affordability. And hidden fees in the ticket industry are part of the work that OAG is doing. And we appreciate the council's focus on the ticketing industry because it is a very outsized issue for DC. DC spends on a per capita basis more than cities like New York and Los Angeles, Miami, Austin, Nashville on live event ticketing. And it is a wide range of those people and types of people that are going to live events and buying these tickets, and hidden fees are a huge problem in that industry. And it has been a major focus for our office. And so we appreciate the council focusing on it as well.
Good evening, Chairperson Nadeau and members and staff of the Committee on Public Works and Operations. My name is Ryan Nicholas, and I'm the Legislative Director for the Office of the Deputy Mayor for Planning and Economic Development. And I'm joined by my colleagues at DLCP. We are here to testify regarding the Resale Act. We are testifying in support of the intent of the bill, but believe that further evaluation of the issue and appropriate mechanisms of enforcement are necessary prior to passage to ensure that the district has a safe, fair, and regulated marketplace for the purchase and resale of concert tickets. Our two primary issues are, one, unintended consequences associated with the proposed ticket price cap, and number two, appropriate enforcement of violations. DEMPED and DLCP remain partners with the council to ensure that we can best protect consumers and support the vibrant entertainment scene in the district. We believe it is of the utmost importance for concert goers in the district to be able to engage in safe, regulated marketplaces to purchase tickets. Predatory ticket scalping is a problem. It takes advantage of consumers who have to pay more, but leaves artists and venues without the benefit of higher prices. We recognize that we are in a moment where artists, venues, states, and the federal government are taking actions to address the problems associated with egregious ticket scalping. Bills similar in nature to the Resale Act are being considered and have passed in jurisdictions across the country. The federal government has taken actions to address fee transparency, and several major lawsuits have been entered into that could drastically reshape the market for the purchase and sale of tickets. It is within this landscape that we review this bill. The district's performing arts venues and theaters, in addition to being cultural staples, are also a key part of the district's economy. Accordingly, we want to make sure that the district passes a law that effectively empowers customers and venues with a fair and transparent marketplace and enforceable and administrable laws. I would like to first discuss price caps on the resale of tickets. We do not believe it is prudent to trade one problem for another. Fraudulent transactions involving ticket resale already exist, and we have concerns that price caps could unintentionally drive more activity to unregulated markets, resulting in higher rates of fraud and greater financial losses for consumers. While we understand the purpose of this provision would be to increase customer welfare and transparency, our concern is that it could do the opposite, by pushing consumers to markets where the risk of fraud is higher and the ability to enforce violations is lower. Before enacting a price cap, we need confidence that this outcome will not occur within the district. This bill addresses several core challenges in the market, including speculative tickets, bots, and fee transparency, which we believe reduces the need for a price cap. Additionally, the pending litigation could potentially reshape the landscape and potentially mitigate concerns that this provision seeks to address. Furthermore, the enforceability of such a provision is questionable from experience in other jurisdictions. We therefore urge the committee to remove the price cap provisions at this time to allow for a more informed evaluation of these developments. To enforcement, as drafted, the legislation would require substantial resources, and we do not believe at this time that it would provide an effective enforcement regime. The legislation envisions a robust program for DLCP to monitor and register ticket resellers, track and enforce violations, and monitor resale sites. While we understand the intent, we think it is unlikely that individuals who would likely violate these laws would go through the necessary steps to register with DLCP or adhere to the reporting requirements. Simply put, the operational and enforcement mechanism that the bill would require is not practical, which could, in turn, undermine consumer confidence. Notice of infraction are not always an effective enforcement tool, and as we have seen in other areas, civil fines and penalties alone are not always enough to change behavior. Therefore, we are recommending two alternative measures that we believe could assist in this goal. One, a private cause of action, and then two, potential misdemeanor penalties for violations. Both of these are measures that are consistent with provisions in other jurisdictions, including New York and Maryland. We recommend that the committee consider adding a private cause of action that is similar to what is being proposed in enhancing the Consumer Protection Procedures Amendment Act, which was discussed earlier. While DLCP works tirelessly to aggressively enforce the CPPA and would do so should this legislation pass, their resources are limited. Thus, allowing for a private cause of action gives harmed consumers an alternative means of recourse. Moving to potential criminal penalties, the resale of tickets at egregiously high prices via market manipulation or the selling of counterfeit tickets is akin to fraud, which is currently enforced as a criminal conduct. We believe including a provision that would address market manipulation and fraudulent ticket transactions as a misdemeanor in certain instances would provide for better enforcement and deterrence. We would like to conclude our testimony by highlighting the aspects of the bill that we find to be positive and that we are supportive of. Number 1 includes banning the sale of speculative tickets. Number 2, including laying out clear standards for refunds that must be provided to customers. 3 is language providing enforcement for the prevention of bots. And then finally, requiring upfront pricing. It is vital for consumers to engage in a safe and transparent marketplace, and that the district continues to support our music venues. We respectfully ask that the committee consider our concerns in evaluating this bill, and we welcome any questions and further discussion on the matter. I'll be here to address any questions, and DLCP is able to respond to any administrative questions about the bill. Thank you.
Thank you. Okay, so does DLCP regularly receive complaints about fraudulent ticket sales or any other issues related to concerts and events?
No, Councilmember, we do not. Confer with both Ms. Crosby as well as the manager for the Consumer Protection Unit. That is not a complaint that we regularly see.
What about hidden fees or deceptive pricing?
Not to my knowledge. No.
Okay. Is it an issue?
Oh, I would say, thank you.
Go ahead.
No, not a regular, but we did receive one last fiscal year as it relates to U-Haul. They did investigate that matter and come to find out the prices were.
U Street Music Hall?
No.
U-Haul, the truck
Yes.
company. Okay.
And it actually did come to find out that the prices were adequately listed and conveyed to the consumer. So enforcement was not needed to be taken there. So in both of those instances, those are not frequent or regular complaints that we receive.
Okay. Does DLCP provide any information for consumers about best practices to avoid ticket scams?
We regularly issue advisory notices and consumer alerts. This has not been one that we've done, but we would not be opposed to doing it. It's just that because these aren't regular complaints that we have received, we had not, but it's something that we could do if necessary.
I understand your concerns about a price cap increasing fraud because transactions will be pushed off of regulated resale platforms. Where do you believe transactions would happen instead?
I think there have been a couple avenues that have been discussed at the hearing today. One of the other transaction sites such as Craigslist or Facebook Marketplace have been mentioned. I think we could also see an increase in the amount of ticket scalping outside of venues where individuals would, conduct a resale there and trying to do like a private person-to-person transaction. And I think those are areas where we could see an increase in levels of transaction.
And, okay. So many of the more regulated platforms charge fees for both sellers and buyers. Isn't there already an incentive to not use these platforms and instead go to one of the less regulated sites?
Yes, I believe there is. However, I think in the calculus that someone would make of I can have a reasonable confidence to purchase a ticket from a StubHub or SeatGeek or one of the other regulated marketplaces. There's a cost associated with that fee, but I don't know that it is enough at this point to incentivize most folks to go and buy something out from an unregulated market. There's a certain level of risk that would be associated with that. Where I think we have the concern is that this bill would push, somebody would purchase a ticket and want to resell it at a higher rate, would not be able to on one of those regulated platforms, and their only means to do so would be to go to these other marketplaces, and folks wouldn't have other options and would go to these kind of unregulated marketplaces.
Well, could education around this issue, such as telling consumers to only buy from trusted platforms, address the concern?
I think that could be a helpful matter, but I think in reality, if there's an in-demand concert like Taylor Swift's been mentioned a lot today, folks really want those tickets, and we've seen reports for the Eras Tour in some of these jurisdictions that have these types of caps. We see other activity outside of market, outside of these regulated places. So I think seeing an instance where one of those concerts where somebody really wants one of those tickets, they might go to those other spots. And education could be helpful in preventing that, but I don't think that it's a solution to the issue.
To clarify another point in your testimony, you're saying that DLCP would not be able to handle volume of consumer protections violations, so consumers should take it upon themselves to sue companies with their own time and resources instead of just properly staffing DLCP?
I think there are two parts of it. We've looked at laws from other jurisdictions where there is a private cause of action, and it just provides another means of enforcement to this. Obviously, the DLCP being able to enforce under its own regime would require additional resources, but this is another aspect that we've seen that would not require additional resources.
Got it.
And I echo Mr. Nicholas, that's exactly right. It's really about providing, if we want to address this problem and rectify it, providing additional form enforcement mechanisms will be most useful. There's only, and we've heard about it a lot today, there's only so much that administrative agencies can do, including DLCP. We handle everything as vigorously as we can, but this would then add an additional responsibility, and also just the investigatory nature and what would be necessary for this maybe will add to additional needs for our enforcement team. So the alternative cause of action, the misdemeanor, in alignment with other jurisdictions that have similar laws, is just to provide additional enforcement mechanisms to address the problem that the council is trying to pursue.
Okay. Does OAG regularly receive complaints about fraudulent ticket sales or any other issues related to concerts and events?
We do. We definitely regularly receive complaints through our consumer mediation program about concerts and events. With regard to fraudulent tickets, I don't know if I would say it's regular, but we have received multiple of those. And it's hard to tell often whether those are from a speculative ticket sale or some other kind of fraud. Usually the complaint we get is, I showed up to the venue and my ticket didn't work, or I bought a ticket and it was never transferred.
Okay. What about hidden fees?
We receive complaints about that in the ticketing industry and several other industries.
Okay. Does OAG currently enforce deceptive pricing under CPPA or other laws?
We do. We have brought multiple lawsuits regarding deceptive pricing, or the lack of all-in pricing, or drip pricing is how some folks refer to it. And we bring under our general CPPA authority for misleading trade practices. And we believe that this conduct is already unlawful under the CPPA, and courts have held that. But that hasn't stopped it from proliferating both in the ticketing industry and other industries. And that is why we are supportive of making it crystal clear in the ticketing industry through this bill that all-in pricing is required.
Does OAG provide any information for consumers about best practices to avoid ticket scams?
I don't think that we have done a consumer alert specifically on ticket scams.
Could you share a bit about the cases that AG has filed against both Ticketmaster and StubHub?
I can't share a lot because they're both still pending.
Okay.
But the StubHub litigation is about deceptive pricing and not having all-in pricing and deceiving consumers. And then the Live Nation Ticketmaster lawsuit is an antitrust lawsuit. Been talked about a lot today. Both of those are still pending, so I can't say much more about them.
How did you become aware of these issues? You, AG, become aware of the issues?
Through multiple means, including receiving consumer complaints prior to filing those lawsuits.
And how would this bill expand OAG's ability to go after platforms that deceive consumers?
I think that it just makes it crystal clear that these practices, which we believe are already unlawful, are in fact unlawful. Just to put that into concrete example, when we bring these cases, every time the defendant is filing a motion to dismiss saying, well, this isn't explicitly spelled out in the CPPA that we can't do this, and we win the argument with the judge that this is covered by the general prohibition on deceptive trade practices, but we spend hours and months having that fight that we very likely would not have to do if this was made clear through this act.
Great. Thank you. Thank you all.
Thank you.
Thank you.
This concludes today's public hearing. If you have not yet submitted written testimony for the record, please do so by 5:30 p.m. on November 10th, 2025. The time is now 6:56 p.m. and this hearing is adjourned.